Welcome everyone today. We are going to start momentarily as we wait for the other colleagues, participants to join us along the way. It's understandable, Uganda's weather, we have our 2 seasons, and those are some of the challenges that we face in our mobility. My name is Mpeo Alan Collins. I am a project manager and I also work as a staff advocate at Greenwatch. Ladies and gentlemen, nice to have you here today for our workshop on science and the law, and with our title, Strengthening Scientific Support in Strategic Climate Litigation. I'll be a moderator for the day. According to our program, we're supposed to, from 8 to 8:30, we're supposed to be arrive on registration, 8:30 to 8:50 a.m. official opening. But as you can see, at least we've bought into the time we are supposed to be handling, especially our expectations and ground rules. But I believe we shall redeem that time in due course during our tea break. We were suggesting, if it's possible, we can have a working tea break so that we redeem the other time that has so far been spent. So without much ado, I would like to welcome my brother Ramon to give us the opening prayer, and then we go into the welcome remarks. Thank you.
Thank you, Alan. Good morning to you all. Let's humble ourselves for prayer. Father, Lord, in the name of Jesus, we thank you for today. We thank you for this workshop. We thank you for everyone that is here. We thank you for those that are coming and they are on their way. Bless them. Thank you for what we are going to learn, for the value added addition. And thank you for the presenters. Thank you for the people that are here and are going to take part of this. Bless everyone that is here. Give us wisdom, knowledge, understanding, and help us understand whatever we get from here. Help us to put it into application and continue to bless us in our daily lives and bless this day. In Jesus' mighty name we pray and believe. Amen.
Yes, thank you, Ramon. We have live stream, so for the participants and the colleagues within this hall today, if you have your networks in which you are, especially on the socials, the IT personnel, you'll guide in later in the course of this first session on how the other participants out there that we are pushing probably to also attend from the online side can join us in this. So we are going into the welcome remarks. The ladies and gentlemen that have been invited here, that are with us today, those catching us online, and those that we await to join us in due course, we welcome you once again to this Science and the Law workshop. We titled it, once again, Strengthening Scientific Support in Strategic Climate Litigation. And it has been wholly organized by Greenwatch. Our ED will be speaking much in line with the work that Greenwatch does, but we have had conversations and have made observations in the line of the work that we do as Greenwatch. And along that line, we noticed that there had been gaps, especially in our litigation, specifically environmental and climate litigation that we do, that sometimes in the line of us advocating, in the line of us litigating, we are sometimes constrained or fall short on the evidence it is that court desires of us in trying to push for the right to a clean and healthy environment as embedded in Article 39 of our Constitution, the Republic of Uganda, 1995 as amended. So your presence here today gives us immense joy and a driver to a foundation to probably future engagements that for some we shall even be agreeing on today in the conversations we shall be having. So please feel at home. Please feel free to engage. Feel free to ask questions. And at the end of the day, I believe we shall achieve that which has brought us today. And for that, we welcome you. Once again, you are selected carefully. And as we shall hear from the introduction of every one of us today, I know we have those tags on our jackets, our shirts, with our names that we want to be referred to within the course of today. So you'll notice that it's a blend. While we are saying scientists, but it's a blend of various fields of science that intersect with environmental and climate litigation or advocacy that Greenwatch does. So once again, we welcome you and we look forward to having fruitful deliberations with you today. Again, we are moving to the next agenda item, which is us having our expectations for the day and ground rules put forth. I'll request my brother Ramon, if you can help with taking note of those. We want to just hear from you, the participants in the room today, what your expectations are. I know we shared the concept and the invitation with you earlier on email. We made some follow-up phone calls with you, had conversations for some where some questions were raised to us prior to this. So just for now, before we kickstart, we would like to just get to know what your expectations are for the day. So Ramon, please have the markers and yes. I don't know, do we have a microphone that can, yes. We can do that in probably the next 5 to 10 minutes. what your expectations are for today. Mr. James Opito. Hey, we would want to know what your expectations are. Dr. Zake. Hey. Maybe when you're speaking, maybe introduce who you are, your name, where you're coming from. Yeah.
Okay.
Yes.
Thank you so much. My name is James Opito. I coordinate the Civil Society Coalition on Oil and Gas. We are hosted at Advocates Coalition for Development and Environment. So while I work for Cisco, I'm a staff of Accord. And I'm glad to be here. And for me, the first element of justice I've seen is that being the first person of the invited colleagues to enter the room, with the exception of Greenwatch, I was given the first platform to say something. That is justice. And I pretty much think it would add into the hard question on litigation. Yeah, so for me, my expectation is, first of all, to understand how Greenwatch has been approaching litigation and connecting it with climate change or environmental issues. And from there, I also expect that we will be reading the lines from the challenges that you and other partners face in your daily work. Because when you have an ambition, when you do something and you feel like you've not hit the target, there should be something which is creating that bottleneck. And for me, I hope that I will listen to those challenges, and then we get to bridge the gap based on our experiences in the work we do. Being the first person to say something, I may risk moving through the lines where other people would want to say something. So I want to do justice and to say I'll also hope to hear from others what their expectations are. Thank you.
Yes, thank you, Mr. Opito. Thank you.
Thank you. Colleagues, I greet you in your respective capacities. I'm Joshua Zake. I'm an independent scientist and consultant on issues of agriculture, environment, natural resource management, and the climate action. I'm very grateful to be part of this conversation, and my expectation is mainly further reflections in terms of sharing experiences. What are the lessons and best practices if you were to follow the path of litigation? Usually it's a difficult path to take. I don't want to scare you, but I've had an experience of it. But now it's also good to learn from others. How have they approached it? Does it work? Does it deliver results? When do you get the results? Yeah, thank you.
Thank you, Doctor.
Good morning.
Good morning.
My name is Patrick Musinguzi. I happen to come from Makerere University, from the College of Agricultural and Environmental Sciences. I'm happy to be here. I think for now, my main expectation is to probably get to know how Greenwatch has been handling issues of science in relation to litigation, looking at the past, what has been happening in the past and the present, and where do you want to go in the future. Basically, I hope to come up or hear from the different participants or learn from the different participants how science-driven approaches can enforce litigation at the end of the day. Thank you.
Thank you, Doctor.
Do we have another person to speak first as I settle?
Yeah, good morning. colleagues.
Good morning.
My name is Isaiah Uyunzi, and I work in Kavala University. I'm very grateful that I've been invited for the workshop. One of the course units actually we teach for master students and some of the university students is environmental law. And sometimes I have to compliment on it. And I'm glad that I've been invited for this because most of us scientists are not well versed in the judiciary things. And when you tell students that it's actually possible to defend your rights through litigation, taking people to court, they don't believe. Because they say, which ones have worked in Uganda? So you need to find, correct cases that have been won, that are being won, and what kind of information do you need, to be able to litigate successfully. So one of my interest is to see what can scientists do to be able to help in litigation. Thank you.
Thank you, Doctor.
Thank you so much. Good morning. My name is David Kabanda. I'm the Executive Director at the Center for Food and Adequate Living Rights. I'm very honored to be here this morning. I have many expectations, quite many. When I saw that the workshop is on scientific support, I looked ahead to join. One, I need to understand the definition or the framework or the delimits of scientific when we use it in terms of strategic litigation, because I have known that in courts of law, court and the judges are the experts of experts. I think you know that. Now, when we talk about scientific support, are we talking about biological sciences? Are we talking about physical sciences? Are we talking about social sciences? And for me, in this workshop, I would also have loved to hear how we can use traditional knowledge and the people's indigenous science. And if so, whether that science is acceptable in courts of law as expert evidence. Because the moment you talk about scientific support, if you are using it in litigation, then you are entering the waters of expert evidence. But beyond that, I also would love to hear from colleagues here in how Greenwatch and us will be working with courts of law at national level, but also sub-regional level, like East Africa. When you look at their rules, there is a way they obstruct scientific support. For example, I don't know whether it is you've faced it. In some of the instances, they will tell you that consultant will not testify in this court because they either have not worked in this region, so their report or scientific findings are out of this jurisdiction. That happens sometimes. We need to discuss and get to the bottom of this and see whether we can be able to change that shift, to make that shift in the courts of law. And lastly, my expectations in this workshop is how I wish it is not just a workshop, and it is some kind of, and I'm speaking to Edie now, how do we make sure that we continue with this science, the scientific, you can give it a name. I know we can get a name such that it is not an end in itself. I would love to hear those conversations. Thank you so much.
Thank you, Doctor.
Good morning, everyone. Yes, my name is Tsime Pauline. I am a legal officer at the Center for Food and Adequate Living Rights, SEFROT. I am pleased to be here, and my expectations, I am a lawyer, so I am here to see how the science, the nexus between the law and science in environment, and how we can work with the scientists to get evidence to protect our environment. The scientists have the knowledge on how the environment works, and then the lawyers have the knowledge on compliance. So I am here to get majorly evidence on ensuring compliance. Thank you.
Thank you to all the pre-current speakers. My name is Joanne Kembawazi. I'm the program head for the Strategic Litigation Program at SEFROT, and I'm here to learn. I think today's topic is quite interesting because it highlights one of the major challenges we face as litigators. That is because we need the science backs up our evidence, but we are lawyers. So how do we interpret the science well enough for that science to support our cases? But also we know that this is one of the biggest challenges that our judicial officers also face because they are lawyers. So today I'm here to learn, and I want to see how the science can be used to support the litigation and how to make sure that the judges actually get the science well enough to make the right decisions. Thank you.
Thank you. You've reminded me of something. Someone was teaching us the law back in the day, and they said the law is both a science and an art. I do not know if when we are speaking about the nexus, whether the lawyers are also scientists here today. But we shall find out in the due course. My brother, I don't know now if the time is ripe for the expectations.
Thank you very much. My name is Desmond Anyua. I come from Kitigo. I was humbled to get the invite to be part of this engagement. And I'm glad to see some of my senior colleagues that I've worked with. I've worked with Dr. Zake. He has been one of the people who used to inspire me in this space. But of course, working over time together, we became a colleague, and we've been doing a lot of consultancies together in this space. You know, like working also to become a PhD student, I'm happy to see my colleague, and I don't know if somebody near that I needed to come and sit near my senior colleague here. The Dean faculty, School of Geography is my supervisor, and we are working together. I'm studying climate finance. Indeed, how we can fund locally led adaptation. How climate change is affecting our local communities. So I practice more of climate change adaptation strategies, and now we need to find ways of how we can fund some of those interventions. So we are seeing how international funding flows down to local community. In line with this engagement, of course, I don't know what formed part of your invitation, but I was happy to receive the invite. I've been getting experiences in some of the cases when I was working with Refugee Law Project, School of Law, Makerere. We had cases of logging in northern Uganda going to court. And sometimes the lawyers just pick one part of the law and interpret, and the case is ruled. And we could questions from the environmental angle. Did they consult this other one? Did they consult this? Did they consult this? So for me, I think this is an opportunity to interact with you people, the lawyers. What has been disturbing me, which I think I will learn from here, is you find law, the legal people study law, and the environment people study environment. And the nature is there. To me, it has been disturbing. And I thought maybe today, maybe even have a case you're working on, that now you want to consult the environmental people. But I've interfaced with so many documents you've developed, especially on the environment social screening, and the EIA documents that the Greenwatch developed, and quite a good documents. So I'm sure also you've been working with some other environment people in your spaces, but maybe my being here is to strengthen the system more and see how we can come up with a good point of serving our people. Of course, we talk about environmental justices, but also we're looking at the aspect of environment, how we can protect our ecosystem. So you might have not written anything, but I'm in the mix of so many things, that learning from you, but also sharing experiences with you, so that at the end of the day, we become one team that can protect our ecosystem. Thank you so much.
Thank you. We've been joined by some colleagues. I do not know if we give them just an opportunity to introduce themselves and where they're from. Yeah, then we can move to the next agenda item. Thank you.
Good morning, colleagues. Apologies for coming in a bit late. Floods blocked off one of the roads, and almost 1,000 cars were in one spot. So we could not actually, we had to maneuver, I had to maneuver to come through here. But I'm Henry Basira, and I work with the Water Governance Institute as the executive director. And I have worked with Greenwatch for quite a very long time. I think I was among the people that helped set up Greenwatch, give it foundation, because I supported them technically. And one of the proposals that was written to actually the idea of training people in the judiciary on environmental science is a proposal that I prepared for them. And then the late Kakuru. And so that's when the idea of sharing science, and especially environmental science, to lawyers and judges arose. And we had the first cohort of judges, and in the Supreme Court, all of them, we took them through a round of training. And I think I began to see the impact of that when we started dealing with the case of heritage and heritage oil and gas. And also, there are quite a number of cases, wetlands, forests, that we brought about that have gone through the judiciary. And so science is critical for the judges. And I'm glad to see many times judges, not only here in Uganda, but even outside Uganda, really grasping the concepts of science and using the science in their cases, adjudicating to the cases they handle. I did not know the protocol or the approach of how to introduce myself, but that's, I thought, would be a quick summary, and the rest, I think we shall share more insights on how we should take this forward. For me, I think it's a great initiative, and I'm glad we are building a cohort of students and new graduates who are actually getting into this sector. Climate finance, you talked about, is going to be very critical, and climate finance is going to raise a lot of legal issues, which we should, in the judiciary, be prepared to handle. Thank you. I submit.
Thank you.
Thank you. Good morning, everyone. Apologies for coming in an hour after my expected time. My name is Mbogga Michael. I work as a lecturer with Makerere University School of Forestry, Environmental and Geographical Sciences. About the discussions today, I have been working on climate change since January 2006. I landed on climate change by accident because when I went to Dubai University, nobody was funding it, but people were willing to fund climate change. So I worked on climate change, a whole cocktail of it, including weather station data, analyzing all of that. But prior to that, I had gotten some small training at the African Center for Technology Studies, mainly working on policy and bringing science into policy or policy into science. And so that has followed me at Makerere. I teach a course on natural resources policies and laws. We used to call it land use policy and law. So I and a colleague who I think is expected to be here in a few minutes, we've been teaching that course for the last, him 20 years, me 15 years. And but I've also worked a lot with the Uganda's climate change portfolio, helping the country do a lot of things in climate change, either reviewing projects or writing those projects. Or the recent challenging task I had was to help develop the, they used to call it the Article 6 framework for the Paris Agreement, which basically people call it the carbon markets regulation and stuff, following the Act of 2021. So we spent a full year trying to grasp that and get it out. I am happy to note that I think early last year that was assented to, but it's still a challenge given what we did and what is actually happening on the ground, getting to ensure that people, we look at the finance coming in through the markets or even the non-market mechanism. So I am happy to be here to share from the experts. I think for most of us, learning does not stop. It actually starts when you know you actually don't know anything. Yes, thank you.
Thank you. We shall just have our colleague, just a brief introduction, and then we move to the next agenda item, and then, yeah.
Good morning. I am Moses Talibita. I represent civil society organizations on the Tobacco Control Committee, which was created by the Tobacco Control Act. I am happy to see council and doctor at the same time. We are beneficiaries of science, and we keep learning. I also teach at Nkumba University in the School of Sciences, and I realized that he's already preempting what I was going to say. So I associate myself with all that he has said. And doctor as well from the Water Institute, we benefit from your resourcefulness. Thank you very much.
Right, thank you. So we are going to we are going to first of all just get a cup of tea, then have a working tea within here as we proceed with the other sessions, because we're trying to also redeem time. We are starting a little bit late. Yeah, so Judith, if you could just confirm, and then as she does that, I would like to introduce Samantha Atkunda Kakuru Mwesigwa, our ED, to just give us a brief highlight of what Greenwatch is and stands for. And I hope we meet these expectations at the end of that day. They told me we're in a new curriculum, so we shall have to be inclusive and tick those and see if we manage to meet all those expectations at the end of this during our reflection moment at the end of today's workshop. So, Samantha, please. After Samantha, we'll have our break tea, then we come back to kickstart the conversations. Thank you.
Thank you so much, Alan. Let's give him a round of applause. He's done just such a great job. All right. My name is Samantha. As Alan has mentioned, at Kunda Kakuru Mwesigwa, I'm a lawyer by practice. Should I also say by training? Yes, by training. Training by fire. Yeah. I'm a lawyer. I'm a managing partner with Kakuru and Company Advocates. That's the law firm that I practice with. I am also the executive director at Greenwatch. Greenwatch has been in existence since 1995, which coincides with the 1995 Constitution of the Republic of Uganda. Because of the timings, our next presenter is coming on at 10:30, and I know that she's going to be on time because it's an online presentation. So I just have a few minutes to go through my presentation. In the event that I don't do it justice, I think I can always come back and kind of rush through it. So the media team, I don't know if you can project my presentation. It should have been shared. Okay, great. So throughout the expectations as we were conversating, and you were talking about what we are expecting what we're expecting by the end of this day, I realized that science and the law, when we thought about it at the beginning, it was just like, will people actually be interested in this? Would they actually come? And I just want to give a brief genesis on how we got here. My presentation is entitled, Why Your Science is the New Legal Sword. And the theme for this workshop is strengthening scientific support in strategic climate litigation. I'll just go to the next slide, which allows me to talk more about Greenwatch. Who are we? Greenwatch was founded on the basis of Article 39 of the Constitution of the Republic of Uganda. At the time, the late Justice Kenneth Kakuru was a practicing lawyer and an environmental activist. And when this constitution came out and he realized that this article was there, he had the vision to ensure that this section or article, does not remain in the books of our constitution, that it should be given life. So that was really the birth of Greenwatch. Greenwatch was established to use that particular article as a tool, to use the law as a tool to enforce Article 39 of the Constitution. And Article 39 of the Constitution, as we all know, provides for the right to a clean and healthy environment. So we are a company that's limited by guarantee. We have our guarantors. We are also registered as a non-government organization. We currently have the license to practice as, to operate as an NGO. So our main objective is public participation. Why public participation? I remember when, so I started off with Greenwatch at a very young age. I think it was about P7 back there, going into S1. So I used to come for many of the trainings and would be the photocopying person at the back. So I would listen in as, presentations were made, and I got to learn about Principle 10 of the Rio Declaration that has access to justice, public participation, and access to information as the principles for good environmental governance. So Greenwatch really emphasizes public participation. But that public participation is to is for the purpose of sustainable use, management, and protection of the environment and natural resources. So what is our vision? And we've, how can I say, we've evolved through the years, because this is not the same vision we had in 1995. But as a team, as we gathered together and participated in our strategic plan, there are some things that we tweaked from the work that we've done in the past, but also what we are projecting into the future. So our vision is a sustainable environment for the present and future generations. Our mission is to protect the right to a clean and healthy environment through public participation that I had talked about. And our goal is to achieve environment and climate justice by 2030. So how do we do this? As I said, we were founded on Article 39, using law as a tool. So immediately we hit the ground running through litigation, because that is the law is what we know. So we were litigating. We were finding out where there are environmental violations. Who are the people responsible? Have they acted? Why didn't they act? Can they be held accountable? And that's how we started litigating. Now, when we got into litigation, and litigation really is just bringing cases before courts. When we brought environmental cases before the courts of law, we found that there was a gap in the judiciary. Environmental law was a new concept at the time, and here I'm talking about mid-90s, going into the early 2000s. It was a new concept. And you would find that judges would adjudicate these matters under tort law, but yet it actually had a separate category on its own. And the law is very interesting, because when you want to bring the law to life, we call it to test the law. You bring cases before the courts, you see how the courts will interpret it, whether they will set precedences and things like that. So we then found that there was that gap, and that's how we started then the training. And why I'm giving this background is because I want to explain how we got to advocate, empower, and litigate, because those are the ways in which we fulfill our what? Our mission. We advocate. We didn't start off as advocates, advocating for different rights. No. We started off with the last one, litigate. But as we were litigating, we realized we need to empower. We need to empower the legal ecosystem, the judges, the lawyers, the prosecutors, the DPP, police, and we've done all those trainings. And then we realized, oh, but we are representing, in most cases, it's in the public's interest. It could be individuals, it could be communities mostly. But how can we also support them to empower themselves? So it's not always Greenwatch going to court, but we can have the communities themselves going to court. But how can we be able to get them to get organized, to bring them to that point that they can actually litigate for and on their behalf? So when we zeroed down, we recently, like I told you, did our whole strategic plan. We zeroed down on these 3 pillars. Advocate, so Greenwatch advocates. We litigate, we empower, and empowerment can be whether it's communities, whether it's the judiciary, whether it's lawyers themselves, whether it's scientists like how we are here today. And we also litigate. Litigation for us is a constant. There's never going to be a time where Greenwatch does not have cases in court. We litigate, because that has been our background. So I know that we've given our expectations for the workshop, the different presenters that are going to come, and the different conversations that we're going to have. But for my particular presentation, and I had it in the expectations, by the end of this, I'm hoping that we'll understand what climate litigation is and why it's exploding globally, how scientific evidence is being used as a legal tool, which is one of the things that I had we would want to know more about, the specific role of scientists in different types of climate cases, and the practical opportunities for scientists in the courtroom. That one was just mine. I felt that there are many opportunities, and therefore we should know about these. All right. The sword has changed. Why science now? Science is now the weapon in court. How did we come up to this? So Greenwatch started mainly climate litigation in 2012. We had our first case, Nisi Mbabazi and others, versus the Attorney General and NEMA. That case is still ongoing. It's really, well, I don't want to go into the nitty-gritties of the facts of the case, but let me stick to the presentation and explain that statement. So I'm going to specifically be talking about climate litigation. Back then, when we started litigating on climate change, 2012, 2010, climate arguments were political, they were moral. You know, we're experiencing climate change. What is the government doing about it? How are you going to change things? How are we going to be able to? So it was mainly on that front, okay? But today it has evolved to science is no longer in the background. It's now at the front. Questions are being asked. What does the data say? If you have an impact, was it really as a result of emissions? How can you be able to create that link? So now we are no longer looking at it, trying to convince the courts that, oh, by the way, climate change is real. Or by the way, we need to have a policy about it. Because our national climate change policy was established in 2015. Before then, we were already litigating about climate change. So you would find that there was a different narrative, convincing that this is something that we must pay attention to. But now we have a policy, we have an act in itself. And now we are seeing that it's no longer a political or a moral issue. Now we are asking, what does the data say? And that's why science is now a weapon in court. So what is climate litigation? Climate litigation are lawsuits that are brought before courts centered around climate issues. Now, these climate issues could be involving laws, they could be involving policy, and scientific evidence that is related to climate change. So what drives these cases? That's the whole big deal. What drives the cases? I'm being signaled that tea is ready, so we can have a working break tea. Though I feel like my presentation is so captivating, I don't see anyone standing up to go get tea. It's a joke. All right, so what drives this? What drives these cases? First of all, it's government's failure to act, as you see as we go further in the discussion, or not acting fast enough. Another thing that drives these climate cases is corporate responsibility for emissions. As scientists, we know what causes climate change, greenhouse gas emissions, and who's responsible for these emissions, who should be held accountable. So those are driving factors of these climate cases. Also, human rights violations that are linked to climate change impacts. Maybe just as an aside, when Mr. Mbazira was telling us why he was not able to come on time, he said it rained and, you know, there were drainage issues, there were floods somewhere. So is that a violation of his right to get to where he needs to be on time? I don't know. So science as the cause of action. The cause of action is really a reason why we bring cases to court. What is that cause? What is that cause? So now I'm giving a comparative analysis between the traditional approach and now the current approach. Traditionally, we had to explain, is climate change real? Is it really? We've been having trainings with different lawyers, judges, and in one of those trainings, one of the participants actually put us to book about that. He said, but you people, you keep talking about climate change. This is a hoax. It's a hoax. It's actually not real. It's just something that has been concocted by the global north to try and spin things around. And I know there are some people who belong, some prominent people in this globe who belong to that school of thought. So is it real? That was before. But now I think the science is clear, and we can all agree that it's even with the policies and the laws that have been put in place, I think now it's judicial notice that climate change is actually real. It's a current trend that we have to deal with in the globe today. General expert testimonies was so from the current approach now is attribution science, which my colleague is going to be talking about very shortly, proving that events are actually caused by, whether it's by the increase of greenhouse gases in the atmosphere. So very specific, the aspect of attribution. General expert testimonies is what we used to use before. I think even in our first Greenwatch case on climate change, we used very general information, because at that time, what we do is we test the law. We didn't know specifics and all that. We're just putting it there and saying, what is court going to say about this? But now, they are so specific traceability reports that we can actually pinpoint and say this particular impact was actually caused by this, and courts in other jurisdictions have actually agreed with the science and pointed in that direction. Also, the traditional approach focused more on future predictions. We predict that if this pattern continues, if we, go off the 1.5 degrees Celsius tipping point, this is what's going to happen. But at present, you can actually measure the harm, which is quite important in litigation. So we have several types of climate litigation cases. We have cases that are government-focused cases. Now, these ones challenge the inadequate climate policies. They could be enforcing constitutional rights to a clean and healthy environment. Most of Greenwatch's cases fall under that category, most of their climate litigation cases. We have the famous case of Agenda versus the Netherlands, where the court ordered that 25% emissions cut. We can go more into detail of any of these cases at another time, or if we have time. We also have corporate liability cases. Now, these really look at suing fossil fuel companies for deceptive policies, or holding those corporations accountable for the supply chain of emissions. We also have human rights-based cases. Now, these ones, the climate harm is a violation of the right to life, the right to property, like I was mentioning, and they have been used in the European Court of Human Rights, the African Court of Human and People's Rights, and other regional courts. Last but not least, which is a concept that we are looking into, I can see you, greenwashing, loss and damage as well. That's also challenging that whole net zero aspect. As you know, as we are net zero, we are low carbon emissions and things like that. But when you actually do the proper research, you actually find that that is a false narration or statement. My colleague is prompting us to go for tea, but I'll just be fast. Maybe Judith, you can check online if Joy is ready. Section 26 of the National Climate Change Act of Uganda specifically provides for climate litigation. So we actually have an avenue of how we can be able to bring these cases before the courts of law. And I'm sure the drafters of this constitution anticipated this and gave us this. It's actually access to justice. When you look at the Principle 10 of the Rio Declaration, access to information, public participation, access to justice. And the subsections 1 and 2 state that any person, so we are all at liberty, any person may apply to the High Court for relief against government, individuals, a private entity whose action or emissions threatens efforts towards adaptation or mitigation of climate change. The court may, and the court here in this particular section, prevent or stop, can actually come in to provide a remedy, to prevent or stop the act, compel remedial action, or provide compensation for loss and damage. And we've been looking at loss and damage suffered. But you see, with courts of law, this loss and damage has to, the causation, there has to be a link for the courts to actually use that remedy of loss and damage. And it's something that we've been looking into in terms of what does what does it actually take if we have landslides in Bududa and people lose their lives and they lose their livelihoods? Can you actually link that to climate change, and therefore does this particular law apply to them? In subsection 3, it says a person may bring an application notwithstanding that they cannot prove the act or omission caused and is likely to cause personal harm or injury. And that's quite open-ended. So before I move into why climate cases need scientists, I would like to pause here and allow for our next presenter to make her presentation. Then I can come back and complete mine. Are we all in agreement with that? Are we? Okay. So she's going to be, as you've seen on the program, and she'll definitely introduce herself. She'll be looking at all right, so our next presenter is ready. I'm requesting if we could just get a cup of coffee and then come back in and as we set up for the next presenter. Thank you very much for your attention. A cup of coffee, 5 minutes.
we agreed shall be a working one. We are going for another presentation, which I know will answer most of our expectations there, especially the major question where we were talking about the attribution, causal links, and then issues to do with the nexus. We are going to have a presentation from Miss Jamila Reyes. She's from the London School of Economics. She will be, I know, extensively introducing herself for us to appreciate her more. And then we are also suggesting we shall be buying into shortly the lunchtime so that we can have the presentation from Samantha. Then we go for lunch, and then we can come back for the panel discussion. It's just about redeeming time, really. But on your tables, there are these small cards before Joy comes in. At the back, there is a QR code. The things of photography, consent really matters. We have been speaking about litigation here. So if you can just scan there, you will access the program, but below the page that you'll be viewing on your screen is where there is something to do with consent, photo consent, so that we know for sure how we are going to run on this. There's also a feedback form down there, but I know even if you click it right now, it cannot open because it will be activated towards the end of our session so that we can also get your feedback. So Joy, you're welcome. And I'll leave it at that so that you go on with your presentation, and then we shall have a Q&A after our presentation. I know, and it's what I'm also looking up forward to mostly, the Q&A with whatever she will have presented before us, and then Samantha will come in. So you're welcome, Joy.
Thank you so much. I hope you can hear me, and I hope you can hear see my slides. Just let me know if there is any issue with regard to either. But thank you, Greenwatch. Thank you, Samantha, for having me. I'm Jamila Joy Reyes.
Joy.
I am policy. Yes?
First, for confirmation, yes, we can see you on the screen, so you can proceed.
Thank you so much. So yes, I'm Jamila Joy Reyes. You can call me Joy. I'm Policy Officer of Climate Attribution at the London School of Economics Grantham Research Institute. I am a lawyer by training in the Philippines, but also I am a science communicator. And I had a wonderful time listening to the expectations of participants earlier. And I hope that I could help at least bridge some of those questions, some of those concerns. And again, as earlier stated, if you do have any questions, just feel free to bring them up during the Q&A later. I will be talking about quite a few things in the time given to me. And so as and when necessary, you might have to speed up. But I'll always be happy to answer any questions that may come up in case I don't delve into much detail about the things. I particularly am grateful to Samantha for laying down the foundations of the conversation, because her presentation earlier, I thought, was very good in kind of presenting what is to be discussed, how science and law can intersect. So this presentation is called Climate Science in the Courtroom, Improving the Evidentiary Basis for Climate Accountability. This was already mentioned by Samantha earlier, but just to reiterate, we work on climate litigation, and the definition that we use to kind of operationalize this are cases that are brought before judicial and quasi-judicial bodies that involve material issues of climate change science, policy, or law. And this came out, climate litigation, strategic climate litigation more specifically, came out kind of as a perceived response to perceived political failure, right? The UNFCCC has been taking so long in the 30 years that it's been in existence. Even though we have the Paris Agreement, it's not going in the speed that we wish that things could go. And so climate litigation is used as a complement to hold governments and corporations responsible. Further, and this is something that I will go back to quite often in this presentation, is that climate litigation is used to change the narrative about responsibility, about accountability, and about who should bear the burdens of a climate crisis. There's also more cases now that are pushing financial markets away from fossil fuels. We call them turning off the taps cases. And prominent among these is the case of Milieudefensie, Friends of the Earth, Netherlands, as against ING Bank. And all of these, as I said earlier, is a complement, right? And the final point of this is to finally put pressure for political solutions, because at the end of the day, it is political solutions that are most needed, regulations that are most needed. So climate litigation is not a panacea, not a silver bullet, but we believe that it's something that could help push the needle forward for climate justice. And if people are interested, we do release a report yearly. It's called the Global Trends in Climate Change Litigation. And this photo is from the 2025 release. We are releasing the 2026 version in a little over a month, which is very exciting. So just high-level stuff about the 2025 snapshot. Number one is there are almost 3,000 cases filed in almost 60 jurisdictions. And we're seeing an increase in cases from the Global South. Interestingly, many of the cases filed in the Global South is not so much climate as center point of the conversations, but usually human rights violations, land displacement, dispossession, etc. Still, climate comes in and therefore is part of the snapshot of global trends. So very exciting where this will go in the next few years, particularly in the context of the advisory opinion of both the International Court of Justice and the Inter-American Court of Human Rights. We're also looking forward to what the African Court of Peoples and Human Rights will say with regard to the matter, particularly on obligations of states to climate change. One thing I didn't mention earlier is that I'm also a project lead on a project called Corporate Climate Reparations. So reparations as well as climate litigation, I think, are part of the same kind of system. And so one cannot talk of one without speaking of the other. So that's just a brief overview of strategic climate litigation. And specifically, I'm going to talk now about the project that we do. So our project looks at evidence in climate litigation. We see that climate litigation relies on scientific input to build strong cases. However, there is an evidentiary gap. And this evidentiary gap is that climate litigation does not always incorporate the latest science. So how do we look into that? So what we want to see is how to improve the evidentiary basis for climate accountability. And in order to do this, we ask three questions. First, how are plaintiffs or claimants using science to make legal arguments? Second, how are defendants challenging these scientific claims, if they do? And third, and perhaps more importantly for the practitioners in the room, how do courts evaluate scientific evidence, right? Because sometimes it might be the case that plaintiffs and defendants, so parties to the case, make mention of science, but then courts defer judgment on the scientific matter, and that is something we've also observed. So just a brief discussion of our methodology. We do release and have been in the process of releasing academic articles. Just last month, my line manager, Noah Walker Crawford, released an academic article on corporate defenses to climate litigation. We also released practitioner-oriented outputs, colloquially called the Grantham Guides, which is done in collaboration with the Imperial College London's Grantham Institute. We engage with practitioners. My favorite part is we do case team workshops as well as workshops with NGOs. And part of that is also engaging in webinars such as this. And so that's why I'm very, very delighted to be here. And we've also seen kind of emerging trends of future research. One of these is health impacts of climate change, not just physical, but also mental health impacts. Conversations of eco-anxiety, for instance, we've seen are coming up more in court cases. We're also looking into methane emissions, particularly in agriculture-heavy areas such as New Zealand and Ireland. As I mentioned earlier, there are now cases on fossil fuel finance and bank litigation, essentially asking banks and other financial institutions to stop funding fossil fuel companies. Finally, we're also looking into insurance claims, particularly on subrogation. So we are very much in the early stages of this project, but it's really, really hopeful and optimistic to know that there are a lot of things that can be discussed still. And this does not even mention the specific context-specific needs of each geographies, which we know will be even more specific and broad. So this is the typology that we look into. There are 8 typologies that have been identified by the authors of Global Trends. So it comes from everywhere, from government ambition until turning off the taps, as mentioned. But for the purposes of this conversation, we'll only focus into 3. So government ambition or government framework cases, corporate framework cases, and polluter-based cases or corporate liability. This does not prejudice the filing of further cases as against states. And so for the meantime, when we say polluter-based, we mean as against a corporation. I'm not going to delve too much into this. Samantha, as I mentioned, provided a very brilliant overview, but just to say that these are the 3 things we looked into. We conducted case studies of around 25 cases, and I will show you exactly the methodology within which we've done that. So we looked at these cases. So corporate government framework cases rather are cases that challenge the ambition or implementation of climate targets and policies affecting a country's economy and society. It also sees whether a country is in line with the Paris Agreement, whether their NDCs are ambitious enough, and other such arguments. Corporate framework cases are similar to government framework cases, but focusing on companies. So these cases seek to disincentivize companies from continuing with high emitting activities by requiring changes in group level policies, corporate governance, as well as decision making. Finally, polluter-based cases, again, I mentioned these are specifically for corporate liability. So these seek monetary damages from defendants based on their alleged contribution to climate change harm through the emission of their greenhouse gases. Many of these cases might have some overlaps with other typologies, and so if that happened, we identified and categorized them in the typology that was most relevant to the case structure. And so the categorization or the criteria chosen, the criteria used to choose these cases were 3-fold. One is their engagement with science. Whether or not courts engage with it is a different matter, but whether or not plaintiffs, defendants engage with science and how they do that. Second, we aim to make this as geographically diverse as possible, fully knowing as well the caveat that geographical diversity does not necessarily mean representativeness. And so in that regard, we do have many of these are European cases. However, we also have the Asia Pacific cases, such as the case of Sharma versus Minister for the Environment in Australia, Smith v. Fonterra in Aotearoa, New Zealand, as well as Asmania versus Holcim, filed by plaintiffs in Peri Island in Indonesia as against cement giant Holcim. We also sought to make this geographic diverse temporally. So we have the youth cases, including Neubauer versus Germany and Juliana versus the United States, as well as the older end of the spectrum cases, such as Klima Signorinen versus Switzerland. Finally, we looked at this in its capacity to particularly create precedent in their respective jurisdictions. The next slide is quite overwhelming. Please don't be too surprised. But this is just to see how I kind of mapped out the coding. So what I did was I manually coded all of these. I keep forgetting the terms, but the horizontal, I think that's called the column. The columns are the temporal aspects. We start with the first ever pleading or letter or initiative by the plaintiffs until the final decision or any other pleading that is most recent. The row, hopefully I say that correctly, is the vertical one, and that's divided into three. First is the main decision or main argument. Second is all the procedural issues, so standing, venue, jurisdiction, etc. And the third are all the substantive issues. So this does not just include all the causes of action, so negligence, if any, trespass, breach of contract, etc. But also, and perhaps more importantly for our purposes, whether or not science is used and what kinds of scientific evidence were presented. The next slide is also going to be quite overwhelming. Again, please don't be too overwhelmed. But this is just kind of a comparative look into three cases. First is Urgenda v. Netherlands, filed in 2015 against the the Kingdom of the Netherlands. The second is the case of Luciano Luya versus RWE, a case filed by a Peruvian farmer in the Peruvian Andes against RWE, a German utility company. And finally, the last is a corporate framework cases, Greenpeace v. Eni. Both Urgenda and Luciano Luya were filed in 2015. Urgenda was decided much earlier. Luya was only decided in 2025. Greenpeace v. Eni was filed in 2023. I don't expect you to see this in much detail, but just to say that it was quite interesting when you look at kind of the comparative temporal aspects of it. In Urgenda v. Netherlands, because this was 2015, the IPCC was the main source of evidence, of scientific evidence. The issue of attribution science was very, very new, just a decade old at this point. The first study on attribution science having been released in 2004 by Miles Allen et al. On the 2003 heat waves in Europe. So 10 years, for 11 years maybe, since that into Urgenda. And so attribution science was still such a nascent field. And so much of the conversation, or very much broad strokes conversation, anthropogenic climate change, the IPCC, etc. In Luciano Luya versus RWE, it was much the same case. In 2015, it was very much broad strokes. It was mostly IPCC. It was mostly UNEP reports. However, 6 years down the road, in 2021, if I'm not mistaken, in 2021, or perhaps late in 2018, 2019, the first attribution science on this particular glacier over which the case finds itself came out. And since then, the conversations between parties became much more into the depths of the science, into attribution science. The court did not decide on the attribution science part, but it did, in the context of the conversation, get an expert, a court-appointed expert, to explain the attribution study. And so it just goes to show kind of like how quickly attribution science has come up in many of these cases. A final case is Greenpeace v. Eni, filed by Greenpeace Italy against Eni, an oil and gas company in Italy. And quite interestingly, this was filed in 2023. And as early as the first pleading, attribution science was already mentioned. And so we're seeing that there is more mention of attribution science, not always engaged with by courts, but very much part of the pleadings of claimants. So 2 months ago, we released this practitioner-oriented guide that I hope will be helpful to those doing this work. It's called Science in the Courtroom, Evidentiary Needs in Climate Litigation. And I will just briefly discuss high-level points from that guide. It's free to access. If you do need a link to it, I could send that to Samantha later for dissemination. Otherwise, just wanted to say that this is something we've been doing because our goal is to make sure that with emerging developments in attribution science, lawyers are able to keep up as well, but also that they don't get extremely intimidated by the science. Just to say as well that through all of these case studies, this is not meant to be prescriptive. This is just to say that these are emerging trends and themes that we've seen over the course of our case study research. So evidence in different types of litigation, unsurprisingly, different types of cases require different types of evidence. And this is important on two accounts. First, litigation is, as we all know, an expensive endeavor. And we are pressed for time, we are pressed for resources, and we want to make sure that the resources that the things we put our resources into are things that will be relevant to the court, to those making these decisions. Second, and corollary to the first, is that judges and courts are non-specialists in climate science. They have specific answers. Their main goal is resolution of a case. It's important that scientists and lawyers work together so that they create evidence, or evidence that is presented are answering the questions that are brought in front of the courts. Further questions that we sought to answer in this report were: how do the demands of each case differ? Which evidence is easier to gather than others? And which cases are easier to explain to legal audiences from an evidentiary? So this next slide, again, as I mentioned earlier, this is not meant to be prescriptive, just to say that this is what we have seen so far. But first, we look at the convergences. So what has historically made science relevant and compelling to litigation? So the main similarity among all cases is the role of the IPCC, or the Intergovernmental Panel on Climate Change. Even defendants no longer question the authority of the IPCC. Even if plaintiffs and defendants mention science in too much depth and detail, courts, without even needing to be told, will refer to the IPCC. And so we've seen an emerging hierarchy of scientific evidence. At the top of this is the Intergovernmental Panel on Climate Change. And this is perhaps for many reasons. One is because the IPCC is a scientific consensus. It does not release or produce new knowledge. Rather, it just combines scientific studies from different geographies. Second is the fact that it's intergovernmental, which means that prior to its submission, prior to its release, governments have to sign off of it. And so this lends credence to it and gives it the authority that makes it then at the top of this hierarchy. Second, in this emerging hierarchy that we've seen are reports by regional and national scientific advisory bodies, including the World Health Organization, for instance, or the United Nations Environment Program, or similar, or the International Energy Agency, and all of these organizations. Third are more granular ones, peer-reviewed literature and expert reports that were made specifically for the case at bar. So the further down you go, the more dispute there can be between parties as to the facts and the information provided by the document. And finally, and perhaps this is a challenge to lawyers and practitioners and legal teams everywhere, are other reports available in the public domain. Unfortunately, these other reports might be the ones that are most context-laden, that are most close to the plaintiffs. These could be reports done by NGOs such as Oxfam, such as Habitat for Humanity, such as Conservation International, etc. This could also be reports or gray literature produced by indigenous peoples and local communities. So it is up, therefore, to the courts, to the judges, to see that further down it might be more disputed, and therefore they have to present this in a way that is compelling and legible to the courts. And this is where narrative comes in. I said that I will be mentioning narratives quite often in this conversation, and this is perhaps the first of my mention of it, other than the first time, because it matters. For instance, because of the time difference between assessment reports, it might just be that cutting-edge research on a certain topic, which is peer-reviewed, which is methodologically rigorous, appear in between assessment cycles and therefore are not cited by the IPCC. How then do you present that in a court and say that this is actually cutting-edge research? I'm not here to present you with answers, unfortunately. I'm just here to perhaps guide you into asking what questions are most relevant to ask legal teams. Interestingly, there's also a difference in judges, because judges might not be able to discern between high and low quality research. We say that peer-reviewed literature form part of the third rung of this emerging hierarchy, but there is plenty of other issues to keep in mind, first of which is the expense that comes with publication. That's already an injustice in and of itself that is procedural in nature. Second, so many of these parties can just file a lot of money to have a paper published in perhaps a not so reputable journal. And then there is the matter of what journals are reputable and what journals are not. That also is something that legal teams need to do. They need to empower judges in order to find out kind of which journals are most reputable, which journals are more rigorous and methodologically sound in their peer review process. Evidence lower down on the scale may have stronger value in the eyes of the court if it is based on scientific publications higher up in the hierarchy. So if an expert report does not create new science, but rather just makes reference to the IPCC, it might be seen as more authoritative than other expert reports. So this is just a very interesting trend we've seen in these conversations. I know that perhaps you might have quite a few questions at this point. Perhaps it is best to write them down and then later we can have a conversation. This is something that Samantha, I know, will discuss later, and so I'll just briefly talk about it. But scientists can have many different roles in climate litigation. The most famous one is to act as expert witness. However, they could also be part of the legal team as in-house scientific advisors. They could produce research independent of any legal team or initiative, and this could actually spur the filing of a case. They could submit amicus curiae briefs as and when required by the courts. And finally, they could engage in judicial engagement in the way that the IPCC was invited by the International Court of Justice prior to the release of the advisory opinion to talk about the physical basis of science, of climate change. So again, this all boils down to the fact that narratives matter, right? Particularly in data, in places where you might not have data that is understood to be positivist and mainstream and scientific. I say that in air quotes. Quite interestingly, one thing in this case of Held v. Montana in the US, which was filed by youth claimants, they mentioned that they could no longer enjoy summers because of changes in the climate. And they said that this led them to have mental health problems, anxiety, etc. Now, this is hard to explain in court. And so what the judge did in that case and what the legal team did was, instead of have just a psychiatrist as expert witness, they asked the children to go to the front, talk about their personal experiences in their own language, in their own context. And next to them was a child psychiatrist who would then explain what this meant to the court of law. So narratives can be a litigation strategy in that regard, particularly in areas where data is scarce or not downscaled. And it could be a really important way to communicate complex concepts in a legal context. And so we argue that the best way at this moment to bridge evidentiary gaps is through storytelling, because evidence is about storytelling. I'm going to talk about the divergences in evidence, but just a brief points on lessons from Luciano Luya versus RWE. So as I said earlier, Luciano Luya versus RWE was filed in 2015 by this farmer from Huaraz, Peru, against German giant RWE, essentially asking for a percentage of RWE's historical emissions into his adaptation costs, which amounted to originally 0.47% of RWE's historical emissions, and then later turned into 0.38%. This case went on for 10 years, and as I said earlier, in the middle of it, attribution science evolved so much so that an attribution study was done in the lake behind it, in the glacier behind where Luya is currently standing in that photo. So it did get dismissed in the end, but not because it did not win in the basis of evidence, but rather that the legal threshold of risk, according to the court, was not met. However, that said, the court did say that in principle, companies can be held liable for climate harms. And that is a very important precedent, particularly in Germany, but perhaps in other jurisdictions that is similar to that of Germany. So this was very much a David versus Goliath thing. And what this still says, is that a simple narrative won the legal precedent. Climate change is an issue of global justice. Transboundary harms can be looked into as a climate change issue. Those who benefited the most from the climate crisis has to pay up. That was the simple narrative within which Luya versus RWE was made. Second, scientific advances set the stage for new judicial ground. And again, this is mentioned earlier when I said that in the midst of it, there were an attribution science report that came out. And then as I said earlier, the case was lost over the framing of the evidentiary standards. So the lessons are, number one, that a core scientific team was needed throughout the case, right? They had to make sure that very early on, before the beginning of everything, scientific team was there. That would be useful to say whether a case could go forward if there were other scientific evidence already that could be used, etc. Finally, second of all, it's about narratives once again. The best science does not win a case. The most peer-reviewed, the most rigorous, the most cited article on scientific evidence does not win the case. What wins the case, or at least what wins the heart of decision makers, are whether this legal scientific evidence are presented to the court in a way that is understandable by them. So we now go into evidentiary needs for different case strategies. I won't delve into this further, mostly because this is something that is in the guides. But just to say that, as I mentioned earlier, the 3 different case typologies will require 3 different different kinds of evidence. So for government framework cases, you need to understand global climate targets, the 1.5 goal, for instance, which is not just a scientific goal now, but it's also a political goal. It's appeared in the Paris Agreement, it's appeared in conversations by the IPCC, but also it's appeared in the International Court of Justice's advisory opinion. When you have those global climate targets, you then look at national level action. This could be an NDC, a nationally determined contribution. This could be a climate change act, etc. And then when you have this, you then present evidence showing that either a state is not in line with this national level action and target, and then show the impacts that this has on communities, on individuals as needed. The second is on corporate framework cases. This is similar to the government framework cases, but again, specific to companies. So you look at pathways. So these pathways could be sectoral in nature. So whether oil and gas, coal, cement, automobiles, etc. It could be also national or global pathways, the global pathway being the 1.5. And then again, you look into what are defendants doing. Is their transition plan in line with this pathway? Are there advertisings in line with this pathway, etc.? There are also evidence that you can submit, such as non-pathway approaches, such as the red lines, as in no new oil and gas. And interestingly, that's something that was presented by Milieu Defensie in its most recent case against Shell. So they're saying no new oil and gas for Shell. A brief look into this. I am very conscious of time. So these are just 4 cases that have used different pathways. And it's quite interesting to see whether courts engage with these pathways and which of these pathways are easier to explain in a court of law. And as I said earlier, and perhaps it could be argued that a red line is a pathway in and of itself, right? Because a pathway is a way is an opportunity for you to move forward. And so if you say a red line, that could also be a pathway in that there would be no more production, no more extraction, no more sale of oil and gas. And so Milieu Defensie, as I mentioned earlier, was one of these first cases, filing a case against Shell, where it said that the pathway that they're looking for is no new oil and gas. And this pathways conversation is important in the context of, I guess, the intersection of science and law, because we are not in line with meeting the 1.5 degree target that is the goal of the Paris Agreement. And so if we cannot meet that, we have to do this thing called an overshoot. An overshoot is essentially going up beyond 1.5, peaking, and then going back down. I know it quite sounds like a different thing. Why would it be called overshoot? I feel like people usually mistake the definition, but it's important to know that an overshoot is a temporary exceedance. You go up, and then you go back down. And this relies on negative emissions technologies, which we know have issues in and of itself as to the integrity and use of it. And so we are getting closer to a world where we might need to look into these technologies, or rather, we might have to push our cases and claims stronger so that we have a chance to meet the 1.5 degree goal. Finally, polluter pays cases. So polluter pays starts with a causal chain, which will need attribution science. Sometimes evidence is presented, usually in cases of negligence and or unlawful benefits, unlawful gains. Thank you so much, Thomas. Of historical knowledge of climate harm. And then finally, evidence is presented on quantifying and assessing damage. And here we're going quite a little into deep with the science. I'm not going to talk very deeply into this. Again, we have a guide coming out particularly on causal chains and attribution science, which is the longest guide that we have so far, and we're very, very excited for it. It might come out in the next couple of weeks, and if so, I will send that off to Samantha for dissemination in case of interest to the people in the room. So very briefly, what is attribution science? It essentially creates a connection between emitter and impact. It's a field of research within broader climate science conversation that identifies and quantifies, as and when necessary, the causes of observed climate change and their effects. So you can now, with developments in attribution science, link between climate forcings or greenhouse gas emissions into the global greenhouse gas system, into impacts on humanity, on people, on livelihood, on biodiversity, etc. And there are four broad areas: warming attribution, event attribution, impact attribution, and source attribution. So source attribution is looking at the responsibility of those who emit. Impact attribution goes into the global system conversation. Event attribution. Impact attribution goes into the actual impact on the individual. And warming attribution is the broader conversation on how greenhouse gas emissions have contributed to the warming of the Earth. So one of the biggest initiatives so far on attribution is the World Weather Attribution. Perhaps you know about this when you read, say, the news a day or a couple of days after, say, a wildfire or floods or drought, where they say that extreme fire weather conditions is now common due to climate change, or the typhoon in the Philippines, where I'm from, was made X times worse because of climate change, or back-to-back typhoons in Pakistan and flooding in Pakistan were X because of climate change. So they don't answer whether or not something is caused by climate change. It's not as straightforward as that. Attribution science looks at how much climate change has been affected or has affected because of these greenhouse gas emissions, how much of these typhoons have been affected, how much of the floods could have been worse because of climate change. So the World Weather Attribution aims to release these extreme weather event releases analysis, and they focus and they regularly monitor extreme events from around the world. They use a probabilistic approach, again, which means it's not to say that climate change caused this, yes or no, but rather that because of climate change, X became more likely, X became 2 times more strong, etc. So it's a concept of probability. I won't delve deep into the different types of attribution science use, but just for the moment, we will use probabilistic approach. The second one, if we're of interest, is called the storyline approach, which are counterfactuals. So what world weather attribution does, and it's been helpful for many of the initial cases so far, is that they do a rapid analysis followed by a peer-reviewed study. So in 3 days or 4 days after an extreme event takes place, they release their analysis. Maybe a couple months after, they will release a peer-reviewed study. And how does this help? It helps because it is using an approach that is already peer-reviewed. Their methodology is peer-reviewed, so it's quite strong already and established in this emerging hierarchy. So we look at the causal links. I might be jumping around. I'm only quite halfway through, so hopefully we can do this. So first, emitter to global warming. One of the earliest defenses and one of the earliest arguments against climate change is, in addition to what Samantha said, that climate change is a hoax, but that second is that you cannot attribute greenhouse gas emissions because of the diffuse nature of global greenhouse gas emissions. But now what we've seen is that a percentage or emissions of a certain company has a specific percentage in greenhouse gas emissions globally. You don't need to identify specifically which, but you can identify how much. And the main source for this is the Carbon Majors report, which was spearheaded by Richard Heady in 2013 and has consistently been updated over the years. I do recommend looking at the Carbon Majors report. It's also the source of why we say that, that 70% of greenhouse gas emissions in the planet are caused by just 20 companies and countries. So that's how we get to that. We use the Carbon Majors report spearheaded by Richard Heady. From there, we look at how global warming then leads to physical hazard in a specific locality. So how will global warming lead to, for instance, increased rains and typhoons in a specific region? And then finally, that's event attribution. And then finally, we looked at impact attribution, which is what is the physical hazard, what does the physical hazard lead to with regard to damage to the specific claimant? So if it's, say, typhoons, increased in typhoons, that would mean the increase in damage to livelihood or flooding, etc. So that kind of creates this causal link. You can now, because of the emergence and development in climate attribution science, create that connection between a company emitting greenhouse gas emissions and contributing to global greenhouse gases, to that warming the atmosphere and creating extreme weather events, and those extreme weather events leading to specific impacts and damages to individuals and plaintiffs. So as I mentioned earlier, the Climate Majors database goes back to 1854. There have been questions about if you file a case, should you look back to 1854, or when is a good time to start conversations about a company's responsibility? Do we start in, say, 1970s when they started learning about climate change? Do we start in the 1990s? Do we start in when the UNFCCC was entered into? Do we start in 2015 when the Paris Agreement was entered into? And so that will be a normative choice for the lawyers in the room. There's also the question of foreseeability. When would they have known? When would the defendants have known of the cause and impacts of climate change, and yet did not do anything to deal with it? There's also issues of double counting, particularly with regard to downstream or scope 3 emissions. So these are all just things to consider when we look at source attribution. In the case of Luciano Luya versus RWE, they used the Carbon Majors report to identify the 0.38% contribution of Luciano Luya, of RWE to Peru. In the court decision, the court said that RWE should have known by the 1960s, which is when the first major study on Mauna Loa volcano in Hawaii was first released. And that was a study on greenhouse gas emissions and impacts on the global system. So what are the challenges? Currently, the Carbon Majors is the only source. And there are still data limitations, and much of this is about extrapolation. So what do you do in the interim? You really make use of narrative conversations. The second, you link global warming to specific events and changes. There are things that are easier to attribute. For instance, like droughts. It could be, the closer to the physical process, the easier it is to attribute. So drought is greenhouse gas in atmosphere. Atmosphere warms, temperature comes up, drought, right? So the closer it is, the physical processes, the easier to attribute. The further down you go, the harder it is, because there are other intervening factors, such as, say, it's hard to talk about increase in agricultural and ecological drought. Heat waves are easy to attribute, droughts are difficult to attribute. It's also difficult to talk about the increase in fire, because fire is not just a combination of drought and heat, but also combination of the capabilities, the vulnerabilities, the exposure of these places. So just things to note, that some things, the closer you are, so a heat wave, easier to attribute. Effects on sea level or coral bleaching may be a little harder. And what other challenges are there? So data availability is one of those. The IPCC is very much regional in nature. It cannot be more granular than that. And so if you want to choose a specific location for your case, it might be that there's just not a lot of data available. And so what happens is then you use broad data over a region, perhaps, and then aggregate plaintiffs. So more plaintiffs in one area would have a better chance of being able to file a case using attribution science, because of kind of the way within which we understand attribution science. It's not granular. It's the further granular you go, the further it is hard to attribute. And finally, linking specific events and changes to specific damages. So this is when you look at quantification. This is when you look at the differences between damages and adaptation cases. But the challenge, again, as always, is data availability. Perhaps more specifically in the Global South, where downscaling data is much more difficult. It's hard to create this link on effects, on impacts on livelihood, on lives, on family, on mental health, etc., to the specific flood or the specific instance of hazard. Also, how do you then, many questions of justice come out, particularly reparatory and redistributive justice. Do you assess non-material damage? How do you assess that? Is non-material damage even something that should be up for assessment, or are we just confining ourselves within a system that needs to put everything, that needs to put quality, quantity, and valuation to everything. And finally, confounding factors such as a person's existing vulnerability, existing exposure, whether they're older or they're younger is always a confounding factor. Whether they live under the poverty line is a confounding factor as well. So there's still quite a lot of things to consider when we talk about attribution science and the law. It is important to note that attribution science is emerging and developing rapidly, the law not so much. And so again, it's always a challenge for legal teams to see how you can use these developments to incorporate in a field that might not be working as fast as science. This is just a brief slide of looking at attribution and climate litigation. Quite interestingly, and again, we come back to the conversation of narratives, courts do not necessarily cite the studies of the world weather attribution, for instance, when they make their decisions. What they cite are news reports that are written after the release of this attribution analyses. And that's quite interesting, and again comes back in the conversation of narratives, because it then goes to show what courts are looking to for authority when it comes to many of these more complex issues. Not to say that the newspapers are authoritative, but rather because the newspapers are able to explain the science, then courts will look into those newspapers. It's quite interesting. I thought that was such a sociological, anthropological look into it, and it was a very important notice to everyone that it's important to have the science be understandable by a group that is non-specialist in science, a group that has had perhaps talked about law for decades now, but are now just starting to grapple with the complexities of climate change and the surrounding processes around that. So this is just a very, very quick causal chain. Perhaps this is a little reductive, but this is how we talk about the narrative of Luciano Luya versus RWE. So first, RWE's greenhouse gas emissions contributed to, RWE's burning of fossil fuels contributed to greenhouse gas emissions in the atmosphere. That was the first step of the causal chain. The second step of the causal chain says increased greenhouse gas emissions in the atmosphere led to increased global mean temperature, which means that the glacier in Lake Palcacocha, in which his community lives, is retreating. So that's the second part of it. That's the event attribution conversation. And then finally, on the impact attribution, is the risk of loss and damage in Juarez, Peru, and to Luciano Luya, who is plaintiff in this case, because of this contribution to greenhouse gas emissions. I mentioned earlier, and I will say it again, it does sound quite reductive when you put it that way, but this is kind of the conversation that courts will understand, because courts want to see X did something to Y, and that's why Y is filing a case against X, right? So courts are asking different questions from scientists. The goal of the lawyer and the scientist in that legal team is to make sure that the science that is currently in existence can answer the questions that the courts are propounding to the parties at hand. So as I mentioned earlier, more of these will be available to you when we have the guide up, which I hopefully will be in the next few days. So just final thoughts on this section before I briefly talk about corporate defenses, which is probably my favorite. But one of which is, number one, science and the use of science is a normative decision for the courts. In Milieu Defensive versus Shell, that was initially decided in 2021, the court said that Shell had a duty of care to reduce its emissions by 45% by 2030. This was appealed by Shell. And so in 2024, the Dutch Court of Appeal overturned this decision. they were presented, as in the court was presented with different kinds of scientific evidence from both parties, and the evidence range for an emissions reduction that ranged from 4.5% to 45%. The court said there is no scientific consensus on this matter, and therefore we will not decide on a specific number. And that's something that the lawyers in this room have to keep in mind as well. So what the court said at the end was that Shell did have a duty of care to reduce its emissions, but it did not say by how much, particularly in the context of Scope 3 or downstream emissions. Second, sometimes courts might not decide on cases based on the science if they have existing legal doctrines such as human rights. And this is perhaps most important in cases where, I know that you have in your constitution the right to a balanced and healthful ecology is the same as in the Philippines. So it might be that courts, even while presented really strong attribution science, will end up deciding using a legal doctrine that they know. So in the case of Klima Signorina versus Switzerland, this was filed in the European Court of Human Rights. The plaintiffs, which was an NGO representing senior women in Switzerland, released or provided an attribution study talking about the impacts of extreme heat to the morbidity and mortality rates of senior women. It was very well written. It was a very strong piece of evidence, I would say. The court at the end of it decided to go back into the European Convention of Human Rights, particularly Articles 2 and 8 on the right to privacy and family life. When it mentioned science in its decision, and it made reference to the broader IPCC conversation and not necessarily the attribution science report that was submitted. So just something to also keep in mind, that courts, again, because they're responding to specific questions, have had for the longest time specific ways within which to answer these questions. And that's exactly why we have the concept of precautionary principle, for instance, where if there is uncertainty, it should not be a bar from action to be done. Next, sometimes courts will defer to the judgment of court experts. So in the case of Yuya, as I mentioned, there was an appointed court expert who then discussed what the attribution science meant. And so essentially what happened was that the court expert directed the conversations on science. The court did not question the results of the attribution or of the understanding of the court expert, and that therefore kind of changed the discourse, changed the direction of the conversation. So that's also something to keep in mind, especially in jurisdictions where court experts can be appointed. And finally, maybe attribution science, amazing as it is, might not be the most important thing to present. For instance, in Brazil, strict liability is one of their main sources or causes of action for environmental claims. And as we all know, you don't necessarily need to identify the specific harm that is caused by a corporation, for instance, but rather that they form part of a group of other corporations that have caused harm. And in that case, you don't really need the specifics of attribution science. You only need perhaps, I don't know, maybe knowledge of climate change and yet profiting off of it. Maybe you just need that they have attended a conference on climate change and therefore know about its impact. So I say all of these because I think we need to enter this quite in a more sober manner. That attribution science is great, is working where it is working, but jurisdictions are jurisdictions. Courts might decide differently depending on their own legal systems, depending on the cost of action, depending on the relief asked for by the claimants. And so it might also be that even with all of these, the courts might just decide on the things that they know. The court might also just defer our decision making on the science. And those are things we have to keep in mind and keep thinking of with a sober, kind of level-headed manner. In the interim, I understand that perhaps in the next 5 years and next 10 years, there will be much more intersection. But right now, what we've seen is that in some cases, courts will be much more conservative, go back to legal doctrines. Other cases, they will engage with the science. What we do know for sure is that courts do not operate in silos. They read the news. They look to other jurisdictions for assistance in decision making. They look to the ICJ advisory opinion, such as in the case of Bonaire v. Netherlands in the Netherlands. And so that means we have to, as much as we can, engage with the courts in very different manners, right? Like, this is why many of these cases also have an NGO working with them. Many of these cases have campaigners, because courts understand climate change. Courts know this because this is lived experience. And therefore, the way that they decide a matter will depend very highly on these many different factors. And so these are just things to keep in mind. Okay, so I have 20 minutes left. I'll just have a sip of water, and I think I'll briefly discuss corporate defenses and climate litigation, just because it might be quite interesting for those of you who are already doing things and might have to preempt or perhaps think about how to frame your arguments or how to present yourself so as not to be questioned by defendants. So this is something that is our second guide. It's called Corporate Defenses in Climate Litigation, a comparative analysis of arguments and court responses. So I actually quite like it because it's not just looking into corporate defenses, but also whether courts are engaging. And again, as mentioned, and as will always be the case, these are all going to be just emerging trends and themes and not at all prescriptive in nature. Okay, so this was briefly touched upon by Samantha earlier, but corporations, or at least defendants, no longer deny climate change, right? I would say that that's perhaps very 1990s. What they do deny, however, is the size or the impact of their role in climate change, in anthropogenic climate change. So instead, what they challenge are the evidence of the plaintiffs, or they promote counter narratives against the plaintiffs' evidence. And so we argue that the legal evaluation of climate science will be fundamental in shaping future climate litigation outcomes. And so we have 6 identified kind of corporate defenses, and I will talk to you very briefly as well about how the courts have approached these. So first is diffused responsibility. They say that corporations say that, yes, we have contributed, but it's not just us. Society is to blame for climate change. And in fact, to bolster these claims, corporations even make mention of the 5th assessment report of the IPCC, which mentions that emissions are driven by population size, economic activity, lifestyle, energy use, land use patterns, technology, and climate policy. And as well as they also say that we are producing energy, and energy is a common good. Energy is a utility that is needed by the public. We are doing something that is beneficial to the public. And that really what are needed are political solutions to address climate change and not changes in our work and in our operations. So the courts, and we've used the cases of Luciano Luya versus RWE, Milieu Defensi versus Shell, as well as the admissibility decision of Asmania versus Holcim, to look at how the courts have responded. And in here, actually quite interestingly, the courts say, yes, we agree that energy energy security needs are important. We agree that energy is a common good, a public good, but that doesn't necessarily mean that fossil fuels are the way to move forward anymore. This was particularly highlighted in the case of Luciano Luya versus RWE, where the Regional Court of Ham actually said that, that for the longest time, industrialization has been about fossil fuel extraction, development, and use. But we are in a position right now where renewable energy actually makes sense as a path forward. So it's quite interesting that courts are really engaging with these arguments, and we're very happy to see this, that this is being engaged with by the courts. The second, they argue that there is no legal duty. So they say that their operations are lawful, that they are licensed to do these, that again, their operations are essential to as a public good, as a common good. They say that there are no specific statutory obligations that existing operations need to comply with. They sometimes question the lack of policies and laws that could give rise to a cause of action. And they say that in cases where the emissions trading scheme is mentioned, that these frameworks are market-based and that they do not necessarily impose mandatory reductions or prohibitions. So this is quite coming back into the more legal argumentation on the legal basis for the claims. And it's quite interesting because the case in Smith Fonterra in Aotearoa, New Zealand, actually made mention of this. So in that case, one of the causes of action was the creation of a new tort based off of customary indigenous law called Tikanga Maori. The court or the defendant said that they were challenging the legal basis of that claim, but the court said that it actually has its time and place in the court of law. Very interesting as well. Next, we go to the more scientific arguments. So courts are challenging the substance of the science. They're highlighting scientific uncertainty. In the case of Greenpeace Italy v. Eni, which I mentioned earlier, which was filed in 2023, at the earliest opportunity, defendants were like, actually, because climate attribution science is such an emerging field of science, there is a lot of lack of scientific consensus. It's still very early. It cannot be believed to be able to respond to questions of law. They mention uncertainties in climate modeling. They mention the uncertainty in the viability of emissions reduction targets, which was in the case of Milieu Defensie versus Shell. And as I said earlier, Milieu Defensie versus Shell, the court did say that there was no scientific consensus and therefore it could not provide a specific number, although it did say that Shell had a duty of care to reduce its emissions. So what we're learning is that courts are increasingly listening. I won't say they're swayed, but they're considering these argumentation. What legal teams ought to do, I would argue, is to argue that courts actually, this is a normative choice. This is a normative judgment. If a range is given, say from 4.5% to 45%, courts have the ability to make a decision to choose between those ranges. And so it is a matter of empowering these courts to make decisions on what they might believe to be outside their remit or ambit of judicial decision making. Next, market, also known as the market substitution argument, or actually in many cases, perhaps in the tobacco cases in the US, it's called the drug dealers argument, which is essentially, if it's not us, then someone else will come in. If we stop production, if we stop development and usage and extraction of fossil fuels and sale of fossil fuels, other companies will just come in. If their production is eliminated, it will not lead to a significant reduction because demand would be met by producers supplying equivalent products of either in the jurisdiction over which the case is being filed or in jurisdictions where there are less stringent regulations when it comes to fossil fuel extraction, production, development, and use. This was one of the biggest arguments of Shell and Mio Defensi versus Shell. They were like, okay, if we are to stop, that does not mean that oil and gas production will stop. It will just be done by competitors, by other organizations, and by other groups that are extracting oil and gas. The court said in this case that even so, and this was also what the court said in the admissibility decision in Osmania versus Holcim, was that even so, even as we say this, even if we agree that that your production will be offset by other companies, it does not mean that you personally do not have a responsibility to cut down on your emissions. And I thought that was a very, very salient proclamation from the court, that just because others might do it doesn't mean that you yourself, your institution, your organization, your company does not have the responsibility to do your part in abetting the climate crisis. Number 5, they challenge scientific credibility. And this is perhaps also quite interesting because we are talking a lot about the intersection, not just of law and science, but also of lawyers and scientists. So in this case, the defendants could question the legitimacy or the integrity of a scientist who is thought or whose work is presented to the court or who is made mention as a potential expert. And this happened in the case of Luciano Liuya versus RWE, where defendants raised an objection against a proposed expert for the case because they pulled out Twitter accounts, and they saw that a few years ago they posted something about climate litigation being interesting, and they said that this meant that they were biased towards climate litigation. This was actually the reason why the court eventually ended up appointing its own expert instead of having the parties agree to an expert. So this is a particularly dangerous thing, I would say, just because mentioning climate litigation should not be a barrier to be an expert in a climate litigation case. In the same way that you cannot say that, say, a heart surgeon is biased for looking at cancer research, like it's not the same thing. It's false equivalence. Just because somebody mentioned that climate litigation is interesting, or just because they went to a conference on climate litigation, does not inherently mean that they are biased. It just means that their work is in relation to climate litigation. And so as and when this comes up, as defense plaintiff teams and legal teams should be careful to already rebut this quite early on in the process. Final strategy is questioning judicial competence. So essentially, if they cannot question the law, if they cannot question the science, they question the competence of the courts to decide on these matters. So this is also known in the US particularly as the political doctrine principle, where they say that courts are not the right forum to resolve climate disputes, and that this is something that is best reserved for legislatures, for politicians, for parliaments, and that climate litigation engages in judicial decision making, and that they raise policy questions that exceed the scope that they engage in judicial legislation, and that policy questions may exceed the scope of judicial decision making. In this case, the courts actually said that this is not true. In the case of Asmania versus Holcim, for instance, they said that actually personality rights are well within the ambit of the courts. In Asmania versus Holcim, they said that questions of customary law are well within the ambit of the courts. And so this corporate defense we've seen so far have been not winning or not gaining its day in court, because courts are actually engaging quite deeply into the argumentation. And finally, when they can discredit the science, they question the motives of the plaintiffs. They say that lawsuits are symbolic and not based on real actionable harm. In the case of Fales v. Total Energies, they did this because Fales asked for an amount of the term was, I forget the term at the moment, but essentially Hugues Fales, who is a farmer in Wallonia in Belgium, asked for an amount of €1 for every instance of drought that happened between 2016 and 2022, which was alternative to his main claims. In the case of Asmania versus Holcim, Holcim said that this was just symbolic because the islanders just want this for climate justice and are not necessarily personally affected by the operations of Holcim. And to that, the plaintiffs say, okay, assuming arguendo that this is a climate justice claim, it does not preclude the fact that the plaintiffs in the case have legal standing and have specific harm to them. And so it's very interesting, again, in the context of narratives, to really put this forward, precisely because in some jurisdictions, standing is much more stringent than in others, and that includes Switzerland. Switzerland, you have to claim specific harm to you and your person. And so the way that corporate defendants are phrasing it as something that is just a move towards climate justice and not necessarily something that the plaintiffs consider to be personal injury to them is very, very important. It has to be at the very beginning provided in that manner, in that, okay, climate justice might be the end goal, but that does not preclude the fact that personal injury and harm has happened to the plaintiffs. I am about to finish, so I hope everyone in the room is still okay and listening and enjoying their coffees and their teas. But this is just something, I guess, a precautionary tale to bring to those who are going to start filing their legal claims. And this is why I said earlier that there are many ways by which scientists can participate in cases, and that if they deem so necessary, legal teams can also have specific scientific teams within their circle. So this was a case called Multnomah County versus Big Oil in the US. And Chevron, one of the defendants, filed a petition to discard two of the scientific evidence presented by the plaintiffs. One of the evidence, or one of the scientific papers produced, was this paper on anthropogenic climate change contributes to wildfire particulate matter and related mortality in the United States. In the fine print, it says that partial support was provided by Woodall Climate Research Center and Roger Worthington. Roger Worthington is part of the plaintiff's legal team. So lawyers for defense say that this was highly biased, this was not transparent, and therefore should be discarded in the court. And I would actually argue that this was such a setback. This could have been, this was a preventable mistake, I would say. First, one is if you talk about the fact that this is a peer-reviewed publication in one of the biggest journals in the planet. One, if you talk about the fact that peer review is transparent, independent, etc., that could have been a good enough bolster to make sure that the defense don't take discussion or take action with this. And second is the transparency of it all. Like, they could have mentioned this acknowledgement and the relationship between plaintiffs and the scientific evidence presented. That might have caused them, the court, to junk the scientific evidence in the first instance, but at least it would not have given the chance for defendants to raise that quite deeply into the case already. And so I go back to the role of scientists. It's important that scientists are part of legal teams because they're able to say from the get-go whether a case is justiciable, or whether there are already scientific evidence on that regard. It's also important that some scientists, or many scientists, are kept not just at arm's length, but completely independent, especially if they have produced evidence that might be relevant to the case at bar. You don't want to compromise the integrity of the scientist just as much as you do not want to compromise the integrity of the case. And so I am mindful of time.
Apologies about that. Thomas is working around it, the IT team. But she was closing in on her presentation. I don't know.
Sorry about that. I am back. Yes, so just to say that I am mindful of time, and I guess two things come out strongly. Number one is science is really emerging quite rapidly, and lawyers have to engage with the science, but also fully knowing the disclaimers of legal systems, jurisdictions, and such. And so that might mean that there will be kinds of scientific evidence that would be most relevant, but perhaps not all. And that's a sobering thought to have. And second is the power of narratives, where science is not yet available because of data issues or technical limitations. Narratives form a very, very important role, not just in talking about the intersections of law and science, but also in empowering the courts to make decisions over things that they might not have expertise over. And so that is me. Thank you so much for having me, Greenwatch, Samantha. Thank you to the participants of this workshop. And I hope that what I said was helpful. And I'm very happy to stay on for a little bit if there are any questions for me.
Yes, thank you, Joy. I do not know if you had on your end hand claps from the audience here. But thank you for your presentation. Attribution science. Hey, the lawyers at the back there. I remember one of our colleagues wanted to know the nexus. And then I was also reminded when I was being told that science is both, the law is both a science and an art. But also picking from Dr. Bazira's statement earlier that they got impacted by the heavy rains. When we speak of source attribution, impact attribution, we are just going to have a conversation. We are going for the Q&A to Joy for about 15 minutes. Then maybe she can respond. Yeah, so we just want to hear from the audience in the room. From Joy's presentation, what you make of. If you have any questions, then we can pick from there. Thank you.
Hello, testing. All right, thanks for the opportunity to make my response. And making this response not necessarily just from these two presentations, but also as a practitioner in the sector for quite a bit of time. And what I have observed has been well explained about attribution of environmental problems with the law. And one of the things I observe that is going to increasingly become a challenge to science and litigation, especially environmental science, climate change science, is the political science. The political science in our context as a country, but also on the context of the globe, geopolitics. And that I want to target in also as the politics that are associated with the corporations. Because we may have to be mindful of the political science and the geopolitics on how it influences even the evidence that you present. Because just a mere looking at Richard and they dislike him is enough to say he is not credible enough to be speaking for climate change. Who is the true lawyer for environment? Do you have the locus to actually speak for the environment? Does the environment mandate you? And how does it mandate you to speak for it? So those are questions I've been, and I think this is a matter we've been discussing in our, I think, drafting of the most recent environmental law. As a citizens, do you really have that locus? Do you have that power? Where do you get the power to actually speak on behalf of the environment? I talked about the floods I went through on Nakawa. The place was actually around after Chambogo, the place was flooded that no car would pass through. If it was to pass through, it would be covered, as I'm talking about a small car. So the traffic had to divert us. Now, who do you blame that one to? Is it an act of God? Is it poor infrastructure? So you see where the gray areas for you to blame somebody or a corporation, because you have so many industries there. Are you going to blame them for the flooding? Or are they going to blame it on the rain? Are they going to blame it on the slopes that we have, the nature? The fact that we are sitting where we sit now actually is at the bottom of Lake Victoria. 4,000 years before Kampala was formed, this place where we are was at the bottom of Lake Victoria. I don't know how many people know that. So people may say, water is trying to retrace its original what? Domain. Can you blame that to any corporation? So those are things that I need. There's another one point I want to talk about. The issue of emissions trading. I look at emissions trading, and I know we are going to use emissions trading and even carbon trading as a source of climate finance. But we need to look at emissions trading, the concept that was brought as a penitence. Catholics understand what I'm talking about. As a penitence to move away, if you notice, we have been shifting away from polluter pays principle. The principle was well grounded. It provided attribution. But with this emissions trading, carbon trading, it kind of circumvents who you must blame. Or they use it as a justification for continued what? Pollution. So these are thoughts I just wanted to share. It's not a question, just comments. Food for thought. Thank you.
Yes, thank you very much. And thank you very much for the speaker, Joy, I think. It's a very interesting talk, and I learned a lot. You talked a lot on attribution science and maybe biases, and I would start by reminding us that science is guided by natural laws. And science is meant to acquire knowledge. Science starts by observations, and there is a theory to how you can prove. When you make observations, you ask questions. And you then seek answers to these questions. You form what are called hypotheses. These hypotheses must be tested. And some of the things you are talking about are how do you test these hypotheses and how do you prove. And that leads to what is called design. Again, most of the things you talk about attribution, biases are related to how do we design our studies. So because this is what we call experimental studies, where you need to have a control so that you can prove this will not occur if this is not. So when you design your study, you should be able to test, and this should be not only you to test it, others should be able to test it. Then you publicize it, and other people should be able to come and test this. For example, if I want to test the average height of this room, I will come here and measure the average height. And this average height should also be able to be proved by another person, not me, and should give me the same answer. And that's what science tries to do. And if you don't do that well, then it can be questioned. What tools did you use and what others? Now, how did the climate change come about? Maybe it is also good to remind ourselves. Even what Samantha said, some people were saying, this was concocted. But if you go back, actually climate change was discovered by scientists. It was not by artists. The first person was who observed the greenhouse effect was a French physicist. He was a physicist or mathematician. He just looked at the distance between the sun and the earth. Conventionally, the earth should be cooler because of the distance. And he said, why is it that the earth is not cooler? So what he observed was the greenhouse effect. That the earth actually, that blanket attracts, tries to trap energy, which is reflected back. And that's why the earth is hotter than what it is. So that was a science. And then the second person was a Swedish chemist. This lady was able to show actually carbon dioxide raised the global temperature. And she was able to link this and demonstrate it. You see, the third person was an American scientist as well, Eunice. He was able to heat carbon dioxide and a normal gas, and temperatures of carbon dioxide were hotter than the normal gas. And these were experimentally, and she was able to demonstrate. You see, now that the kind of the modern science which linked to carbon dioxide to carbon dioxide, again, is a British engineer, you see, called Guy Callender. And that's why we have the Callender effect in climate change, 1938. So he was able to show this. So basically what is happening in science. But now how do we design our studies to show that actually to avoid these biases and to have attribution? And that now is the challenge. Because he also talked about compounding factors, biases, and all of that are related to what I call the design when I was giving the theory of how science does. So that would be a bit difficult because, one, climate change takes years. It's about 30 years or plus. I'm sure with lawyers, even if we said malaria is caused by mosquito, they will challenge that. But for malaria, it is easy because you can inject the parasites to them. And within days, it will show up. Climate change takes 30 to 50 years. So it will take years to prove that. So it means time will be a problem. And then also what will be your control? Those compounding effects Joy was talking about. How do you prevent that the compounding effects are not affecting your experiments and so that you're able to attribute? That will be a challenge. And then the duration. How long will it take so that your data can be attributed to a specific event, as we were saying here? So these are the things we needed to kind of debate or discuss, and maybe also trying to now organizations like Greenwatch, we need discussions like we are doing now between lawyers and scientists to understand how the two work. Thank you very much.
Yes, thank you, Dr. Isaiah. You see, interestingly, you've said climate change is a science. Now, me as a lawyer, I'm wondering where I lie. Whether I was part of those scientists that answered that question. Interestingly, as I go to the next participant, what has also shaped our law has been people like Pythagoras, people like Wesley Hofeld, who was a chemist and also a mathematician. But I know at the end of the day, ultimately, we shall know where we lie. Are we fully the other side or fully here, or we are there in between? Yes. Yes.
Thank you very much. I am a beneficiary of science. Like I said, with Dr. of Sefrot, because we have engaged ourselves in some bit of advocacy, and we have, in a way, convinced lawmakers, because we have interacted with scientists who are seeking to have a common good. But we have also, in that path, also identified that there are also other scientists who are biased, in the sense that I hope you remember during COVID, there were scientists who came up with findings saying that smokers are safer because tobacco that goes through the lungs will save them from being exposed to tobacco. And of course, big industry. We have had big industry come up with stereotypes and narratives, which in a way, of course, other lawyers will buy into. I wanted to also say that Uganda has, because she was giving us cases from other jurisdictions, but Uganda and East Africa also has jurisdictions that are highly persuasive, and one of them being where we witnessed the reading of a judgment by Greenwatch's founder, who was the biggest activist of the environment. And all of us who are activists for tobacco control were shocked. That also takes me to, at some point you have heard people saying, are the judges indeed part of the society where we live in? Or they are closed from what is happening? But the former Chief Justice said that the judges will talk from the bench. I hope you remember recently, a judge was retiring and he said something which, by the way, shocked others. So the judges indeed are talking. But also the judges believe in what the scientists actually say. They are indeed persuaded by the scientists whose research they have actually confirmed that they never got funding from big industry. So the ethical research peer review is very necessary, especially for the peer-reviewed journals, that they in themselves can persuade the judges even before actually, if they look at a track record of that particular scientist. You remember there is, I'll mention somebody who said, animals should not be used in a circus. You remember at some point they were bringing gorillas and they were throwing them around. Animals also get annoyed. Nobody believed it. So we are benefiting from those. I also wanted to state that communities, indeed, she also said about narratives, whether a testimony from a community can be believed or disregarded. I think the Friends of the Earth in the Niger Delta give us good testimony that indeed people who see their fish floating or they see their animals running out of food, they are attributing it to maybe the gods have not been annoyed, but there is some human error somewhere. I also speak from the tobacco control constituency. There is from a convention on tobacco control where testimonies are shared, where countries are also supported, the developed and the undeveloped. And I think that also speaks for the food industry, even for the sugar industry. There were a time, I think you have seen the soda industry advertise even in places where you have gone on a Children's Day. You see teardrops and all over. The tobacco industry also used to do the same. You remember Marlboro and the cars. The beer industry is equally doing the same. But increasingly, when testimonies are actually even given by people who have nursed a patient who was exposed to a bad product, that narrative at some point is elevated to what would come from an expert. Thank you.
Thank you. And speaking into storytelling, I've not heard any one of us speak about how you use statements that can be understood by the wider public in your publications. I do not know whether you insist that we do not get to understand clearly what you mean, or it's a different thing in our jurisdiction in Uganda. I don't know. I think it's something we can talk about too.
Yeah, thank you. Thank you, Chair. Yeah, for me, I also appreciate the two presenters for the additional information shared, the experiences in respect to litigation, and actually giving examples of how these have been followed through and what has come through, but also the challenges along the way. I just have a few observations for reflection, and maybe to start from the mindset of the judiciary in terms of appreciating and using scientific evidence and attribution in these cases. If you look at the trajectory and you look at where we are coming from, where we are and where we are going, I think increasingly their mindset and attitude is changing. And it also means we need to position and see how to engage to support them along that. Because if they don't believe in the science, then maybe it may not be a key consideration in decision making around these cases. And I think Joy has also clearly brought it out that there are other factors that inform that decision. So it could also mean that as we go through the litigation process, it is useful to be also mindful of what is happening in the landscape and also see how to engage. Then the other, I kept reflecting and saying how much scientific evidence or attribution is required for a specific case. There can be a risk where you provide too much or too little. So the legal team and the scientists maybe need to reflect internally and organize to know that or decide that whatever they are bringing in front of the court is actually adequate and just enough to make the decision. Otherwise, there can be a risk sometimes when you talk too much, it might also raise more questions. Yeah, the basis of disputes, quite interesting. And for me, what I picked, maybe Joy can confirm. Does it mean that also, because you kept saying these two terms, plaintiff, defendant, and then the judge. So does it mean, or in reality, does it mean that also the other side or party has a scientist on board? And as you're presenting your evidence, it's possible that this can be challenged. Then if that's the case, it would be also useful to reflect on the evidence you're presenting, whether it's meeting the acceptable scientific standards in terms of methodology, principles, and so on and so forth. Because if you haven't prepared very well, you might present evidence that can be thrown out, and that can be a bad start as you engage into this process. Then I like the hierarchy Joy presented on the quality of science, the IPCC, regional advisory bodies, and then the literature review, peer-reviewed articles and study reports. Yeah, whereas the IPCC might be of high quality, there are also challenges that in some cases it is generic and may not be very contextual. So maybe then that means that one source may not be enough. Maybe you may need more than one source. But also sometimes you may need to do additional studies to generate the evidence, maybe based on data available, and you do a data analysis and trends analysis in addition to what you've got through those sources. And of course, I like this comment on the testimonies, and for me this speaks to the realities on the ground. Does the science speak to the realities on the ground, or it is the opposite? And sometimes the realities on the ground can tell the whole story or even make decision making easier. Because I remember 15, 20 years ago, we talk about climate change, and people, public would think maybe we have vested interests and they think it's a hoax. But I think it's when the floods in Teso happened, I think these awakened everybody's mindset and thinking that maybe this is the real thing to deal with. Yeah, thank you.
Thank you, Doctor. I had wanted to come from the other side like this, but it's okay. Let's do this, then we go to... Yes, Doctor. It's okay. It's okay.
Thank you so much. I think since I'm in front of you, I can stand. My name is Apollo Bregea. I'm a civil engineer. I work at Makerere University as a lecturer. I think I came in between the presentation of Joy, and of course I'm a victim of climate justice or injustice, where I stayed, it rained, and I couldn't move out of my house. Yeah, so my colleague who talked about the rains and the floods, I feel you. I captured the conclusions, the two main conclusions Joy made. One being that science is emerging as a tool in delivering justice, and the second one being that, yes, the power of narratives is important. And then she pointed both to data, that if we do not have enough foundational information to support our narratives, our evidence, then justice is going to fail. Lawyers are going to come and challenge us, scientists and engineers. And it's very easy because a lot of scientists are conflicted. But I want us to bring it back home because I think justice is also applied in context, within context. We as Ugandans and Africans, of course, we must all understand and appreciate that climate justice, infrastructure development, industrialization, affordability, and sovereignty must all come and exist in context. And of course, I have a few points I would want maybe Joy to reflect on and come back to us. One is that climate justice without industrial justice can deepen Africa's dependence and poverty. And of course, Africa contributes very little to global historic emissions. As a matter of fact, each one of us here, the per capita carbon footprint you have is 0.12 metric tons. The 2015 Paris carbon footprint threshold is 2.3 metric tons. So you're still at 0.12. You're supposed to increase to 2.3. I mean 2.3 yes, metric tons. That of London is about 17 metric tons. And then we are told to fix our carbon emissions. Who should be told? And I like, my friend talked about the carbon credits. Actually, we should frame it well. It's a good way of trying to tell those who have cooked our planet to continue cooking it, and we cover them, okay, with our 0.12 metric ton per capita. We are telling them that yes, we can give you our cheap carbon, create legitimacy for you to continue polluting as you buy very cheaply from us. So we must come out clear and understand that Africa cannot solve poverty using policy frameworks that keep us behind, that makes production or productivity very unattainable for Africans. The second one is scientific evidence must be contextualized for African realities. A major problem in global environmental discourse is importing standards and assumptions that are Eurocentric. And here I want to talk about the FIDIC form of contract that we use to procure construction projects. Mainly, if you look at the drivers of carbon emissions in sub-Saharan Africa, it's going to be infrastructure development, the materials and the construction processes. Now, FIDIC, we all know how it comes about. As lawyers, consultancy companies in Europe assembled, about 300 of them, and developed a frame of contract that should be used to procure infrastructure projects. In Europe, where infrastructure was well evolved, they have laboratories, they have standards, they have systems that are different from us. As a matter of fact, if I'm building a house in Europe, anywhere in Europe, 70% of the cost of developing that house is going to be labor. 30% is what goes into materials and technology to develop this house. Now, for that matter, their karma structure is based on high labor risk because the cost of labor is higher. Come to Uganda, if you're building a house, 80% goes to materials and technology, 20% labor. No wonder our contractors are businessmen, not engineers. But in Europe, they are engineers. And so when they frame their contracts, they are trying to manage a risk of high cost of labor. And these contracts are not just stopping at the legal terms, they're also looking at the technical specifications. They're looking at the way you advise on how infrastructure is going to be delivered, constructed, methods of construction. We are seeing 3D printing. You've heard about 3D printing of houses. It's very exciting for them because they are dealing with the 70% labor. If I'm buying a bag of cement in Germany, it costs 3 euros. But if I hire a German labor to build a wall with that one bag of cement, you're going to pay 100 euros because it takes 2 hours, and per hour it's 50 euros. And therefore, to cut that cost, they want to eliminate a builder and have a machine do the work. Here, the same bag of cement is 10 euros, but labor is less than 1 euro. And therefore, when I blindly go and inherit their frames of contracts, their standards, their way of work, I come here and drive dependence. I make infrastructure development unaffordable. We know that when we build a house here for rental, you cannot recover that money. We also know that we grew up in houses that do not actually qualify under the European standards as houses. But didn't we grow? So when a standard, when you achieve something below a standard and it serves a purpose, doesn't that show that the standard is actually mainly an instrument of commerce, not necessarily equality matter? So we need to know that we cannot. Science is strongest when it understands context and not copying geography. The third is environmental protection and infrastructure development are not enemies. Often we come in to present it as the narrative as they cannot coexist. But then, of course, when you have poor infrastructure, you're going to destroy lives. You're going to find people living in flooded zones. People are going to die. Poor roads increase poverty. You have health risks. Okay? And so the question is not, should Africa develop? It should be, how does Africa develop intelligently, affordably, and sustainably? Okay? And in this, you want to engage advanced spaces that have data, that have research that is evolved. Can justice be delivered by us accessing that information and developing intelligently? The fourth is Africa needs local grounded, low carbon material innovations. I have encountered 2 incidences sponsored by, one by World Bank and another one by EU entities. One, they sponsored a Swiss engineer to come to Uganda to meet the Minister of Water and Environment and sell them the idea that we can reduce the carbon emissions of cement by replacing cement with clay, which has to be burnt at temperatures of 800 degrees Celsius. and the maximum replacement level was 40%. Now, clay comes from our swamps. Uganda currently substitutes cement by 55% using volcanic rocks, which nature cooked long time ago. But here you are from Europe telling us, sponsored by a funder, by EU, to tell us that no, you must get clay, burn it, put in more energy, and replace cement clinker by 40%. And so, lucky enough, I had cement companies in the audience, and when we explained and asked those questions, that narrative died. The second one was World Bank funding a study on carbon capture in Uganda. By the way, those two studies had European technologies backing. So when we see these studies coming, you want to ask, where are we in the value chain? Are we manufacturers of technologies locally? Do we even have carbon dioxide? Since we are at 0.12 metric ton per capita. So those are questions we want to ask. Okay, so we need to understand that yes, where we are, science must be applied in context. So another one is that courts, I'm about to finish. Courts increasingly shape engineering and industrial decisions. Yes, we are seeing that you are encroaching on our mining licenses, infrastructure approvals. People are going through courts and threatening you they can build in swamps and on top of drainage systems, water management, land use. Now, if engineering is absent from these conversations, of course, technical decisions will increasingly be made without technical understanding. You lawyers are going to start making technical decisions, and where, of course, knowledge is not, you're going to be bold. Number 6 is scientific integrity must remain independent of donor ideology. Of course, scientific credibility depends on independence and transparency and contextual honesty. I don't want to go deeper into that. We all believe it. I appreciate it. 7, Africa's greatest climate vulnerability is weak systems. We are not about carbon emissions. We are about poor drainage, fragile housing, weak urban planning, informal settlement, poor maintenance culture, low industrial productivity, weak local manufacturing, and then, of course, all those capped by imported dependence. So climate justice, climate resilience are not only about carbon, it's also going to be about whether we as a society can build, can maintain, can adapt, and recover from poverty. And finally, litigation should not only punish, should also stimulate better systems. Well, strategic litigation can improve accountability, but it should also reward innovation, it should reward local manufacturing, should reward safety, safer infrastructure development, and responsible industrial transformation. And of course, to make sure that our people are lifted out of poverty. That's what the motivation for justice, or climate justice, should be. Thank you.
Thank you, Apollo. This is interesting. Now I'm seeing we are going to have a very good panel discussion from the so many points that are being raised here. I hope the panelists before us are also taking note. Let's have Mr. James, then we have...
Okay, thank you. I know a lot has already been said, so I will also try to be brief, very brief actually. I will bring a common saying in Luo, I am Anachole. Normally when we have a gathering of this nature, we say kachoke, where people gather. And now where people gather, some come with very refined views, some come with very abstract, some come with very completely almost offside, kind of. But in their collective, they actually help to refine into a desired goal. So I might just be coming from the other side. Earlier on, we asked the question whether it's for the social scientists or the natural science or whichever science. But one thing that gives me confidence is when at a national level we question whether mathematics is either natural science or social science. We are still somewhere in between. And many teachers of math have been asking why they were not considered scientists in the salary hikes. So my point is not very different from what this earlier colleague talked about, contextualizing. When we look into the national context, what is that big question on science and the strategic issues that we need to litigate on? So many times we ask, what are the key issues that needs litigation? Do we have to litigate on every issue, or there should be specific issues that require litigation? And recently, I wrote some article on, I think 2024, on our energy transition and how we are at the crossroads. And the article also looked at the global energy asymmetry and how we are emitting too little of the carbon and compared to the global north, and why it is a very painstaking process for us to embrace the process or in energy transition. And so my issue is we need to contextualize and we need to ask the big question, what is the key issue that we need to litigate on? But I think for Greenwatch, it may be a clear cut because from the ambition of the creation, you could see that it was more focused on Uganda's environment, how we should keep the Pearl clean. Because when you give a reference from the creation of the Uganda's constitution and also the founders and the groups that helped to form the institution being key stakeholders in that space, then probably it was more aligned to Uganda. Then probably we could say also East Africa, but we need to understand which context. Many times the injustice comes when we look at the global context and then we don't think about the abstract reality at the local context. When we look at greenwashing, for example, I know this has been talked about, but very little was expanded on from the presentation. But you realize that most of us who are trying very much to embrace the carbon credit system are working with companies who are aligned with those in the global capitals. And we have a question of who gives you the measure of how much you have actually reduced emission on so that you get the dividends back to you. You realize that companies are partnering at the international level, but we are also enrolling local communities to embrace the programs. But many times, sometimes the good thing in embracing the products are basically from the products you buy. Maybe you bought a cook stove and they have told you the cook stove is at this lesser value compared to if there was nothing, it would have been this higher. But actually when you are utilizing that, you are actually helping to reduce emission, but cumulatively, the benefits could have actually plowed back that when companies are eventually paid, you could actually have also, as a consumer, in real cash terms, as opposed to just reduction in the value of the item you've bought. I give an example. We have many energy efficient or materials that are said to be energy efficient, whether they are energy efficient or not, but at least the consumer's intention is to buy a material that is energy efficient to help curb emission. So sometimes, for me, my focus is how do I address the injustice that is being played by those who bring substandard material products in the market, and the innocent community members who are trying to embrace the national level efforts are coming to buy these products with the hope that their consumption will be energy efficient and will help the nation reduce that, national carbon emission. We don't have a registry for capturing these clients who are, spending a lot of money buying these products. So there's another, that aspect of injustice also, we need to look at it. So could also that, our national, litigation, could we also focus at how do we protect people who are actually genuinely coming to embrace newer systems, but are vulnerable to the scams by those who come and masquerade that they are actually providing genuine systems that will accrue them benefits. Eventually, these benefits don't come to the grassroots person. Maybe it comes to the company, and then the company will, convert the benefit into another form which is not cash in nature. And I think for us, when we don't focus at that, we will continue losing out. We will continue having very weak systems that don't recognize how much we are working so hard to reduce emissions, and then we will not be having a national database growing to show how much we have done to reduce this. Rather, it will be the few companies who actually align with those in the global capitals, and they get the credits and they get the payments, and that it doesn't trickle down to the local person. For me, I wanted to think about that injustice, and could that be an area where there could also be some litigation? So for me, that is the big question I wanted to ask, and whether it is very off-board, but at least it is something I thought it would be on the item. Thank you.
Thank you. Before Doctor comes in, I think Joy is supposed to attend to another session. Okay.
Thank you very much. I'll do 2 minutes or less. I didn't know Opito was reading my scrap book here. 2, 3 things. One is on data. We ask the question, we need more science, more data, more data. Sometimes it's not necessary. A lot of people here in this country prepare for heaven. I don't know whether somebody has asked for data for heaven and evidence, but everybody, we spend money, we spend time praying and hoping to go there, and people think they go there. Nobody asks for evidence, but on these things that actually we're suffering from, people keep asking for more data. Now, that's 1. 2, science. I think we're not going to go into the problem or the quagmire of defining science the way Uganda has defined science. Science is about the process. 2 people on the sides, on 2 sides of the court, can actually go together for the common good, and know that for us as a country, what the problem we're trying to solve is actually how to deal with the impact, the resilience, less about the emissions. We can ignore those, but more on the impact and how we help the small people, the woman in the village, the poor child in the village who is out of school maybe because of a climate change impact. How do we go together, even with very little evidence, even with little science, to help this person solve that problem? I think that should be our goal. Thank you very much.
Yes, I know there are so many questions, but because you're speaking justice here, I've seen justice even in the statements. As Joy comes in, what you're going to do, let Joy come in, Samantha comes in, then we unpack all that during our panel discussion. Because these conversations are going to come back, and all of us are going to engage. How about that? Because I know even for the lawyers, my colleagues there, you have quite a number of things to respond to. Yes, Joy, if you're still with us, please, if you could share with us your thoughts, and then your parting shots.
I was not able to get all the names, so I will be referring to you in the order by which you came in. I hope that's all right.
Joy.
Well, first of all,
Joy,
is yes.
I know you're closing. There is a burning question here, so that you bundle your responses at once. Yes.
Thank you, Joy. Just a brief question. I think maybe I'm Patrick from Makerere University, Patrick Musinguzi, but I just have a question in regard to your presentation. One, I think when you need to guide us as well here, because the issues of scientific consensus being in agreement in what we are presenting in most of these fora is becoming a key issue. I think you highlighted it in some of the presentation you made. I mean, agreeing towards a common scientific kind of, common point in argument or in litigation. How do you want us as a region here to handle such kind of cases? Secondly, you mentioned that actual attribution science is moving rapidly as well, and it's really a notable point. But I think maybe that is more of in the global north. I don't think in the south we are doing well in this, and I think you need to comment on this, on how we can also speed up with attribution science in the region, because at the end of the day, as members have already highlighted, the issue of data to really back up all these litigation measures is something we need to think about critically as a region. Then lastly, there are a few things I think which also you can comment on. In our region here, there are simple things that we are suffering with. For example, insurance. Most of our farmers are affected by many shocks, and there is insurance. There are these small things within our region that actually are not understood in terms of litigation. What is your experience in things that members have mentioned directly affecting the local person, but they are facing they are lacking that climate justice? At the local level, you could think of, what do you think we could handle? What can we do as a region to move towards that kind of direction, to bring climate justice to the local person somewhere? Thank you.
Joy, over to you.
Yes. So yes, as I mentioned earlier, I might go by chronology, aside from the few people at the end whose names I was able to get. But the first one, I really believe that there is a need to have conversations on climate litigation vis-a-vis geopolitics, right? Like that was a very, very salient point, particularly in countries, especially the US, for instance, where there is a lot of backlash as against scientists, climate workers, legal teams, etc. And that's reality at the moment, which is disappointing, but always something that has to underpin our work. I also like the statement of, all of these carbon removal, CCS, should not be a justification to continue polluting. Otherwise, we're just reinforcing the same inequalities that has gotten us here in the first place. For the second speaker, I really like the conversation of the temporal aspects of climate change. We always say to our to friends that we work with and NGOs that even if we stop all fossil fuel production at this very moment, the impacts of climate change will still be experienced by people moving forward, and that's just the lock-in effect. And so when we design our studies on attribution, those are things that we also have to keep in mind. And I guess this is also a point for the second intervention, is that it's really important for lawyers and scientists to talk to each other. However, we have to be quite clear about the limits of litigation and who is actually making the decisions. And so in here, I would like to say in quite a sober moment that interdisciplinarity in legal teams is so important. You need to have lawyers, scientists, anthropologists, even sociologists, data scientists, But there shouldn't be an expectation that courts are interdisciplinary. And that's why it has to come back to the conversation of what courts are able to answer and what kinds of questions lawyers are able to answer as well. And so at the end of the day, I feel like the bridging of this evidentiary gap is about really engaging ourselves and also like empowering ourselves to communicate with each other better. The third person, I agree, scientists have a responsibility to integrity. Climate cases are quite interesting in that it's almost the same issues that have been seen in cases before, such as tobacco control, which was mentioned by the intervener, as well as asbestos and mesothelioma cases. So there's a lot of things we can already work on. We're not on new grounds. We're not on like point zero again. We have so many things that we have know already, and we can still work towards. And on the topic of greenwashing, I just want to mention, for instance, this case of Notre Ferro 2 versus Total Energies, which was decided a few weeks ago, where the court said that Total Energies engaged in greenwashing, especially in their claims of climate neutrality by 2050. And that was a very important proclamation. In the similar vein, Netherlands, and this is not litigation but just legislation, Netherlands no longer allows fossil fuels to advertise fossil fuel advertisements. But I agree. The third intervener commenter said that perhaps there are more questions than answers. And I said this earlier as well. Maybe my goal here is not so much to provide you with answers, but to allow you to or to help you towards the asking of the questions that are most important. Number 4, I really like the reflection on how much evidence is required. Again, like judges, courts are non-specialists. We shouldn't be overburdening already burdened dockets with more evidence as is required for them. But then that means there has to be, again, conversations between lawyers and scientists to make that work. There was also a mention of, yes, defendants will also present their own evidence, and that's why plaintiffs will have to be ready for those as and when it happened. So in the case of Milieu Defensie, as I said, plaintiffs presented that that Shell should do a 45% reduction by 2030. The other side presented a similar study, but with much lower emissions reduction pathways. The thing about this is these scientists are working with models, right? And in the models, you input your variables, you come up with what happens. And so part of this is also saying, okay, judges, you have to be empowered to make those decisions. The science, it's not that there is no scientific consensus, it's that there is different ways by which there is a way to communicate that science, or depending on the variables that you put in the models, some things will come up differently, and that's something that has to be explained to a judge as well. I'm going towards the end now on the intervention of Apollo. Yes, I agree that foundational information needs to underpin the cases filed. And I always say this, I think I said this at the beginning, and I will say this again because I think it's really important, but climate justice is a systemic issue, right? Climate justice requires political, legal, institutional movements outside the courts, protests are all very relevant in the conversation on climate justice. And so litigation, even though it's going so well at the moment, I would say, or at least there's a lot more engagement with it, it's not a panacea. It's not a silver bullet. We have to work together using all of these other sectors that are available in order to move the needle forward. Another point to Apollo's intervention is that this is not just a data issue, right? And this is something more specific to the Global South. I'm a Filipino, so I understand the needs, but It's not just a data issue, it's an access issue. It's not just whether people have data, but whether they can actually access courts, whether courts are something that is expensive, whether they have all the lawyers and also legal knowledge that can then be able to bring into the courts of law. And so that's why I always say litigation is one part of it. Climate justice is a systemic issue. We need to work through all kind of directions to move the needle forward. And in the context of this conversation, this was probably also in relation to what James said. I just want to highlight that a few weeks ago, at the end of April, I was at Santa Marta for the first conference on transitioning away from fossil fuels. And I thought that was really, really important. Because for the first time, it gathered indigenous peoples, academia, faith workers, social workers, people of Afro descent, and all of like trade unions, laborers, etc. Not just about the science of a transition and by extension of loss and damage, but rather what does it look like in practice? Who do we talk to? Whose voices matter? Who do we put to the margins when we always focus on the mainstream conversations? How do we elevate and amplify the voices of those who need to be represented most, of those who need to be in these rooms, of those who need, by virtue of their lived reality, to speak up and take leadership in these processes? And so I really recommend those of you to read the outcomes of the transitioning away from fossil fuels agreement. I thought it was a really good first step of how it might look like when something comes from context and something comes from the global south perspective and from the perspective of communities. I also really agree with what James and Apollo said, that scientific integrity must not depend on donor ideology. Too often we've been bugged into these conversations. I have a book chapter in there that I wrote that should come out soon. But integrity is integrity, regardless of who is providing the money for it, right? And so scientists should work with integrity in the same manner that we should protect the integrity of scientists when they engage in courts. On the seventh question, until the last on data. This is really important. I agree. I mean, science is not neutral. It depends on how you use it. It depends on the people bringing forward the science. And so in parts of the story where there is a dearth of data, there is unavailability, there is difficulty in downscaling data, that's where narratives happen. That's where lived observations of people who are clamoring for climate justice, this is where they matter most. And that is going to be the role of scientists and lawyers. It's also the role of scientists to co-create knowledge production, knowledge sources with those on the ground, with those experiencing these contexts in a way that is not extractive to them. This is a need to strengthen collaboration. And finally, on the question of attribution science, I agree. Attribution science, it's much more so in the ambit of global north countries who have financial and technical capacities to do that. I argue that the precautionary principle is still very much a strong established discussion in a principle in international law that could be used complementarily when scientific data remains to be uncertain. One should be used with the other. And there are many other legal doctrines, such as those of human rights, such as constitutional law, that could come in as and when attribution might not be the most strong of the sciences or the most strong of the evidence to present. I really, really appreciate all of these conversations. I am very happy to answer and collaborate with people in the room in the future. I have sent in my email address to the group chat. Samantha also has my email address, so I'm very happy to keep working with you forward. But I guess I'm going to end with a vision of hope. we're seeing that there are many cases coming forward. Yesterday, we saw that the UN General Assembly operationalized the ICJ advisory opinion. And that is a strong message for hope. People everywhere, despite geopolitical shocks, despite backlash, despite threats and harassment, as I know that you know, as against environmental and land defenders. I am one of those. What I want is to see more cases, not just in Africa in general, but in East Africa and Uganda in particular. There you have been leaders in the tobacco conversation, and we imagine like it's time to rephrase the narrative, reframe the narrative. It's time to turn the table upside down. It's not about people in the global south being recipients simply of knowledge or being victims simply of a crisis that they did not create, but it's time for people of Africa, for people in Asia, for people in Latin America to take leadership in these conversations. And I know it's already happening, and I'm very, very excited for more of this to come. And I'm looking forward to see how Greenwatch and the rest of you will be part of that move towards climate justice. Thank you so much for having me, and I hope to see you all in other spaces.
Thank you, Joy. Still, I hope you hear the hand claps from the room. Yes. Now we struck a balance here because of the timing and try to redeem some. Samantha is coming through for considerable minutes. Then we shall get into lunch after her presentation, and then reconvene for the panel discussion. For whatever questions we've been having and comments, the panel discussion, I'm sure, is going to do justice for us, because we shall be having a conversation as a congregation here today. So Samantha, please, you will, after your presentation, usher us into the lunch. Yes.
All right. I was just making a comment on our team WhatsApp group that, wow, guys, we didn't expect so much to come out from the very first session. Not session, but the very first meeting of this kind. Maybe just to reiterate something. So I was saying in the beginning that Greenwatch litigates. In our litigation, and we are litigating on climate and climate change impacts. Currently in court, we have 3 ongoing cases. And in these 3 cases, we have had to interact with experts, scientific experts, science experts. And most of the time, the experts that we've engaged with have been from different jurisdictions. But at a certain time we said, no, we need our own experts. We would like that type of research to come out. We would like that type of contextualization to be what it is that we actually use for our cases. And really, this is where this conversation is coming from. So it's not we are thinking of cases to litigate, or it's a hypothetical thing, or whatever. No. This is actually Greenwatch's reality. That we need, David talked about a cohort, an association, a database, I don't know, speed dial of scientists in different fields, whether it's water, atmosphere, geographic, whatever it might be, because all these issues keep coming up in the cases that we are currently handling and those that we are thinking about handling in the future. Now, this is specific to litigation because it's what our organization does. That's what we are. That's what we do. Okay, if you are a cardiologist, the heart is what you do. It's not like you won't give a prescription for someone who's having a general medical problem. You might, you kind of have some information, but the heart is really what you specialize in. So for us, litigation is what we do. So if we are not, I don't know, diversifying into different areas and only probably focusing on litigation, because this is where our gap falls. But nonetheless, we have started the conversation on different aspects, whether it's geopolitical, whether it's data and how far the data can go and how much should be given, whether it's ethics, and all those things come as a result of this specific thing that we are doing. So back to my presentation, and I know I'm standing in between your lunch, but I'm sure that I'll be able to do it within time. So Joy really, her presentation brought out many of the things that I'm going to conclude with in my presentation, and I'm really speaking from experience with regards to the cases that we've handled and the experts that we've engaged and what we've seen. So, why climate cases need science? And I think Joy has really done justice on that, but I'll just follow my line of thought as I had done it in the presentation. Number one, for the facts, we've been talking about data from either the experts or the scientists' own research. It could be and monitoring programs, what you directly observed and measured. This is usually when the research is quite specific. The second role why scientists are needed in cases is to provide expert witness for the court, and maybe just to say that sometimes we may think that court processes are very complex and complicated, and I think Joy mentioned it. The simplicity of it is, what is the question that the court is asking? What is it? What do you have the, should I say, I don't want to use evidence. Do you have the data that points to the answer to the question? And can that be explained in a way that the court can clearly understand without obfuscating, without complications, without things like that? So I'm hoping that one of the things that will come out of this conversation is actually the simplicity of it. Expert witness. So these ones are really opinion-based on specialized knowledge, interpreting what the evidence means to a non-scientific judge. I hope that's clear. So that's one of the needs. Attributions specialist is really what we've been looking at in Joy's presentation, linking specific emission sources. And here we talk about emission sources, but it could be contextualized in whatever it is the case is actually the issue of the case. Linking specific emission sources to specific harm events with source traceable scientific methodology. And I think this is something we've also talked about, like Dr. Mboga was clearly stating the processes, the process has to be similar or has to be established. It's like an established process, so to speak. Hey, you know the good thing about lawyering, eh? Like sometimes you're in the medical field, other times you're in the engineering field. Now I'm beginning to understand the science and research. Sooner or later you might hear doctor. And also policy modeler, and this I think also has been talked about. I think it was Dr. Mbogo who also talked about policy making. That I don't know, I recall someone mentioning about, who talked about, yes, when you were talking about the tobacco laws and policies and things like that, the contribution of the science towards that. Yes, so policy, projecting future impacts under different regulatory, or I can't see the word, but I think it's science, to inform the court on foreseeability. So those four roles, so to speak, not limited to, but it's why climate cases need scientists for facts, for expert, for attribution, and as policy modelers. All right, so here's just a few, it might seem obvious, but I thought I would put it in the presentation. What you must know before testifying. What must you know before agreeing to become an expert witness? First of all, and Joy said it a lot, said your role is to assist the court, not to advocate for a side. You're neither on the side of the plaintiff or the defendant, yours, because they say that science is what? There's a term they use. Science doesn't lie. Yes, the science never lies. You will be cross-examined on methodology, we've talked about that. Data quality, Joy also talked about that. Uncertainty ranges in the event that they are aspects of your research or opinion that, you know, have some bit of uncertainty, to bring that so that that's clear. And potential biases as well. Like she was saying, maybe you wrote an article sometime back where you are disputing climate change, and now you are an expert talking about the reality of climate change. You need to bring that to the forefront, that whereas this other time, this is where I was, but now I have agreed and this is where I am. So what's the key difference from academic work? And later in our panel session, Prof. Byakagaba is going to be talking about the academic side, so I'm really looking forward to that conversation. So we see in science and in court, and just to prompt that discussion. So in the science, this is likely true. It's likely true. But in the courts, do you have reasonable scientific certainty? And that also goes to the standards, understanding that the jurisdictional standards of the court. And the preparation steps that I put there are understanding the legal standards. In Uganda, I was trying to verify with the legal team at Greenwatch. I said, what is our legal standard in Uganda? And, you know, them being just kind of a bit fresh from law school, said civil cases, balance of probability, criminal cases beyond reasonable doubt. So in your research or as you prepare for cases, understanding what the legal standard in that particular jurisdiction, because I believe as many of these cases come up, not just in Uganda, in East Africa, in Africa as a region, as we prepare for those opportunities, you will be making your research papers and opinions and things like that in different jurisdictions. So understanding what the legal standards in those jurisdictions is also quite important. Distinguishing facts from opinion testimony, what amounts to a fact, what is an opinion. I don't know if I have to belabor on that. I feel like being scientists is very obvious. Also writing reports in a non-scientist can follow. Now we've, in our experience, we've received scientific reports that you open and even you yourself, you say, you know what, I need to sleep at 9 so that I can wake up at like 4 a.m. if you're a morning person, so that I can read. When my mind is not clogged with so many things, so that I can understand and decode what exactly is this expert saying? And how can we be able to extract a witness statement from such a what? Such a report. So how can we be able to write such reports? As well as acknowledging limitations before opposing counsel exposes them, and I think Joy talked about that. Ensuring that if there are any loopholes or gaps or uncertainties, or just to expose those beforehand, because we do know that if the defense counsel, and I think here when I'm talking about plaintiff and I'm talking about the defendant, we understand. No. Do we? All right. So before those are exposed, because it's much better to bring those issues beforehand, before they are actually dug out. Then practice being cross-examined. And I'm sure my colleague Amos will talk more into that on the panel session. What is cross-examination? What should you expect? What does it entail? It's not a peer review experience at all. It's not coaching, because we are not allowed to coach the witness, but there is an art to which you can actually be trained to be aware of how opposite counsel will pose a question to you and how not to implicate yourself from statements that you've made before or paragraphs within the report. So just making a few pointers on what you should know as you're supporting cases. And this we talked about quite a bit during our conversation, and it was good that can was opened in terms of what are our duties as expert witnesses, ethics, okay, and things like that. The first one I had is, do not become an advocate. I think it has come out a lot. You're independent. The facts speak. The science doesn't lie. The facts speak for themselves. You're neither here for the plaintiff, neither you here for the defendant. You're here for science. And you're here to ensure that your findings can be used by the court to make a sound decision. As Greenwatch, we mostly litigate in the public interest for communities, for and on behalf of the common man. So we also expect that the collaborations and partners and support that we get from the different people that we work with has the same baseline. Do not omit contradictory data. In the event that data is contradictory, please bring it to the forefront so that it's clear and out of the way. Do not overstate certainty. I don't think I have to belabor on that. This small screen is, Do not attempt cases outside your expertise. Always, in the event that tobacco is not your thing, please pass it on to someone who's more specialized in that. And last but not the least, and I think it has come out a lot, is remain independent, objective, and unbiased, even when paid by one side. And I think Joy brought it out when she said that being, how can I say it, engaged by one side does not negate the justice for you who has actually done the work. Okay, so I just we shall talk more about if Greenwatch has engaged or supported your research. Should it necessarily be in Greenwatch's line? Like, those things. I thought it important to just highlight, the term that I wanted to use there is not career opportunities, no, but really just opportunities that are present. Like you've had, climate litigation cases are increasing. We have over 5,000 as per the 2026 report from the London School of Economics. Many cases are coming out in the global south, and with our globe being opened, it's not just limited to Africa. There is Asia, there is South America. So growing demands for trained experts in this area, climate litigation consultants, and David was hoping that this would be a beginning to something that will grow into something else. Okay, so that we can be able to continuously have these trainings, collaborate, partner, share opportunities, and not just for, how can I say, not just for our careers, so to speak, but also to support work, to support grassroots work. Because when we are in cases, when we're in court with multinational corporations and things like that, they have the best of the best. And sometimes organizations cannot afford the best of the best. Our resource pool does not allow us to. But what we have is collective effort, partnerships and collaborations. So in as much as they can pocket, we can also support, collaborate, and train so that we can be able to measure up. Expert witness training programs such as these ones and many others that are coming up. Many others that are coming up, of which details, once we form our cohort or something like that, we can always share. Court-appointed advisors. Who knows, maybe one day, one time, we'll have a specialized court for the environment, and the court would probably need advisors. So being able to prepare for that or position ourselves for that. There's also pro bono support for NGOs and climate litigation. Many of our scientists that we have engaged with have actually been pro bono. And for that, I really applaud, I applaud you, that you haven't made it difficult for us when we approach you. And so, thank you very much. Your experience can change policy without legislation, and I think we have an experience from that in the tobacco sector, which is such great work that's actually making a difference. All right, what to remember? Just a few things. Attribution science has turned climate data into legal actionable evidence. As Joy explained to us, there's several cases that have been going on. And I know that most of the litigation that she referred to was litigation in different jurisdictions in Europe, but there is litigation ongoing, but also some that has been concluded. If it's climate litigation, there's Kenya, the Save the Lamu case, there is South Africa, not so much in Uganda, but we are getting there. And I think the idea or maybe the thought process is that even as we know that the trajectory that's happening in other jurisdictions, eventually with time, we will also be able to get there. But learning from them, you know, because courts have come up and said, maybe I've thrown out scientific evidence for one reason or the other. And as that is happening, even as we are learning and knowing how to do it correctly, so we course correct and we learn how to present these reports and evidence better. Scientists are no longer peripheral, like we said in the beginning. Climate change is not something that, you know, we are still trying to figure out, but it's right here. So you're central to proving causation, damages, and foreseeability, just like what Dre was saying. And preparation is everything. So learning the rules of the courtroom before you testify, and being able to have legal teams that work together with scientists, because this is actually really what we are trying to achieve. That connection, that understanding, that making it easy, that if I call on Apollo tomorrow, it won't be, you know, where did you get my contacts, how did you come, but you would know that Samantha is with Greenwatch, she litigates on climate change cases. When she calls me, she probably is calling me for the work that, you know, the organization is doing, and it becomes easier, and you can always refer. I started to work with Professor Biakagawa a long time ago, but the number of referrals that he's appointed me to, because it's through him that I knew about Dr. Mboga and all the other scientists that we've reached out to in our course of work. So remember, it's not just litigation that we do, we also empower and we also advocate. So in different spaces, you find yourself needing to connect with whether it's the academia or scientists or things like that. So that also has been quite beneficial for us. So this is exactly what this is the first meeting of this kind that we have put together, and we know that it's not the first. So if there is anything amiss, anything that's not aligned, anything that's, we also just, you know, trying to create something that I believe is new together. And I do believe this is my last slide. Yes. So thank you for your attention. And I really don't know if there's any questions for this. I felt like, oh, okay. Mic runner. Okay.
Hello. So thanks for the discussion and guidance on how we respond to court processes. So I want to ask a question to all of us. I'm not asking for answers. How does a court respond in a case where the information or the evidence that needs to be presented needs to first be researched? You undertake a study to verify, to prove. How does a court, in that situation, how does court address or adjudicate, is that the right word? On a case whose evidence must only come out on the basis of a study. Let me give an example. We do work in the mining sector as Water Governance Institute. We monitor countrywide pollution from chemicals like mercury and the others. And so you have a case of somebody saying you have poisoned my water downstream. And as evidence, somebody has to go there, collect soil samples, water samples, take them to the lab, and verify for those pollution case claims. So now the case is in court. Does the court then commission say, okay, we are lacking this evidence. Can we conduct a study to verify whether that case, that problem actually exists? That's the context of my question. Thank you.
Mr. Msheja is going to answer that question in the plenary session. Yeah. Oh.
Yeah, actually I feel it is a discussion of the plenary, but the court...
Kindly introduce yourself.
Amos Msheja, an advocate of the High Court, specializing in litigation. So to maybe briefly touch on your question, but you shall expound more on that. The court or the case in court is purely determined on the paperwork that you submit before you get. So that's why they are saying that before you file the case, you sit with the legal counsel and then decide what kind of evidence do we need before we file. So that means by the time you go to court, you already have enough data, because court is not on remember there are two parties. There's one who has taken you to court and one has been taken to court. So the judge is simply receiving your evidence. So if that means by the time you go to court, you have sufficient data. So before we go to court, you come to me, say, okay, this is what I was poisoned. How are you poisoned? Then I say, let's engage an expert. We first investigate, collect the evidence. Now, the moment we are sure that we have the evidence sufficient to support the case, then we prepare the paperwork. Now, that means by the time we go to court, we already have enough data. We are not going for fishing. It's called the fishing expedition. Yes. So you are throwing something and you want court to help you find evidence for your case.
All right. Please. Should we? All right. Let's do it.
Maybe to just.
But he came before you. Let's give him a chance.
Yes. Sorry, colleagues.
Well. Is it
not particularly to his, but I'm trying to also. Yeah.
We have an example. I am from the Department of Civil Engineering. There's a lady that knocked her husband and killed her. That is the time of Kare Kaihura as the IGP. And so the police had to bring the gate lock for us to cut it and look at the quality of steel and reverse engineer and know whether that vehicle had enough capacity within that short distance to push the gate and bend the lock. So there are examples that exist, and then we had to make a report, and the case was heard, and colleagues had to go and testify. So it's established, science is working.
Okay, thank you. Yes, I think the idea here is really using laws, not only just to win, but to sift, in my understanding, maybe policies, behavior towards, climate science and yeah. Now, this, from what Joy has presented, there are elements to do that. One is establishing maybe possession and attribution. Just an example here could be, we know the glaciers on Rwenzori are melting. And if I want to sue, now how do I prove that actually, or the attribution is, which company do I point to? You see, we know it's happening. The second is, if you go to areas like Kabale, Kisoro, and others, we know that mosquitoes used not to be there. But now we know, because temperatures have been rising. The data from meteorology shows that actually the West, the temperatures in the West have risen fast and are higher than what they were. We have that data, you see. So if I want to sue, now who do I attribute it? And then also, from what Joy said, you need to define the standards, which means even that data to be used, maybe I have to have that data maybe be able to be compiled into the IPCC, and we have scientists here who can of course they send, how do we have that data framed into that? And then the third element is also, which she said, which is important, is how do we counter? You see, companies train, and companies use lawyers which can go and argue. In most of these climate conferences you have gone, they go there and they lobby, they advocate, and you see how vigorous they are. How do we counter such instances? Thank you.
Thank you very much, and that's exactly what we are trying to achieve.
Thank you so much. Thank you so much for wonderful presentation. I didn't get a chance to also respond to Joy, but it was also a wonderful presentation. Now, I know that Greenwatch, when I went to university, many of the cases we read were from Greenwatch, done by Greenwatch. And in fact, Greenwatch started us on a very high note when it comes to environment and climate change. For me, I'm not asking you a question because you are speaking clearly to what I feel should be done or ought to be done. And I started by thanking you for the presentation that you've made to us, highlighting some things that were even overlooking and bringing scientists in one room. I want to go back to my expectation, which I see coming out. is it possible that, because I know right now when it comes to environment litigation, it is not as free as it used to be with the Justice Kakulus, with Ntagova, with it's not as free as it used to be, and it is hurting many of us so much. So I want to suggest to you, now that you started it, is if we could have like thematic areas, and maybe we could say monthly, we can have online where we have these very beautiful and wonderful, handsome scientists who come and maybe present, such that, and then lawyers who also speak into spaces where we want. Because now we have oil. Some of us fought so hard that the oil is left in the ground, but political science, the political economy played in so much, even in court. So now we have to live with the reality that the oil is getting out, and the project affected people and areas will need us. But who are these scientists that are bringing out the very good science, public health, and related science? It is a very big now movement on climate change and public health. So I think what you're doing is already very good ahead of everyone. If we could have it periodically, if you have resources, it would be better that it goes even beyond that. But at least the starting point, I would suggest that maybe if we do not have a lot of resources, we can start with online. And then we continue having these conversations with these scientists, and then we build these cases. Someone talked about greenwashing. And this is a big thing. In some countries like, is it Brazil, Mexico, these big companies have even been given quotas of how they should use water. This means man, sometimes I feel like jumping through my... I for a very long time, I've been containing myself, but now I've started exploding. Let me stop. Thank you so much.
Thank you so much. Those are actually many of the things that we want to see brought to life, and this is just the beginning. So thank you for actually affirming. Most of the time when we talk with the team, we wonder whether what we are, gunning for is something that can be welcomed, but just you affirming that makes us realize that yes, it's actually something that is very much needed. Ladies and gentlemen, it's lunchtime, so allow us to stop right here. We'll have a plenary after lunch, and then Dr. Lwasa is going to be taking us through the last session, which will come at 3 p.m. And right now it's coming to 2, so let's kindly keep down. All right.
Ladies and gentlemen, it's time for us to have lunch. We are going to use Kazinga restaurant. It's at the basement, and I'm sure everyone has received a coupon. If you haven't, kindly reach out to me. Our seats are reserved next to the window section. Yes, the laptops can be kept here.
Yeah, thank you so much for the organizers for this invitation and opportunity to speak about the issue of scientific contributions to litigation. And of course, Greenwatch and everybody behind the scene, thank you so much for this opportunity. My name is Shoaib Nwasa, and I'm joining you online, based in The Hague. And I'd like to talk a couple of things about the issues to do with ethics and responsibilities. The great thing is that a good number of issues I wanted to touch on, or I'm going to touch on, have already been spoken about by Joy, but also the deeper conversations and discussions that every other contributor in the previous session has made. So in my presentation, I'll take you back to what I think of as the go-to place, which is IPCC for any credible high integrity science about climate change in general, and then what I think of as the key principles to guide our support to the litigation teams when they are litigating, and then the key things about the science is really about the confidence and uncertainty language, and also a little bit about the procedure for including scientific and gray literature. Now, I would like to mention on this slide that these are not the only guiding principles, but from my experience, indeed, these are really very important guiding principles for any individual, scientist or otherwise, or expert who is going to support the litigators in the courts of law to walk through the evidence that supports the cases that will be before the judge or judges in the court. Of course, a lot has been said about the objectivity of science, but that can be questionable. That's not the intention or topic of discussion. The integrity of science, but also the integrity of the scientist. Again, a lot of issues have been raised. How scientists can gift doubt to the individuals, companies, cartels, and groups to spur their narratives or propaganda, and the importance of independence as a scientist, but also the independence of the available evidence from the scientific literature, I think also has to be recognized and respected. Sometimes you also have to deal with confidentiality, and that speaks at different scales, from the granular level to even global scales. For example, it's not really confidentiality, it's open confidentiality, if you will, where in many of the negotiations in the United Nations Framework for Climate Change Convention, they dropped words like developing and developing countries. So they talk about regions. In some ways, it's a sort of open confidentiality, but the concerns of the developing or the countries in the low and middle income brackets was very much hard about that. But there are so many examples that you can bring up when it comes to confidentiality. Conflict of interest, yes, there's been some discussions about who funds the research, who is funding IPCC, and how neutral, for example, is IPCC, or who is funding, or whose narrative is the research agenda that is drawn from elsewhere for a good number of us to do in the global south or the low and middle income countries. There are so many ways in which actually conflicts of interest can arise. But as an expert or scientist in the litigation, I think upfront declaration of that is important. And again, I think in the summary before the lunch break, it was also very clear about how that can be done. Transparency speaks again to so many things, but the one that I would like to highlight is that in as much as the science assessment looks mainly at the evidence available, and I'll dive a little bit deep into that later, it's also important to be representative, such that you do not overrepresent one side of the narrative, because even science and scientists themselves have multiple opinions, which are, of course, usually evidence-driven. It's not just personal opinions. So they draw conclusions from what they have been able to crunch or analyze, and that can create different scenarios. So being transparent about all possible scenarios, you can think of them as sides. It's not just two sides of the coin, perhaps it's multiple sides of the prism, this is very important as a key guiding principle. And in order to exercise or put in practice these principles, then as an expert in science, you have really to rely on a very well-balanced, representative, and holistic assessment of all available literature at point in time. And we need to underline this as we go forward here, the last part, because it's so important and it's going to come up in a couple of other slides that I'll bring up. Now, if I could step back a little bit on the IPCC in general, the IPCC stands for Intergovernmental Panel on Climate Change. It was created by the two World Programs on Environment, or UNEP, United Nations Environment Program, and the World Meteorological Organization, to really underscore or conduct assessments on the evidence that had emerged even like 80, 90 years ago, as someone indicated when he went through the very interesting history of when and who identified climate change. By then, you can say that during those years it was a postulation, but over the years it was increasingly becoming evident that actually there's something going on in the planetary system about the climate that needs to be assessed. But then, because there is no program that is coherent at planetary level, then the assessment of all existing science in all different disciplines, and we shall later see that actually that has expanded even beyond the traditional science disciplines to humanities as well. Some people have alluded to traditional, indigenous, and local knowledge. That's a relatively new area that has been incorporated into the assessment. So all available literature should be assessed on the state of what is happening in terms of climate change, issues to do with the vulnerabilities, adaptation, impacts, but also mitigation, the consequences of them, the possibly latest development out of negotiations, but also evidence in the scientific literature is the loss and damage, and whose loss. Again, the conversation around attribution becomes very important. But it is not just about the problematics or the impacts. Assessments also do cover how to avoid increasing global warming, which drives climate change, but also how to prepare for possibilities of different scenarios of when the climate changes. And that also lands in the space of policy, regulation, legal and regulatory engagements. Cooperations and partnerships are also part of the assessment, as you'll notice in the IPCC. So all governments, about 196, signed up for this, and then they created a scientific body called IPCC. So this is the setup. WMO and UNEP use the IPCC plenary mainly by the delegates from the governments, the secretariat at WMO, and then the bureau. This bureau keeps changing. Of course, the secretariat also changes. So recently there was an advertisement for the head of the secretariat. And then the IPCC is organized in 3 working groups and task forces, one of which has sort of remained permanent is the Task Force on National Greenhouse Gas Inventory. So working group 1 basically focuses on physical science basis, working group 2, climate change impacts, adaptation and vulnerability, and then working group 3 is on mitigation of climate change. So this already speaks volumes in terms of the kind of assessments that go on, but also the amounts of literature that are assessed, and therefore the heftiness of the reports. And underneath these working groups, periodically for every cycle, authors are nominated by the governments. They are also contributing authors, but also reviewers. So the latest of the scientific reports that was published is the assessment report number 6. And I'm not sure whether you see this. So this is the volume of working group 3. So for those of you who have been talking about data and evidence, this is where they go to place. So you can imagine how much time you can take to, dig through these volumes. And this is just working group 3, which is on mitigation. Working group 2, I think, if I'm not mistaken, had about 3 volumes. And working group 1, physical science basis, also had 2 volumes. In addition to these big volumes where the traceability of the underlying science, we also do, because I'm part of also the 7th cycle, we just kicked up with the special report on cities. We do what we call the summary for policymakers, and that is what is approved. And the summary for policymakers is usually headline statements that cover all the different aspects as approved in the outline by the governments. and then with traceability of the sections in these big volumes of working group 1, 2, and 3. And then that summary for policymakers is the one that is approved. And in addition to the summary for policymakers, there's also production of what we call a technical summary. That is where you have all the detailed data analysis, synthesis, schematization, and different figures that perhaps some of you are familiar with and have seen, which underline the headlines in the summary for policymakers. And then after the 3 groups, because they usually start at different points in time, perhaps a space of 6 to 8 months in between, once the last group, which is 3, finally gets its approval of the summary for policymakers, then the technical support unit, or the TSU, together with authors and the co-chairs of IPCC, produce what we call a synthesis report. And that is what threads all the 3 group reports from working group 1 to working group 3. So I thought that was also very important. So as we think about and discuss the role of scientists in litigation, we also have to remind ourselves that the governments have key roles to play in this process. Usually it's the government that requests the scientific body or community to conduct the comprehensive assessments. And the governments also do elect the bureau, and there are rules and procedures for that. And the governments also request the bureau, which bureau then conducts what they call expert meetings to really draw up a strawman or draft outline of each of the agreed report. One thing that I've not mentioned, although I did so in passing, apart from the mainstream reports of working group 1 to 3, summary for policymakers, and then technical summary and the synthesis report, the governments can also agree, and they agreed so many years ago, to produce what they call special reports. So in 2017, 2018, there were 2 special reports, one on the cryosphere, so for those who are interested in water, there was one on land and climate change. And in the seventh cycle of IPCC assessment, we have this special report on cities. And that one is ongoing, and the publication or the approval is expected sometime late February or early March 2027. Meanwhile, the main report cycle has kicked in, and working group 2, for example, and working group 1 have already had their second lead author meetings. And I think the second lead author meeting for working group 2 is actually ongoing right now in Nassau, in Bahamas. So the bureau then receives nominations from the government. There's always a focal person within the government. In Uganda, it is within the Ministry of Water and Environment. Some of you are familiar with this person and the process itself. Then nominations are sent in, of course, with evidence of credibility of being a scientist and publications and experience to assess, as I'll be mentioning later, and expertise. There is also a balancing of geography, expertise, gender, and the most recent one is also the issue of indigenous knowledge. So in the special report for cities, there are actually scientists who self-identify as indigenous peoples, and the idea is to capture as much of the lived experiences that in the definitions I've had in that conversation and discussion doesn't fit your definitions of science or the quagmires mentioned by Mike of how government of Uganda has defined science. But in the global community, that definition is very fluid. And I implore that you actually step back from the contextualized definitions to a much more broader global so that you can plug into this knowledge, because the IPCC, in my opinion, is the first go-to for the evidence that you need to take into the litigation process. Governments also participate in the review. So again, as I mentioned, the special report on cities, starting last week up to early second week of June, I think, the governments have been invited to actually review the second order draft of that special report. So should you be interested and you want to acclimatize with the process and how literature is assessed, but also get to know what evidence there is, because all these reports are progressive. So every report is based on new scientific evidence, not even all scientific. So the 7th cycle assessment is based on literature since 2022 after the approval of AR6 up to until now. So it's progressive rather than, getting stuck into the histories of all those. And governments also then eventually make the decision once the review is done, the second order draft is done. And that is where, after that, then there will be the final draft and then the summary for policymakers for approval in February, March next year, which will be done for that special report. So in IPCC, therefore, there is no conduct of new research. And IPCC does also not monitor trends of climate change or impacts of vulnerabilities or emission trends and mitigation opportunities that are going on. No, it does not do so. However, the scientists can actually find a gap that is so critical for the assessment. And if there's already ongoing research, which is why we have internal deadlines in the process, for when the cutoff dates, when the literature to be included in the assessment will be, and in this case for the special report, the cutoff date is October 2026. So any new literature on cities and urban areas and territories and how they're responding to climate change or impacts of vulnerabilities or loss and damage can only be accepted up until October 2026 published. So the acceptance and submission to journals was March, so it's passed, but the publication is October. So if that paper is not published, then it's not included in the assessment. So it does not, in IPCC, there's no conducting of comprehensive assessment of published. Rather, it does conduct comprehensive assessment of published, and to some extent, grey literature. I added in the grey literature here because grey literature is not necessarily peer reviewed. Some of it is peer reviewed, but a good number of that material is not peer reviewed. So in the special report, grey literature can be included. Even in the mainstream cycles, working group 1 to 3, grey literature can be included, but it is usually tagged and flagged that it's grey literature. Again, it must respond to a critical knowledge gap that particular piece brings into the whole picture or the puzzle. But IPCC does provide statements that should be policy relevant and policy neutral and not policy prescriptive. So in the assessments, you will notice the scientists, the reports do not state that governments should do this or governments ought to do that, but rather offer option to say that the governments or entities or corporates or whatever, now in the special report, all that has been included, although the target of the assessments is usually the government. They are advised that there are these number of options and these are the things and ingredients you use, and this is where you might land. So towards the end of this talk, I'll talk about scenarios and what they mean in being credible, unbiased, but also objective when you're supporting the litigation process. So the review is very important and an essential part of the IPCC process to ensure the objectivity, but also comprehensiveness. But there's also need to recognize that there are usually quite a number of differing viewpoints that exist within the scientific community, and those usually are actually reflected in the IPCC reports, all of them. So in maintaining those guiding principles, then it should be an assessment, but not a review. And since a good number of you are academics, you can tell the difference between review and assessment. Assessments use confidence language and evidence, low, medium, high, and confidence. I'll give some example here. For example, this is coming from AR5. Projected trends in climate change related exposure to human health will increase malnutrition, consequencing disorders, including those related to child growth and development. The evidence is robust, not this word here or this in italics. The evidence is robust with high confidence. So it means you have assessed a good number of publications that point to the direction that the changes and exposure of human beings and general human health to climate change are high, and they are already driving increased malnutrition, and that is already connected or linked to how it affects child growth and development. So the evidence is robust and with high confidence. So that's an assessment, it's not a review. So when you're litigating or when you're building the evidence base as part of the the bundles that Amos is going to talk about, but he highlighted earlier when he was responding to the question that goes to the courts. You should not leave out this, confidence language, because it's the language of assessment. And the moment you leave it out, the meaning and possible interpretations could be multiple. And that could throw the whole litigation process and, of course, the cross-examination into very problematic spaces that you don't want to. So what is this uncertainty language? Again, I think Samantha did mention a lot about uncertainty. It is important for communication, but it's also important to communicate the fact that actually science is complex. A good number of you have talked about proof, but rather than proof, I think it is evidence. Rather than proving that something exists, it is evidence. Otherwise, we wouldn't be talking about assessment number 7, because assessment number 2 is where the fingerprints, is when the science was very clear that over 90, 100 years, the fingerprints of the fossil fuels and energy used to anthropogenic warming were discernible, therefore clearly marked, of course not 100%, with a certain level of uncertainty and confidence language. And then AR3, AR4, AR5, all of them have been building on that. And you may have heard about the different generations of global circulation models, but also the different generations of scientific scenarios, which I'll touch on a little bit here. And you don't have to worry about the complication of the language. The SPM simplifies that, and then the context supports the SPM statements. So uncertain language should be very well calibrated. It should be open to scrutiny, and it should also support risk management and decision making, because the assessments are meant for government. The governments are the ones that request, and the expectation is that the government should also take action on that. There are 2 metrics for the degree of certainty, qualitative and quantitative. I've heard a lot of people talking about data and the assumption that if you crunch and hypothesize and then you develop the methodology of tools and reproducibility of the data, then that is science. Well, in IPCC, it's not just about the numbers, it's also about the qualitative, and that matters a lot. Some of you have raised that as narratives. You can build a narrative out of qualitative and lived experiences. So this is very much relevant in the policy space as well. And it depends on the multiplicity or the distance of the different authors, but also, most importantly, the underlying scientific evidence. It's not just about the authors, but what is the underlying scientific evidence? Again, going back to the guiding principle, it has to be reliable, broad enough, representative, and holistic. It's not just about a few papers. You really have to bring up all the evidence that you need that is available. And then the degree of certainty will always vary among the findings based on the state of the associated scientific literature. And you need to communicate this very, very, very clearly. Otherwise, that might actually, like I said earlier, create inconsistencies in the process of litigation when you are participating in that process. So the confidence language is a qualitative evaluation. You have to understand what is going on. Therefore, you have to be really not just an expert, but somebody who is up to speed and update in many ways on the discourse on climate change. I'm not criticizing, but what I heard a little bit in the conversations, what some people are still perhaps so many years ago, and then the science of climate change has progressed. You need to acclimatize and catch up. You also have to have different strands of evidence. Not again, representativeness is very clear. And you also have to ask yourself, is the evidence consistent or is it conflicting? So be aware, it will always be conflicting. Some of it will be consistent. And that's where the confidence language becomes very critical. Do I have many or only a few studies? So if you have a few studies, like 1 or 2, however robust it is, because it's 1 or 2, and that has not tested the reproducibility, then you can hardly say robust evidence and high confidence. Usually that would be low confidence. Why? Because there's only 1 or 2 studies or 3 studies. So, but there could be some studies which are really groundbreaking. I think one of those that I can think of head is the study on the planetary boundaries and the different envelopes. So if you're familiar with that, nitrogen, water, hydrosphere, and all that kind of stuff, and the carbon, of course, and how these are closing in. and how now the tipping points are starting to. So it's a really very robust study because it's at planetary level. And that's where perhaps the challenge in litigation in the case of Uganda becomes even much more complicated, because climate change as a process in the system doesn't really map on squarely to a specific small spatial scale context. So you cannot say that in Mwende or in Soroti when it rained, then the flooding was caused by climate change. Starting from there is very, very problematic and uncertain, but also difficult. But starting from the planetary system, because what brings the moisture to land in Soroti happens somewhere in the Indian Ocean, and whatever happens in terms of interactions and whatever that goes on, the energy and the speed and how much is deposited, all that is not very much context specific in Soroti, but it's coming from elsewhere. So it's really, really difficult and complicated to start from Soroti and say this is climate change, but rather you have to start from the global and regional scale in order to then use the contextual knowledge and information to say, okay, this seems to support that. Again, hear my word, this seems to support that there is change and impacts happening. In the uncertainty language, we also employ probability and likelihood. And this is the basis for, or as a precondition for quantifying likelihood. And in this figure summarizes what I would say perhaps in so many minutes. You have the evidence, does the evidence agree, the scale, and then rather the evidence is on the X, and then the agreement level. So the evidence is based on the type, the amount, quality, and consistency. And then the agreement levels is now the assessment that we bring to it, that if there is low agreement in the literature based on limited evidence, then it falls in this box. But if there is high agreement and robust evidence, then it falls in the last corner. And then you can distribute the quantification across these metrics, depending on, again, the type, amount, quality, and consistency, and the papers that you have included in that assessment on that particular topic. So where there's a lot of literature from multiple lines of evidence, we can also evaluate the agreement. We should also state the confidence in the conclusion as well. And therefore, the calibration of the uncertainty and confidence language is that you can have very high confidence, medium confidence, low confidence, and very low confidence. And some examples here. I pulled this, I think, from AR5 again. The first one on top here is in baseline scenarios, again, the greenhouse gas emissions are projected to grow in all sectors, except for net CO2 emissions in AFLU. AFLU stands for Agriculture, Forestry, and Land Use Sector. The evidence is robust, and there is medium agreement. So you can imagine there's a lot of literature on this. Of course, a lot of people are studying for deforestation and land use change and all that with all the models, but still there's medium agreement. Why? Because it's about net CO2 emissions, because that sector is very tricky. It's not just about felling a tree and the decomposition or the transformation into wood or whatever, or the fermentation or whatever. It's also about, okay, how much of that actually gets back into the system as carbon. And therefore that net, the difference, becomes very critical as an example. So again, this really illustrates the complexity, but also the multiple point of views of different scientists working in different disciplines, perhaps on the same thing, or well, similar thing, not the same thing, and coming up with slightly different or differing opinions with their results. And then the second example is in region X, there is limited evidence, but high agreement that the rich biota of the alpine zone is at risk through increasing shrubby growth and loss of herbs. Again, you can integrate your confidence language into the statement or bring it at the end. And I pull this also from that AR5. And then the third example is extreme heat events currently result in increases in mortality and morbidity with very high confidence, with impacts that vary by age, location, socioeconomic factors. Now, for those of you who really, sort of were debunking the importance of contextuality of scientific evidence, this last one just tells you that you can not only start from the context. You need to start from somewhere else, which is you have to think and work at multiple scales. The scalarity of the evidence maybe starts from the global level, because as I mentioned earlier with that example, the rains that come down in Uganda don't actually all necessarily from in Uganda or Lake Victoria. Majority of them perhaps come in the long range, which are just stopping right now, come from Indian, and then in the short range, perhaps a proportion of it even comes from the Atlantic, as we know it from the meteorology and geography. So quantifying uncertainty requires us to assess the amount and consistency, as I mentioned earlier. And the addition here is that the way you have sufficient confidence and the data allows it, you may want to quantify uncertainty using likelihood terms as well. And those likelihood terms are here again. So this is the sort of adding of the sort of the scale from 0 to 100%. So if it is 0 to 1, then probability, then exceptional and unlikely. But if it is 99 to 100, that is virtually certain. So I haven't seen in any report that actually uses the likelihood language of virtually certain. Most of them land in very likely or likely, unlikely, and a few of the assessments I've also mentioned very unlikely. For example, the assessment of the very emerging, relatively younger technology or geoengineering, there are not many papers, but a few of those that have been assessed, at least by colleagues, don't seem to be, landing well with evidence and robustness. So it's very unlikely that actually geoengineering could actually have an impact at the scale and rate to which response is needed to keep the global warming on the basis of the political goal of keeping it under 2 degrees actually can be achieved. So again, some examples. Very likely that the time mean rate of global mean sea level rise in the 21st century will exceed the rate observed during 1971-2010, and this is in agreement with all the representative consideration pathway scenarios. That is the meaning of RCP. I'll highlight a little bit of that in a few minutes down the road. And then since 1950, the number of heavy precipitation events over land has likely increased in more regions than it has decreased. And the third example is increasing temperatures and changes in precipitation are very likely to reduce cereal crop productivity with strong adverse effects on food security. Again, this is really the examples of how you can state the confidence language with the likelihood aspect. In the assessment, what we try to avoid is to not be unclear or to be vague or ambiguous, very ambiguous. Already the use of likelihood and uncertainty language can be ambiguous, but perhaps a little bit more clearer, and creates consistency and communicability. But you avoid to be vague. So this first statement, which I'm not going to read, although it ends with a confidence language that is high, in between here it talks about trajectories that are at least about as likely as not to. So this is very confusing. So you cannot that statement cannot be approved in the plenary of the SPM if this is a headline statement. They will just throw it out. At best, they can tell you, okay, go in a huddle and then discuss it, revise it. But then the key challenge is that what is the underlying science that led you to this assessment? And if that underlying science is not evidentially linkable to this, then the whole headline statement can be withdrawn from the SPM. So again, I pick another one in the most recent AR6 Working Group 2, Chapter 6, evidence from urban and rural settlements in unequivocal. The unequivocality of climate change fingerprints, as I mentioned earlier, I think that word was first used, if I'm not mistaken, in AR3, and then it became sort of with a high confidence level in AR4. Climate impacts are felt disproportionately. Again, cities and different urban areas are exposed to different amounts of risks to climate change impacts, and therefore you will only do the assessment. You can only zoom in one and then say this is representative of everything. So with the most economically and socially marginalized being most affected, high confidence. So again, that's a good example of a statement that is communicable and consistent, but also clear. And then underneath this statement, then traceability with section numbers. If you have quantifications of who are marginalized, how many, in what geographies, what are the economic losses, what sort of communities. Of course, I don't want to start mentioning people living in slums and people living in a former settlement, but also there are other, organically developed settlements around the peri-urban zones that seem to be, well-to-do, but not planned and therefore have high exposure. So it's not just about slum areas. So it has to be representative, and the underlying evidence then supports this particular statement. So, as I come to a close to the close, I also want to raise one thing that is also most likely, I don't know, I don't have the answer, but I foresee that this is problematic in the courts of law when you're going through a litigation process. That is risk, because risk itself also has a lot of uncertainty. Because it combines potential for adverse consequences, uncertainty. And risk is different from a hazard, and hazard is also different from a disaster. But risk is the basis for the hazard landing somewhere and then creating a disaster. So that probability or susceptibility, that the likelihood that you're going to be affected in an adverse way with such describable consequences is what is risk. Now, in litigation, I'm not sure how this could land, because it could create a lot of gray areas and a lot of complications, because the evidence would be needed about the potential. The good thing about climate-related risk is that the evidence is very much already laden into or lying under the confidence and uncertainty language. So you bring that actually this is the likelihood that this risk is likely to increase or happen already. And this is the evidence that actually in these papers that shows that it's happened. So risk can be complicated, and it has to be evaluated in different ways. So the last two bullets are not relevant for this conversation, but at least what is important for us to communicate, and for me to communicate to you, is that when you are being an expert in the courts of law, you should also be able to transparently and upfront communicate where the evidence on a particular piece of litigation evidence also embeds risk, because it also creates a different layer of uncertainty. I promised that I would also highlight a little bit about the pathways, because the assessment is not just about the impacts and vulnerability, but also where are we likely to land, or how should we avoid, or how should we navigate and land somewhere. So, and the figure here summarizes what we call the shared socioeconomic pathways. There are 5 of them. 1 is the most green, 2 is in the middle, and 3 is regional rivalry. So whatever is going on now in the African continent, and they're based on the geopolitical polarization. So the nationalism and emerging, whatever sovereignty and things like that are creating a little bit of regional rivalry. So should you stay within your docket, within your boundaries? I'm not sure, because there are certain things that go beyond the boundaries, just like climate change. So that is, if this continues, then we will most likely land in scenario number 3. And 4 is if you increased and persistent inequality happens, then that actually could be a really very divided road. 3 is a rocky road, and 5 is taking the highway. So the highway is basically just get all the oil that you can discover across the world, whether it's offshore or onshore or in the mountains or under the ice in the Arctic and the Antarctic or under the sand, and just burn it and just develop, and then things will fix themselves later. So in this table, you see the different generations. On the left here is the different, the older generation of scenarios, A1, F1, B2, B1. And here on this left side, you see the representative concentration pathways. So, RCP 2.6 is SSP2, rated SSP2, 4, and then 6 and 8.5. Now, why do I bring up this picture? If you have been following the politics in the United States and the justification, the continued narrative to justify why United States is pulled out of the Climate Change Convention, they have focused on RCP 8, and they have, again, which I think we're trying to hypothesize is perhaps author gift or science gifting or compromising of scientists. They have crunched numbers on one scenario, and then the narrative in the social media and the publications on the media is that, well, we're not going to warm up to 8.5 degrees, but they're not communicating the other scenarios. That's where the objectivity of science actually stems from, because there are different ways and different possibilities of how the system works. The models are calibrated differently, and they produce different possibilities in the future. So it's not just about 8.5. It could also be 4. It could be 4.5. It could also 6. But if you have read Nassim's book of the Black Swan, you could also get an RCP that is completely outside these current RCPs, which could be 10 or even 11. Who knows that? So again, as science, you can never prove anything. until you find the evidence. So at the moment, the hypothesis or conclusion is that all swans are white, but Nassim reminds us that actually that over-obsession of randomization and the control trials might actually make us miss the fact that there could be a black swan at some point on this planet. So I circle back as I conclude, just have to be objective, exercise a high degree of integrity, be independent where needed and possible. Confidentiality is a key principle. Declare conflict of interest, but sometimes even if you declare, you can still give an opinion if you are cross-examined, I guess. I'm not a little bit about that. And then also being transparent, just use all the evidence available. So on this transparency thing, you can start from the IPCC headline statements and then use the data and evidence from the contextual level. So there's so many micro studies, case studies in Uganda, for example, on different things, deforestation, urban flooding, heat. Heat is becoming a new issue as well. In the last February, I think almost 8 days above average of the normal in that month. So it was never declared a heat wave, but international definitions of heat wave or scientific definition of heat waves, actually that would be a heat wave. So being able to be transparent around that is very important, and remaining balanced and holistic is also very critical. And I would like to just throw in this just for fun and see whether there's something wrong with that map. And thank you very much for listening to me. Back to you.
Thank you, Prof. Would just like to, within a few minutes, maybe 5, the impression of Prof. C's presentation before we move to our panel discussion, which I've decided to term as a fireplace, a choto. We are going to talk and talk until we feel at least we've done justice to the conversation. Yes, so, yes, please.
Thank you, Prof, for the presentation. I just want some clarity. I think you really emphasized on the kind of quality data and how you emerge to have some bit of confidence in the kind of data you discuss in IPCC. But I had one major concern. How do you really consider the imbalance? I mean, when you are sitting on the panel, I expect you that probably you have a very good team of scientists, maybe at global level, and I'm assuming that in that team there is a balanced representation. In other words, if we are from East Africa, how balanced are we on that panel? And those even who are there on the panel, are they the right people who are supposed to sit on those panels? I mean, I'm concerned about, because at the end of the day, I think in this agreement kind of assessments to agree and disagree and have a common way forward, I think if you have an imbalanced team, you may struggle to argue out a point. How have you handled such a case? I think that's my main concern. Thank you.
Yeah. Yes, my name is Isaiah, and thank you very much for the presentation, Prof. I have one or two questions. One is, given that these studies are really designed for different objectives and by different people, how do you harmonize the objectivities of these studies? It could have been sponsored by companies and other groups for different things, yet you review existing data and you don't have your independent studies, and you kind of organize that to fit the objectives of the IPCC. 2, how do you define your confidence levels in the IPCC reports to know? I imagine they're different. 3 is in the presentations, the morning, and was that the companies actually use uncertainties and also trying to say some of this may not be really, they are biased reports and things like that. And yet, even I think the IPCC, according to you, you use confidence levels, and these are probabilistic. There are uncertainties, and again, yet the standards they say is that they maybe IPCC reports need to be used for maybe litigation. Yet, courts would prefer that you should be able to attribute the cause to the event. And that should not be probabilistic. It should be really something which is certain. So how do we improve the IPCC reports so that they can be used for litigation? Thank you.
Is there any other? Oh.
Also, Prof, thank you for your presentation. In different spaces, we've been getting information that least developed countries, and we're looking at Africa and maybe other islands in other continents. So we are being deceived. I don't know if it is true that we don't have enough scientific data to sometimes contribute toward IPCC reporting. Is that the case, or it's just somewhat they want to always limit us in some of those decision making? Thank you, and over.
Prof, over to you.
Yeah, thank you so much for those wonderful questions. In the same order, quality of data, but also imbalances in IPCC and the argumentation that unfolds. My response is that actually that question should be going to the focal persons and of IPCC in each country, but also to the Bureau and the technical support unit. As an author, I'm not part of the TSU, neither am I part of the focal person in Ministry of Water, neither am I part of the Bureau. I'm supposed to be an independent author or scientist contributing to the assessment. But indeed, inherently, your question also underscores one of the long-standing challenges within IPCC in terms of representation of scientists from across the different regions. And indeed, there's always been a backlog or over-representation of some regions. Starting AR5, there's been a deliberate move by the co-chairs and the Bureau to ensure that there is at least balanced by gender, but also balanced by geography and balanced by expertise, which actually complicates their life, but that's their life and that is not my life. So inside the assessment, there are also some challenges about the opinion, the different evidence and how vocal some scientists can be. So you can only imagine when it comes to scientists from the North America and Europe, they tend to be a lot more vocal than the scientists from elsewhere, and they sort of dominate the discussions and the narratives within the reports. But some people are in different regions are not there as gap fillers. So there's a lot of pushback that is emerging. And the co-chairs, especially from the co-chair for Working Group 2, is from Tanzania, Ladislaus. So they try to defend. They also there are another co-chairs from Cuba, Working Group 3. They try to make sure that all these voices are actually balanced. So that question should be well answered by the Bureau and the TSU and not me, of how the balancing goes there. Isaiah, so many questions, but thank you actually. They're really very great questions to take this conversation forward. My first response to your question about the different objectives, studies of different objectives, as I mentioned in one of the slides, IPCC does not do research. However, it assesses existing research, which you acknowledge that it is designed for different objectives. However, the target here for IPCC is any literature that has been published and has gone through the peer review process, which we trust, all scientists at least with not 100% probability, but maybe maybe 80% that we will trust the peer review process. Some of you have participated in the peer review process of journal articles. Because you trust that, then you target what that particular piece of paper or number of papers talk about or say in respect to either impacts or vulnerabilities or adaptation, or the global warming, anthropogenic warming, the descending of anthropogenic warming and natural warming and variability. There are the multitude of topics. Climate change is amorphous. It's a very broad, composite notion that you not only study by focusing on carbon in the atmosphere, but you also have to understand the fluxes and the dynamics of our energy and the importance of carbon both underneath, below ground, in the atmosphere, and perhaps even beyond. And on the other side of the scale, you also have, okay, what is driving the anthropogenic warming? If it is to do with fossil fuels because of high carbon intensity, then how can those be mitigated? Again, within the IPCC, there is a specific definition about mitigation. So you look at all papers that are talking about use and burning of fossil fuels, whether it's in different sectors, energy, industry, transportation, maritime, wherever, or I follow the example I gave of agriculture, forestry, land use sector. The reports go in detail in each of this sector. And this response also relates to the last question of the scientific data in the Global Sound. If you go into Working Group 2, please go to ipcc.ch or something like that. You will see that there are 3 reports, Working Group 1, 2, and 3. And in Working Group 1, there are regional chapters. In Working Group 2, there are also regional chapters, but at the same time, there are sectoral chapters, including AFLU, industry, human settlements, urban areas, agriculture, which is AFLU, buildings, transportation, maritime, energy. Each of that chapter assesses the data, not the data, but the literature in that particular subsector of energy or industry. So there are multitudes of papers from different journals that are focused on that, energy, combustion in industry, or industrial symbiosis, or whatever you can mention it. So, Isaiah, we don't do research, but we assess available research. And therefore, the target is not the objective of that research, but what topic relates to any of the subtopics in the approved outline of Working Group 1, 2, and 3. And that's where, as an expert to support litigation, you should go as the first point, because that's where you get the headline statements on the basis of which you can then use contextualized evidence to say that the likelihood of the floods in Soroti might have actually been driven with this level of probability by climate change, because the IPCC report says ABCD. Of course, we know that there's also misinformation. So how do you define confidence levels? The slide that I showed you of the different levels, very high, medium, low, and very low, is how we do that. And of course, the quantification is 0, 1, and then the top is 99, 100. Again, that is subjective in many ways. But the beauty about science and this process is that it's transparently developed by scientists, not an individual like me. This has been discussed over the different cycles. We are now in the 7th cycle of IPCC, and there's agreement that actually this is something that is communicable. It offers consistency to the policymakers, the governments that actually do request for the scientific assessment, and it is easy to understand. I believe that we don't have to get stuck into the definitions, but use what is already developed by IPCC and add the contextual evidence, use that confidence language, and then be supportive of the litigation process. If you agree with me, then we don't have to dive deep into that. And then the issue of risk and attribution, the courts need attribution. Yeah, I think the courts, despite the comment earlier in the conversation that a good number of judges and perhaps litigators may not be very much knowledgeable about climate change. This is the opportunity, I guess, that what Greenwatch is doing is to build this, to really send a message that when it comes to climate change, we really can only talk about attribution with very high likelihood. And that is very difficult to attain. Think about the black swan. It's very difficult to come up with a statement that it's very highly likely that this is going to happen or this was caused by that. However, I know a few studies that have tried to discern or disentangle the fingerprints of anthropogenic warming to some of the rain events or rainfall and precipitation events, including the most recent in the United States, the South, the winter storm that extended further south. And currently in Europe, there is now good enough evidence, although not high, somewhere medium level likelihood, that the changes in the Atlantic, the Atlantic highway of the water masses, and then that one is going to actually create either extreme winters and extreme summers. So there are some fingerprints, but again, the attribution is not very high likelihood. The attribution is still lower. So my point is that, in my opinion, now I'm giving a personal opinion, we just need to build the evidence base to support the litigators to communicate to the courts of law that in climate change, attribution cannot be certain because uncertainty cannot be dealt with. Even in very high quantitative terms, you can hardly deal with uncertainty. How do we improve reports of IPCC? You don't need to, that's a mountain to move. You can only contribute. So if I challenge or I implore that you identify a topic on climate change and do the research that is needed in Uganda or region or whatever. If you have the resources, you can even do continental-wide studies, and that would be your contribution. And that contribution then will be picked up by IPCC so that they have a balanced, holistic, and representative assessment. So that is the trajectory or the pathway that individually you can actually contribute to the climate change and the reports of IPCC. That also responds to the question of, I hope that it wasn't just data, it was just scientific knowledge. The last question on data and the global south or least developing countries, I hope it's not just data, but scientific knowledge. The scientific literature exists, but we know the systemic challenges in publications because IPCC assesses peer-reviewed literature, and we know the problems of getting articles into journals from the global south because of what I talk about or call the editor-reviewer, closed quotes, author bias. And we have to keep fighting that. But when we have some people from different regions, LDCs also being part of the IPCC process, then you individually can support them. So how can you support? As I mentioned earlier, the special report on cities is under review now. Go on site on IPCC, register, look through that report. If you have comments, if you have evidence of the papers that can support your comments, include them into the assessment Excel sheet. It will be picked up and it will be included. That is the transparency, it's the level of integrity, and it's how the IPCC process goes, because everyone who can and is able to can be part of the process of the assessment, so that it's not close to the only 600 and plus or 20 something plus scientists who are working on this seventh cycle of assessment. So I think those were the questions. My last point in respect to the last question about scientific data, which I hope is not scientific data, but rather scientific evidence from the granular level, like in the case of Uganda. Again, go to the website, look at Working Group 2, and you'll find the regional chapters. There is a chapter on Africa. You'll find sectoral chapters, and in each of them, there are also boxes on Africa. You may not find Uganda, but you will be able at least to get the headlines that resonate with Uganda, and then pick the studies that have been conducted by the likes of Mike in your midst and Patrick in your midst and Joshua in your midst, and then you pick up the evidence that needs to support the litigation. Yeah, thank you.
Thank you, Prof.
Thank you.
I don't know if you had the hand claps to you.
Yes, I did. Thank you so much.
Yes, we appreciate your availability and sharing that knowledge with us. So we are going to our perhaps last segment of the day, and that is the Choto, the fireplace. It's going to be led by Professor Byakgaba Patrick. Prof, if you'll be kind enough to grace one of the seats up front. He'll be joined by Dr. Zake Joshua. You're welcome, Doctor. Then Council Amos Moshija. Professor Byakagaba, since you are our moderator for the fireplace and the lead on this, I hand over to you, and you'll be perhaps at the commencement of your moderation, inform us on how and guiding us on how we shall engage with you. Over to you, sir. Oh.
All right, thank you very much, Alan. I work while standing, so sitting is a huge problem for me. And thank you for the big titles. My ancestors have up to now delayed the process of gazetting the title professor, but the signal I'm getting is that they are getting more and more interested. They don't want me to break the record of the clan. My name is Patrick Byakagaba. I wear many hats, but for this space, I will associate myself with Makerere University, where I work while standing, like I said, as an instructor. But also, I am part of the Africa Climate Collaborative at Makerere University. Greenwatch, give me at least 30 seconds to talk about that program. It's an African initiative that is supported by the MasterCard Foundation. We are operating in 3 countries, Uganda, Ghana, and South Africa. University of Cape Town in South Africa, and University of Ghana in Ghana, and Makerere University in Uganda. In each of these countries, we have other partner universities. And our mission is to build the capacity of Africans in the area of climate resilience. So I needed to declare that in the likely event that you see me tending towards resilience, it's partly because that's what I do on a daily. Being a moderator, you choose what to say. So you're not regulated by the convener. I don't know how many people have participated in supporting civil society organizations in doing climate litigation in the room. Any? Okay, Isaiah. And I also want to recognize all my colleagues here. Everyone here is my colleague. And the Greenwatch, thank you very much for, we need to declare I and Zake, we are classmates. So, and then I and my namesake Patrick, that's why I decided to be Byakagaba, because you might confuse us. We went to the same high school, but he's younger. So we need to be clear on this early enough. It's good to always declare enough in case there's any conflict of interest. So I have participated in supporting organizations like mostly Greenwatch, of course, in climate litigation. And I thought, since this is a fireplace, much as there's no fire here, let's assume we have the fire, I should share my story. Maybe it will be inspiring for others to join. Why I want to share, I'm expecting to have more people cut their teeth into this or pick interest in participating in climate litigation processes. But also to show you that we have an obligation, and also to provoke. So if I leave this session without provoking you to pick interest, it will also be problematic. Greenwatch, I also want to encourage my student, Anywa, do not in any way fear to make a contribution, because your instructor is this side when we get to that session. Just to remind ourselves, I don't know how many of us have picked interest in looking at the Climate Change Act of 2021 of Uganda. We probably have the most progressive laws in the world that foster climate litigation. There are not many countries where you find that you have a national law that allows or that provides for climate litigation. If you have your law here, the act, or you have gadgets that can lead you there, Section 26, subsection 1, it states entirely, a person may apply to the High Court for relief against the government, individual, or private entity whose action or omission threatens or is likely to threaten efforts towards adaptation to or mitigation of climate change. So among the climate actions, the framers felt that adaptation and mitigation were the most important. I want to believe within adaptation we could also include resilience, considering that the Paris Agreement on climate change, there's a whole provision, I don't remember the actual article, that emphasizes resilience. So we have a very lucky country that our members of parliament and our government felt that we need to have such a provision. They went further and within the same section and provided the remedies which court may grant if anyone went to court. I'm raising this such that we don't think it's very abstract. Greenwatch is positioning itself as an agent now that the law has been passed of sovereignty. We have a provision within our national laws, and there was no any influence from any other actor outside Uganda probably that led to that particular provision. So among the remedies which I want us to be reminded of that court can grant, I'll state them. Prevent, stop, or discontinue the act or omission that is subject of the application. So in the likely event that you go to court and you want to hold someone accountable, either a company or government or an individual who has in any way disadvantaged you in terms of mitigation or adaptation, court can stop that person, can ask that person to stop that act or prevent that person, to, or even ask that person or organization to discontinue that act. Okay? Court can also compel the department or a lead agency or any other person to reverse the act or perform the act that was omitted. For instance, if someone cleared a forest, originally I'm a forester, so I'll use forests as an example, and you feel that this has affected our capabilities to mitigate climate change, because we know forests are carbon sinks, then that person can be required by court to restore the forest that they have cleared. Okay, a great opportunity provided by the law. The third remedy it can provide is to provide compensation to a person that has suffered loss. Listen to the language, the diction. Suffered the loss or damage as a result of the act or omission. And I think this is where most of our conversation has been today. How do we provide evidence that my action or omission as an individual or an organization or a corporation has resulted into loss or damage? And those of us who consider ourselves as scientists in its traditional interpretation, this is an opportunity for us to demonstrate how people suffer loss or how people get damages due to our actions or inactions. So I thought I should bring this early enough so that we don't think we are just chatting, we are trying to be academic, we are trying to be lawyers. I'm not a lawyer. Or we just want to look busy. We have a law that gives us the foundation to engage in what we are engaging in. So what has been my experience? I should declare that my experience has mostly been with Greenwatch. I don't know, Greenwatch, whether you have any other, I won't call them rival, but another organization with shared interest that does climate litigation at your level. If we have them, then they are not coming to me. So I have mostly interacted with the Greenwatch in supporting them to make an attempt of using our laws to get justice. Mainly leveraging on the provisions that I've just mentioned. And in my little interaction or short interaction with them, maybe now 4 or 5 years, I have observed the following. And I think, is she Joy, the lady who, she has 3 names. So which one do you prefer? Joy, okay. Joy did allude to this, and I've also observed the same. And I want us to pick these lessons, because these lessons are from lived experience. And in qualitative research, lived experience is not challenged, because you have to live it for you to challenge it. And it might take you time to live it. I have observed that it's more feasible to argue for failure of mandated agencies or departments. These Ministry of Water and Environment, the different departments, have been given responsibilities by the law. So it's easy to argue that they have failed to perform. There you are most likely to win, to make some wins if you go to court. I've also observed that, and similarly, I've observed that if you want, okay, maybe I need to restate it. I've also observed that evidence that is convincing to demonstrate impacts of acts or omissions is very critical. However, scientists or researchers are not intentional in undertaking such studies. Most of us do our studies for other benefits. Very few have that intention of doing research that will provide evidence that people who can go to court can use. Remember the provision that I mentioned earlier on. So when you are looking for evidence, you scatter around, you search, you only see Michael Mboga is interested in seeing the changes that are happening, but he's not linking them to the harms, okay, that people are experiencing. So you will present data or evidence that shows that yes, we have these changes, but the nexus between these changes and the harms that could help you build a case, we don't have many of them. I have also observed that there are several NGOs and researchers who are doing their part in terms of research that could be relevant to climate litigation. However, when you look at, no offense to all of us who do this kind of research, the rigor is still wanting. It's a bit difficult to use their work as evidence. And in line with this, if you look at the contributors of the reports that my senior colleague, Professor Schweib, has just presented, you don't find many of us there. There are reasons as to why we are not there. The rigor of our work is still wanting. And for us to have rigor, we have to put in place certain things. You need good resources in terms of both resources to do the research, but also over time. If you are just going to have a one-off study, it might be very difficult for you to have the rigor that can be presented to court. I have also observed that scientists do not yet appreciate their role, and they don't have what we call agency to make a contribution to climate litigation. You meet an individual whom you suspect that he has good papers that can be used, but there's no agency in that person. There's no fire in his or her belly to make a small contribution in climate litigation processes. So how do we build momentum for that? For researchers to start thinking that they have reason to make a contribution. So lack of agency means that we're not going to have adequate numbers of scientists or researchers that will participate in providing evidence. We've talked about evidence a lot, but also I think Joy, which I agree with her totally, it's important to have what we call powerful, compelling narratives that describe lived experience of climate change impacts if you're going to do climate litigation. Now, I need to declare, I studied political ecology at some stage, and political ecology is about narratives. And the scientists are very poor at drafting narratives to communicate effectively their message. They still believe their p-values, their confidence levels are going to be convincing. This is not how the world is run. The world is run by you convincing the other party. So from all those analyses that you've done, using all the tests you want, there has to be a narrative. There has to be a story. Meaning, we need to have individuals or communities that are willing to tell their story. So in our interaction with Greenwatch, we struggled to get a community that is willing to share their story of how climate change has impacted them because of certain actions or inactions or omissions by certain individuals, organizations. Yet, those compelling stories, as we saw Joy's presentation, the different cases in the different jurisdictions, they convince the court to make a decision to give you the prayers you have made. I've also observed that placing your evidence in legal principles is very critical if you're going to get any gains in court, or if the prayers you're making for court to grant you And now, this might sound a little bit technical. Which principle do you reflect on? Different jurisdictions will make decisions on different principles, depending on what is considered to be, I don't want to say popular, but commonly appreciated. Now, which principle do we have to invoke when we are pushing for certain rights on climate justice? Do we go for the polluter pays principle? Do we go for the precautionary principle? My experience is that most organizations, including Greenwatch, have been mainly invoking the polluter pays principle, one, but also in some cases we have been looking at using what the Constitution provides as rights. But is that adequate? We've just learned from Professor Luasa that the data we usually have there are different levels of certainty. So if there is a lot of uncertainty, okay, not a lot, if there is uncertainty in what we provide as evidence, that has implications on what kind of principle you want the judge to be reflecting on. And one of the principles that is within our different laws, even the National Environment Act, is the precautionary principle. But it's the most complicated principle to operationalize, especially when you have a judicial system that likes certainty. Because with the precautionary principle, we acknowledge that there might be no cause-effect relationship, but there is a reason for us to be concerned. Okay? And that's what we do in climate change discourse. We demonstrate to you the risk. But what should be the threshold that is acceptable? So it's important. I've observed that that's a huge challenge that we have. And so until we get to promote particular principles that judges can use for them to be able to give us the remedies that we are looking for, it might be difficult. Then I've also observed that sometimes our litigants ask for remedies that go way beyond the constitutional power of our courts. You can easily, I don't know, is he still here, the gentleman who was feeling like he wants to grab somebody? You can be very annoyed and you run for, you start pursuing remedies that court cannot grant. Remedies that can only be granted by a constitutional amendment, meaning you need a new law, which has, maybe even might even require a referendum. So the court will be in a crisis. It will be very difficult for court to give you those remedies, okay, that you are praying for. So we need to be cautious. We need to be careful on what kind of prayers we make based on what court can grant. I'm about to finish. What are those were lessons we need to reflect on as we get into our discussion later on. What challenges have I observed as an outsider or as a person who supports CSOs, particularly Greenwatch, in climate litigation? Again, I will refer you to our Climate Change Act of 2021, but specifically Section 23 of the Act, which requires the minister to come up with regulations that prescribe climate change obligations on private entities and individuals. Again, we are very lucky that we have a law that is requiring the minister to come up with regulations that are going to help us in stating what obligations I have as an individual, the Akagava, what obligations a business has, a corporation, what obligation, and this would help us a lot to hold individuals, again, to invoke Section 26, which we talked about. So if you have Section 26, which gives you rights to hold individuals or organizations accountable, we need these regulations to help us invoke that particular provision. So it's a bit complicated now. Now we only use the Section 26. So without regulations, again, court will find, unless you have a cadre judge who is very passionate about climate justice, he or she will have difficulty in giving you remedies based on the prayers you are making. So as a way forward, probably this is something that Greenwatch could start considering together with your partners to request or to demand the responsible minister to come up with these regulations to help us to foster climate litigation. Another challenge, climate change is still perceived as an issue that cannot be solved by court. This is of course picked mainly from American jurisdictions, but even here, people think if you're looking for climate justice, then court is not the right place. Negotiate politically and get answers. Okay, but we all know when a person chooses to go to court, it means this person has tried other avenues and have not been successful. So court is considered as the most fair arbiter. Okay, so how do we change this perception of thinking that matters to do with climate justice can only be solved politically? Okay, we need to demonstrate that court can make a significant contribution. Another challenge, it's hard to provide high quality scientific evidence on the role of climate change to harm and causing losses. I think we have had this discussion, but the good news is that we just need to acknowledge that there are different levels of certainty. So how do we, to be my next point, how do we ensure that we appreciate the fact that unlike other cases, like the criminal cases, it might be very complicated for you to prove beyond doubt that there's a cause-effect relationship. And we have, again, many within the jurisprudence that we have, enough judgments that have made based on the level at which judges have made decisions based on the confidence level that has been presented based on the data. Of course, this one I am attacking myself and also my colleagues who are in academia. Our footprint, specifically Ugandans, on evidence that links climate change to harm and losses is very minimal. Okay? We do not have an adequate pool of scientists that can support climate litigation. Green Watch will come to Byakagaba, then Byakagaba will go to Mboga, then Mboga will go to Dr. Lwasa, Professor Lwasa, to Isaiah, and before you know it, you only have like 15 people. And probably we have only 1 or 2 papers. And of all those, there is no paper that is linking climate change to harm or losses. I was just checking before Professor Lwasa came in. There were 86 authors and review editors of the current IPCC report. 86 authors and review editors. Of those 86, only 11 are from this continent. 11 are from Africa. You want more statistics? None of them is from Uganda. The nearest is a Kenyan. Countries like South Africa had like 3. Morocco had like 2 on that panel of authors and review editors. That's a huge indictment to us who hold these titles. And partly that's the reason I don't usually use these academic titles, because people, once you use it, then people check your contribution on Google Scholar. So if you're not doing very well, in Africa, in Uganda here, there is a way they can look at you and you know that they have judged you. So the only title I use, Samantha, is Oiktinesa, because that one, no one can remove it from me. It was bestowed to me by the Omukama of the only empire in this region. Okay? Yeah, the check H index. So our contribution to climate change discourse is really still very small. And in peer-reviewed articles. You heard Professor Lwasa did mention to you that they don't do the studies. They look at what is existing. Not so. But they don't pick every paper that is existing. If you published your work in the Hoima Journal of Climate Change, they will not see it. Be aware. It has to be, I'm mentioning Hoima because Hoima is trending. We were celebrating Arsenal and we are on BBC. Arsenal win. So what does that tell you? If we are not visible in those journals where they pick research outputs, it means we are not making any contribution. So how is the judge going to respect your views if your work has not contributed to the report? Huge, huge challenge for us. I'm about to finish and then I give my colleagues an opportunity. I already talked about limited agency to prioritize climate litigation cases by the judiciary. I don't know how long it has taken us, Greenwatch, for some of the cases that you filed. So there is no agency. But the other cases, especially criminal ones, I'm sure you remember the most recent, usually they are processed very fast. So how do we encourage our government to prioritize these cases? Legal standards sometimes are blurred when it comes to climate litigation cases. Okay, I think that's quite obvious. Then I know council here will probably weigh on this too. I want to raise your attention on this. The use of experts in litigation of civil cases is not very common. This is my observation. I don't know why it's not very common. Because of this, partly the reason why we don't have this is the fear of the cross-examination. Because most of the lawyers here, they will cross-examine you as if you are dealing with a criminal offense or criminal case. Okay, so the standards are a little bit not acceptable to many scientists, so they shy away from participating. So how do we encourage use of experts in these civil cases? Evidence on climate change, like Professor Loasa mentioned, is based on the level of confidence. Our laws do not provide clarity on the level of evidence. Again, correct me if I'm wrong. I know for the criminal cases, it's clear. It has to be almost 100%. But we know in civil cases, if you get 51% level of certainty, I don't know whether that's what we apply here, but elsewhere, 51% is considered acceptable for civil cases. And we know climate-related cases are really civil cases. They should fall in that category. Okay? I talked about the precautionary principle, and therefore we may need to reflect on, and again, this is for you, Greenwatch and the other partners, how do we engage the judiciary to start looking at these cases related to climate justice as cases where the level of certainty is very important. Because if you don't have that, it's going to be very difficult for us to achieve what we want. We could be treating them the way we treat labor-related cases, not so. If your worker says you touched me in the wrong place, the judge does not ask you where exactly did he touch or did she touch, not so. Yeah, as long as there is a reason for the judge to start believing that, well, I think you touched this person in the wrong place. Okay? So the fact that courts still treat climate change cases with strict highest degree of certainty is challenging. So we need to work towards addressing that, and they still treat them as the criminal cases where you have to prove beyond reasonable doubt. So it might be difficult, as we've learned, either from experience or from what Professor Loasa raised. So this is my story of what I've been able to learn and some of the challenges. But Zake, who has many hats too, also has a story to share, and then we shall wind it up with Amos. In the likely event that I have misrepresented the lawyers in my views, please feel free to say this we disagree, this is not what we have, for the benefit of the audience. Okay? You don't have to sue because I don't have what to pay. All right? Do you want to use this?
Yeah, thank you. Thank you, Patrick, for setting the scene, and I would want to take the approach of not repeating what you... I just want to add to what you've shared in this reflection at this Kyoto. Yeah, so I'm Joshua Zake once again, and indeed I have many hats, but today here I'm putting on the hat of an independent scientist and consultant in sectors of agriculture, environment and natural resources and climate action. And I also work closely with the several CSOs on different issues, including Greenwatch on aspects of pursuing cases of litigation. Yeah, but that said, and from the point of adding additional reflections to what Patrick has shared, is that, for instance, I want to pick it up from where you asked which CSOs are doing litigation in Uganda. And you can quickly mention, there are not very many, they may not even go beyond 5, But also, if you look back 10, 15 years ago, there were a number of CSOs who were doing litigation and even using a collaborative approach. For those of you who have been around for some time, you remember the Mabira forest giveaway for sugarcane plantation. But I would want to say it didn't use the approach of litigation alone. It was really an integrated approach involving campaigning, advocacy, and litigation, and it involved many stakeholders, including even the citizens and the public. And I think at the extreme end, the citizens went up to on the street, and even some lives were lost. And at that point, I think Cabinet had to suspend the giveaway. But also, beside litigation, the science had a very huge contribution. If you remember the study on the valuation for the proposed giveaway, which brought out what do we lose if that portion of the forest is given away. And of course, the government, the other side, was arguing, we are going to make so many jobs, we are going to create so much income, revenues, and so on. So for me, that's a lesson that maybe litigation alone may not be the silver bullet, and I think it came through the presentation. So it's also about assessing and taking that decision of which strategies to apply. But I think it's better to apply more than one strategy. And then, and in that process, a number of NGOs were involved. I could list. I think Greenwatch was leading, but collaborating with ACORD, Environmental Art, NAPE, Nature Uganda, Teen and Anti-Corruption Coalition. But through all those that process, the different actors, the civil societies, were also taking up actions based on their competences and capacities, but also when it came to mobilizing the resources, because such process require a lot of resources, and not only financing, but also human resource, technical capacity, technological resources. And each of these were mobilizing the resources, and it was done in a collaborative way. But back to the question, how many CSOs, you could see that 10, 15 years, maybe up to 8 or 10 CSOs could take this as an approach. But as we speak now, there are very few. So it means there are challenges and risks for civil society to engage in a litigation process. I don't want to create more fear for the CSOs, but these are also realities. As you go into do litigation, it's important that you do a very good analysis of what is the issue, how do you position it, how do you remain objective. But I like your comment, you emphasized that the policy and legal framework already provides for this. So if you choose to do litigation, you're not doing something wrong. But then to avoid a misinterpretation, because as you're doing that, maybe somebody in the government is saying, now look at this civil society, it's doing something wrong. I think we have, you will need to remain objective, but also factual, and even remind the different actors you're engaging in this process that what you're doing is not bad. You're actually doing what the policy and law provides for, and you're contributing to development. Because there is also a scenario where the misinterpretation could be that you are anti-development. So it's important to manage that as you do the litigation. So it would require for maybe effective communication along the litigation process. And then related to that is the protection and what? And safety. I remember during the Mavida campaign, I was at Environmental Art, and we had a number of break-ins into the office. Of course, maybe you could not directly attribute them to what was going on the lobbying and advocacy and the litigation process, but the reality was that they happened at the same time when these processes were going on. And that speaks to the attribution and certainty. Yeah, but sometimes this can go beyond just the institution as a civil society to even track individuals. So as we engage in the litigation process, it's also important to reflect on how to protect the organization, but also the individuals involved in the process. so that by the end of the litigation, we are not having again the people involved getting injustices through the process. And I've already spoken to the institutional capacity, and when you say capacity, of course, it's wide, and it's also not possible to have one civil society that has all the capacities that would require to have an effective litigation process. But also, in reality, not every civil society can do or pursue litigation, because maybe you're good at lobbying and advocacy, or you're good at working with the communities who are facing these injustices. But the reality is that you need those resources. So responsive capacity building is important. Sometimes it may require bringing in the required human resources, or mobilizing the required finances, or even having strategic collaborations. And interestingly, or the other entry point is that some of the issues which are being litigated are also issues of international importance, because it is, for instance, unfair if our government commits at a global level in some of those multilateral agreements, and then another to do the opposite practice at what? At the local or community level. So it will be like shooting yourself in what? In the foot. So it also means that as we analyze and synthesize how to engage through the process, it is important to analyze who are those stakeholders, and how can a community issue also become an issue of global interest. But also litigations can go beyond the provisions in the courts of Ugandan law, depending on the issue. Sometimes you can take it even at a regional level or even international level. But that's only possible if you've done the stakeholder mapping, and you're also able to mobilize that kind of support at the different levels. I think let me leave it at that. My colleague I know can make further additions. Thank you.
Thank you, Dr. Zake and Owechitinisa. Yes, and thank you all for being present. You know, there was a time when we were looking for expert witnesses, and now I'm shocked that we have even a room full of experts. And you know, that's a challenge that we have with the, climate litigation and environmental litigation. Amos Musheja is my name. Work with Kakura and Company Advocates. I can say with Greenwatch as well, because Greenwatch has always been the client and Kakura and Company Advocates has always been the lawyer. So that's how we work. Okay. Environmental litigation. My experience, first of all, my background before, because my experience with climate and environmental litigation actually spans with Greenwatch, but looking at my background in commercial, criminal, and other civil aspects of the law, the principle was always however, the law does not act on mere suspicion. However ingenious the thing might be, he who alleges must prove. Now the complex with when it comes to the environmental litigation is that the law and the science do not always follow the same logic. The law looks at the clear liability. You have infringed on me. I bring the evidence of your infringement. I prove it directly. And then judgment is given in my favor. If I don't have the evidence, the case is dismissed. Now when it comes to the climate environmental litigation, now that is why I met things like uncertainties, probabilities, you get. And you find it conflicting with our legal system, because you find that if you speculate something, they say that is hearsay. You get? So imagine you're supposed to speak the facts. So you find that is conflicting with our system. And that is now, of course, when Joy was speaking, other jurisdictions like Germany realize that they've embraced the aspect of future harm. Yes, and it is still a new phenomenon in our jurisdiction. So that means if I call you as an expert witness, your job is has been a cause of action here. Bring me the science to link the infringer to the cause and the harm, and the cause to the harm that has been caused. You get? It is not. And some of the experiences I've had is that most of the scientific reports I've read is that they are presented more in an academic format. Like you're presenting to maybe meant for an audience or are not specifically tailored for the court. And maybe that's because maybe not having this knowledge on how to present our evidence before the court. So you find that now, when you call on an expert, let's say I call on Dr. Zake, say, oh, you come and tell us what government has failed to do. We are losing forests. So how can one prove that the government has failed to do its work? So Dr. Zake will give me his presentation. This is the data I've researched here. But I want you to link that information to the action of the government and to find that actually they are at fault. So the challenge comes that he's supposed to present that in court. And he doesn't know how to present that in a witness statement. Because our evidence here, before, you used to come and we ask you, you narrate to court. That was your evidence in chief. Now, we sit with you and we write your what would have been your evidence before court. We put it in writing. Now, you realize that as a lawyer, you want him to, you're telling him, this is what we want. You say, how can I do it? You get. So you realize that now you're supposed to read how many pages of a report he has sent to you to explain that simple thing, that because of this, this is why this is happening. To reduce for him in a statement. You get. So you find that now that has been, we are getting there. Initially, we'd come up with, let's say, because for sure climate change litigation is a new phenomenon. That is why you find that when it comes to other cases, civil, like criminal, land, family, they move fast in the system because the judges are used to that. And that is what is taught at law school. Now, when it comes to this climate change, you realize that actually even our judicial officers are learning something new. So there's a time we had, I think it is still there in court. A case was filed even before I finished law school. Up to now, we are still arguing the same case. There's a time a judge said, okay, I see you have your scientists that have presented their evidence. Government has also presented their NAPA, NDOR, DC's reports. Can I just decide this matter based on these papers? We had agreed at that time. We said, okay, just look at the evidence and proceed. Then the judge said, okay, you put for me submissions highlighting each of your witnesses in their reports, what they are saying, and you. So we did ours. Then they realized, okay, I think our reports are not sufficient enough. And that's the time when this new Attorney General, I think, had just come in. He said, no. That is not how cases are handled. We need to hear the witnesses. They hear our witnesses. Okay. The case, now, we're waiting for judgment. The judge called us. He said, no, I was told the other system doesn't work. Can we go back to square one? Bring back your witnesses. Yes. And I know she was doing that because when you look at the reports you guys make, and when you present these IPCC reports, the whole thing looks like this. And you scare, the judge is scared. It's like, okay. See, so, and most of the time, the other things that some of these climate, some of the judges tend to look at them as if you are being political in a way. And they fear to pronounce themselves, to make decisions, which might affect the Kawogo in future and the promotion. So they tend to say, okay, they keep you in that system until that one is transferred. Says, you get. Another one comes. Hey, what's this case about? Hey, okay. Put in your documents and we proceed. So, but first tell me, what is it about? You explain this. Oh, okay. We are in June, May. Said, okay, the earliest I can hear this is November. You get. Now, those are the challenges that we are having. But like we said before, and I think why the other challenge is that there are always very few litigants in this area. The defendant, and is also always, I think, one, the government. So if you go for a corporation, let's say a polluting company, you may need to go under the civil law of tort. You get. So you find that now when you're going for this public interest litigation, it is either the civil society and the government on the other side. And it appears that you're attacking them. One time we were handling a case. I think you remember it was the forest in Bugoma. I was with Justice Kakuru. I don't know what was happening, but I think Samantha knows. But the judge called me and said, you know what, Mushija? You know when you're fighting certain things, you need to know when you're getting a bloody nose, and then know when to retreat. You know, sometimes. So you need to balance, because you need to survive and also take on another case. So then I realized, okay. The person behind the destruction of that forest is reacting. You get. I think we somehow pulled out of that case, and we had other colleagues, the civil society, they stayed, and the judgment described exactly what we expected. So I think that is it. Yes.
Thank you. Well, I'm now going to change. I'm no longer a panelist, so I'm going to be a moderator. Can we have only one microphone? Okay, great. We have two. So please weigh in, the audience, from where we started and this panel or this fireplace, to hear your perspectives. Do we all know each other? I came late. My name is Patrick Ibiakagawa. So for the benefit of the Secretariat, please mention your name and maybe the organization so that they pick up your views.
Thank you very much, my brother. I call you my brother because when I look at your age, we might probably be within the realm of protecting our gains. Thank you. I am Marius. I have come from Uganda Matters University. I also work for another university in the north where I work standing like you do. First of all, I am at a loss that when I came in the morning, somebody promised us that Amos was going to present things to do with the cross-examination. I have not heard that one. Maybe he has forgotten. That's a reminder. Two, I wonder, we are looking at strengthening scientific support. If, as a scientist, I support this court with scientific evidence, under what circumstances does now the judge make scientific recommendations? In most cases, I stand to be guided. I provide this scientific evidence, but the judgment is to imprison or to do the other thing, leaving the recommendation on the improvement where the evidence has come from. I think I have a gap in that understanding. Are there circumstances where the judgment recommends scientific improvement? Dr. Joshua, there are advantages of breaking a silo. These people of the law and us, the scientists, we have the same question. Sometimes they make fun of these lawyers that when you get married to a lawyer and you come in the afternoon, you say, babe, I'm hungry. The question is, where is the evidence? But Patrick, is it not the question we ask in science? We also ask my brother here in social science, the question will be, where is the evidence? So the two disciplines are evidence-based, but then there should be gaps when it comes to training. Law is training to use evidence to make judgment. Science is training to use evidence to make a decision. Why is it that this silo is not broken? The training is one way for scientists and then the other one. That area needs to be very clearly understood. We all look for evidence. We are all rigid. I've never seen a rigid discipline like in science. Somebody insists on asking until further notes. Even subject the little evidence there is to peer review. And even when it goes through that, somebody says, this is not evidence enough. Please go back. How can we break that silo so that there is a cordial relationship, especially when it comes to training? It is very true in our science there are areas where we do parts of the law, but it is very small. And I don't think in the legal or the law training, that is where they do a lot of that kind of science. Otherwise, I am very happy.
Thank you very much, Morongo. Alan, any other person that wants to weigh in?
Break the silo.
Thank you very much. I studied law, and then I veered off. I studied a master's in sciences called the NRM, Natural Resources Management. But I also work in the NGO sector, in the health consumers. And annually, I am a consumer of annual prevalence reports, either the Cancer Institute, Heart Institute, Lung Institute. And those inform our advocacy, either to persuade finance to raise taxes. I think you saw recently they raised taxes on sugar, they raised taxes on cooking oil, because science has proved to us that there is a direct link of being exposed to these products and death is the resultant. we also engage in, I don't know whether you've heard of maternal death reviews. We, in a way, change that any mother that dies at a hospital while she was going to give life, whoever was involved automatically has to go to police and make a report. So, speaking at how science can be picked and how documentation is indeed believed, without necessarily these particular authors of this very document actually being called to court. I think also that speaks to documentation. And you also said the rigor of research. You have developed the models so that it is tamper-proof. And we also said you need to declare your conflicts of interest so that they know who funded you, so that you have a document which is a fact speaking for itself. We have also benefited from doing spot checks in the markets. I think Dr. Kavanda left. But for him in Sefrot, he just goes to, say, Karelwe market, and then just looks at all these tomatoes, and then looks for an NDA person or a person from the Standards Bureau. And they just either go to Government Analytical Lab, they do tests and say, this particular spray that was on this cabbage is directly linked to. So I am thinking, like you did say, we need to invest in those resources. We also need to persuade these particular scientists to move away from their peer-reviewed, because they also need to have their work disseminated. And when they see their work indeed move court, move policy, and change the law, they have more relevance as academia to improving how the society perceives, and they bridge the gap. Otherwise, they'll find themselves making presentations in boardrooms or making presentations that finance actually finds problems with, and that in a way I'm happy that now you're trying to create that marriage of convenience. I would request that this doesn't become a one-off. You do a lot of resource mobilization. You have cross-fertilization of the lawyers, and because I have a student who is now a magistrate and is now studying a master's in natural resources. And he was at some point perhaps arguing against you, or yes, because he was in NFA. Now so if we can have them brought, and now they appreciate that language, or perhaps also if you can have, say, the judges pay visits, say, to the Cancer Institute, to the Lung Institute, there they can have a hands-on. And I'm very sure if you can afford them that kind of resource, they'll be more happy to make a judgment with that background behind them. I know this is the very first of its kind, and I hope, we pray that it gains fruition. Thank you.
All right, thank you so much. My name again is James Opito. I coordinate the Civil Society Coalition on Oil and Gas. And we are aware that the oil and gas sector has moved through a number of phases, and we are now looking forward to the first oil. Don't ask me what does first oil mean, because it has a lot of nuances. Yeah, so my question is to address the question of litigation. I know when we particularly limit the talk on litigation, then you realize that the space is narrowed. It's not everybody does litigation. But now, how do we plan to work with others who do not necessarily do litigation, but their work actually ends up supporting litigation processes? I am glad that from the key pillars of Green Watch, we've seen advocate, empower, litigate. And when I look at advocate, when I look at empower, then you see that those are very key pillars that tells you there is a potential of working with those who do not litigate, but they end up placing the building blocks that end up with litigation. I'm aware that there are those who may not necessarily do environmental litigation, but they support those who have been voicing causes on the defense of environmental rights. And they might have not gone to maybe challenge in the court of law that this position is not this way, but probably they are defending those who have been expressing themselves to say we need urgent attention of these stakeholders on a particular issue which relates to environment, climate change, and others. So maybe you could help give us a little bit more direction to that, how you work with others or how you are planning to work with others who do not necessarily do litigation, but their work would end up supporting litigation. Thank you.
Yeah, thank you. Kimbo Richard is my name. I work with the Uganda Coalition for Sustainable Development, but also chairing the Renewable Energy CSO network that is hosted by Environmental Alert. Two things. The first thing is when I came in the morning late, I have been listening in, but what I realize is that there are experts here, one side, but there are also experts the other side who are not in this room. I mean, the judicial people of the other side. So when I came in, I thought when I got this invitation, so like strengthening scientific support in strategic climate mitigation. It was like a capacity building, but now I realize we read it is not really a capacity building, but rather identifying the gap, the so-called gap analysis, and say how can we address the gaps, because all the skill is here, both here and the other side. So I would, as it is a fireside, I think my side is like a gap analysis is what we need, and then we see what we can do, rather than looking at a capacity building of some sort. The skill is already there. We don't need to rewind. Lastly, I think the capacity it can only be on the comparing narratives. That is where the weakness is. Excellent report, like you have able summarized it. Huge report, then the judge looks the other side and says, this side I cannot read. And it goes for all of us. When it is too huge, even online, you first order a cup of tea, and somehow you can switch off and go to sleep. Because it is too big, you cannot start reading it. So the thing is that how can we be helped to get the science into a compelling story, into that can help court in this regard? So maybe that's the question that we have on our side in the fireplace. Thank you.
Thank you so much. My name is Tsime Pauline. I come from the Center for Food and Adequate Living Rights, SAFEROT. The discussions have been so intriguing, and maybe I'll have to first go back to the first discussion that was by the engineer. The engineer's discussion was very intriguing on my end, and it brought back Joy's discussion on the issue of the narrative. The industry has set its own narratives, and then we should also know that the industry is a big power. The polluter is a big power. When you're fighting the polluter, you are the David, and the polluter is the Goliath. So you need a lot, you need grace to fight the polluter. And the narratives, most of them are in line with poverty. So they are looking at development over so we have to pay the price of climate justice for development. And I think how maybe we can counter that is we need economists. Those are the other people I think we need to have in the building alongside the scientists. The economists to help us link or create a nexus between the cost of inaction and the cost of action. I don't know how to explain that, but if the government does not act against the climate injustices, what will happen? What will be the cost? What cost will Uganda pay in the 5, 10, 50 years? Because recently we had a case in the East African Court against the ECOP development, and the court, literally court used it was just a time effect that they used against us to kick out the case. And they ignored all the arguments against the pollution, the resources that are going to be destroyed by the pipeline, the future likelihoods of linkages, but they ignored all that and just looked at just simple technicalities in the case. Maybe also the other point I wanted to point on is on the scientists. I think my opinion, scientists majorly look at research for academic, and most of us do research to publish and not research to create change, because someone writes a paper and they just publish it and like that's all. But then I feel like research has to move hand in hand with advocacy, because the moment we've done the research, then we have to we have to do advocacy to create change. If you've found out that in the next 5 to 50 years, the carbon emissions in Uganda will have increased by this amount, then what should be the solution? What do you recommend? And if you are making recommendations, then what advocacy are you putting forth? Maybe that's where the civil society organizations come in. And then also is the issue of strategic litigation. Strategic litigation is not independent. It goes hand in hand with public mobilization. If you have the support of the public, trust me, you will have the support of the government. But most of us, the civil society, we first take on, yes, we are fighting for the public, but we leave out the public. Like, we work on things that when you meet a member of the public, for example, I'll give an example of the project affected persons of the pipeline. If you meet a member or a PAP from maybe Hoima, I want to remember the exact place where the pipeline is, not majorly Hoima. Okay, Bulisa. If you meet someone maybe from Bulisa and you ask them about the work we are doing, you ask them about the ECOP case, can they really tell you anything? If you find someone that has been, I want to use, okay, maybe the examples are skipping my head, but if we are having a case, a public interest litigation case, the public we are representing, if one member or 10 members from from the public are picked out, can they really speak to the relevancy of this case? Yeah, that's all I had to say. Thank you.
As Isaiah picks the microphone, in that particular case, we saw a list of the litigants, and many of the names were not associated with the local landscape. But that's a story for another day. So someone can use that actually to think that you're from Kololo and you're arguing for people in Bulisa or in Kikuwe. Question is, do you have locus?
Okay. Yes, thank you, Patrick. Interesting. Colleagues, science is about not publishing. Science is to solve community problems. That's what science is about. Nobody thought man would go the other side of the moon, but we have recently been there. Nobody thought that we are going to have telephones which you can carry around. The other time telephones were fixed in the house, but now telephones are carried around. Science actually is about solving problems. And for me, I think what is important is to identify what are called the variables. What do you need, to take to court as evidence for climate change litigation? And what are those things? And that's what maybe we should be discussing and beginning to see. As my colleague here says, for me, when I came, I thought it's like, okay, how do lawyers work with the scientists to have evidence which can be maybe presented in court and for this kind of litigations? I give you some examples. I worked with the civil society before I joined. I worked with the in the academia and then joined civil society, and then I went back. But when I worked with some of these organizations, there was this challenge when the oil development started. There were complaints that actually the elephants, for example, in the north, were moving out because of petroleum development, and they were moving to eat people's crops and something like that. WCS, with the UWA, developed a study. The elephants were radio tagged, and the movements were able to show that actually, even before the petroleum development came into place, these elephants were moving actually between Makshon Falls up to Nimle National Park. That was a corridor. This corridor were settled by human beings, and were not able to allow the elephants to move around because elephants are matriarchal. The mothers can remember things even over 100 years. So they remember where they used to move, and we were able to demonstrate that. The ministry challenged us, you see, and others. So we were able to prove that. The second thing was there was this problem of wildlife trade. You know, wildlife trade, magistrates, even the people who were working for the revenue authority were saying, what is the evidence? How do you help us to make sure we gather evidence that can be presented to court, or what do we look for? We started training URA magistrates. Dogs were used to trace some of these things, scanning and other things. Now there is a lot of evidence. Once people are arrested, there is evidence which can be presented to court, and the cases are successful. So it is what you are looking for which can be presented. The other thing is mineral identification, minerals. We all know how minerals were coming from other areas. At first, it was difficult to know whether these are blood minerals, the blood diamonds, gold, and other areas. Scientists sat together and said, how do we make sure these things can be identified? And it was developed that now minerals can be traced where it was mined from, and where it goes, and where it is, who gets it. So it is possible. The other thing is this carbon dioxide thing. For example, the oil thing. In Uganda, we know, for example, the oil is going to generate some carbon dioxide. We had these discussions several times. One time we had in Nairobi, and I questioned, I said, as Ugandans, we are going to generate this oil. And we must have evidence that actually we're going to mitigate. I think the general manager then tried to play around. And it didn't take long. People actually picked that up. You remember Uganda was sued in Total and others were sued in France. It was based on that. So in future, it will be possible this thing will come up. When people are going to prove that actually what you are generating is causing problems. But what is that science we need to show to prove that this there is evidence? So this thing, it's not difficult, it's not impossible. The most important thing is let's identify what are the variables. What is that evidence we need? You see, then a man can think about that. Thank you very much.
All right, thank you, Isaiah. Patrick Musinguzi.
Thank you so much, the panelists and our moderator, and of course, colleague. I think for me, just have a few points to add on the discussion. One, I think we should be grateful that there is a law on climate change in the country, but unfortunately, still, most of our laws are not known. It still remains a challenge that we don't know what's happening in this country, many of us, and the implication of such a law, especially as we keep on, talking about climate change. I think something which is not understood by many, for information. It's a law which has just been passed not many years ago, but that's a big point we need to think about. But also, as we advance all this discussion, I think the political ecology, I think you mentioned you did studies on political ecology. I'm trying to catch up with you a bit. Political ecology. I think as we discuss all these science issues, we need to we need to be keen on the political environment at hand. If you study the political environment in the country, you tend to move faster. Like now we know what's happening with wetlands. and what the government thinks about wetlands. So we need to really be in tandem with what the government is thinking, even as we try to propel some of these important concepts. But also, there was a concept of data being simplified in the courts of law. Actually, I noticed that this global warming concept is not a Ugandan problem. Sometimes we mix up these things. This is a global problem. And all these emissions we are experiencing from our systems here, driven by human activities, actually they are coming from a global issue. It's a global community. Now I'm imagining when I go to Amos and he's trying to help me out on law issues and, you know, supporting me in terms of litigation, you can see how he is going to struggle with a global issue in a local court. It's not a small concept, but that means that I would imagine that in these scenarios, also we need to think about how our localized laws are fitting in our total discussion. For me, recently I've been doing some assessments on carbon footprints. And when you go to the communities, people will ask you that the rich in Kampala are the top emitters of carbon. You're looking at their lifestyle and what they do, and people are saying, why don't we put a law in that respect? Because they are the guys who are, you know, releasing a lot of emissions. Now, if you compare to my local farmer in Iteso there, who is a low emitter, and you know, and the other day there was a big truck taking some cement to some factory. They were asking, this a lot of noise, a lot of pollution, a lot of release of emissions in my community. Now, you see, it was like that needed a legal kind of engagement, that there are trucks here moving on our roads in our village, moving with material, meeting a lot of stuff from my community, and they were complaining. Now, meaning that even these laws we're establishing, we can customize them in the context of climate change. Because if you have, for example, a carbon footprint really taken seriously at national level, it means if you pollute and there is evidence that actually you're emitting more than the other local person, we can get you in that direction. And then the other thing I think on the publications, you mentioned about we are not so intentional. I think this again we need to be a bit specific, as some of us from academia, if we don't have publications in our region to support the IPCC frameworks and this kind of thing, I think we need to do something as academia to boost. And lastly, you mentioned about how do people suffer from loss and damage. This is something which I've not thought about so much, especially how we can actually discuss further. Because, you know, if we don't understand these systems well, especially how we are linking to the linkage between what we are seeing globally, the losses and the damages which are directly can be, you know, taken. I think we need to understand this well and define these aspects in different regions.
All right,
thank you so
great.
much.
Yeah, loss and damage has never been an easy thing. Oops, sorry, even at the international level, we still struggle. Zake and Amos, you are going to share 5 minutes to respond or to comment. Most of them were comments for the Secretariat to pick, and then we move towards ending this session.
I think I'll begin with James. What is your area of expertise? Aha. Okay.
Peter, don't worry.
Okay.
I don't
No,
have any area of expertise. So
you mentioned something to say that, how about us who are not in litigation? Now, there's no anyone here who is in litigation. That is a point of correction. Normally, an expert witness is called to court on 2 instances. One, you can come in as an amicus curiae, a friend of court. There is a matter between the parties who are fighting, and there are complex scientific issues. And they say, there's James who is an expert on this. Let us look for him. Court calls you on that instance, and you give your expert opinion. You are neither side. That is as an amicus curiae. You are not the litigant.
You get? But you've simply come to give your expertise on that issue before court. The other instance is when, for instance, I have been bringing a public interest litigation on behalf maybe of the people of Bududa. We have been having landslides going on for years. This is a responsibility of government. But then I need a scientist to tell me whether is this a responsibility of the government? Is there something with the soils? So then I call you in. On my side, as me who is filing the suit, you present your evidence. You help me prepare that plain. An example is that the first case we had filed, I think, on climate change, we didn't sit down with an expert. And we had challenges in bridging the gap. When the expert came in, we realized that actually he was presenting things which we had omitted in our pleadings. And a court case is won on papers. If your papers are shoddy, however much you speak the expertise and the good English, your papers have to back up the evidence. So realize that actually the expert had more data. Initially, had we sat down with him, would have brought up a very good case. You get? And I'm sure the second case we sat down with a doctor here. We saw a difference because we sat with an expert in the material that we presented. So it is not you, the litigant. When you say that those in litigation, no. Anyone in your field, you can be called as long as it is an area that the law needs to solve a solution. Get? So I think why we are here is to see in the event such a thing arises, how do we work together? How do we go about it? Okay? 1 minute. Now I haven't touched the cross-examination of that man. Okay. Okay. Maybe let me help you on that cross-examination bit. I know anytime soon you're coming for cross-examination. But here is the thing. An expert, you're looked at as one who is knowledgeable in the field that you're talking about, either through your academic qualification or your length of practice in that area. So if you're building a case, I'm using your experience, either the accolades you have through the school or your practice in that area, you use that knowledge to solve that case. Now, I present you my facts, you fit them within that science. When we go to court, the other people are looking to discredit, first of all, are you qualified to testify to this particular issue? So they first attack your academic qualifications. That's the first thing. Second, is your science you're talking about, is it the general? Because when you talk about, I realize that the IPCC seems to provide the generally acceptable science for this thing. So is it something within that? So the whole intention of cross-examination is to credit you and make you a liar before court that what you're talking about, you don't know it. You get? Yes, it intimidates you. But if you have been in this area for more than 10 years, 30 years, you are speaking of what you know. So no lawyer can actually put you off your feet if you are speaking what you know, because you are speaking from experience. Is that clear?
Thank you, Amos. I'm called Patrick Vyakagava International. Locally here, they call me Vyakagava Patrick. So they can easily say, what's your name? Patrick Vyakagava. But your certificate is reading Vyakagava Patrick. Are these two different people? Then you get disorganized. But Zake, go ahead. That's how lawyers earn, unfortunately.
Yeah, thank you. Thank you, Chair, and colleagues. Thanks for the additional reflections at this fireplace, and I want to appreciate them because they are real additions to take forward, to continue with the fire, continue having it burning. But maybe I just have a comment, so points of emphasis on some of the suggestions raised or the comments raised. I like the one of breaking the silos, and I think it speaks beyond what we are talking about here, but even to the wider sectors. People want to work in the comfort zone. But unfortunately, the realities on the ground go beyond the comfort zone and silos. So of course it's a hard nut to crack, but the good thing, the universities are here. Maybe we are missing colleagues from the judiciary, but we have some of them. And also the good thing is that Greenwatch has started on this journey. The question would be, how do we structure it more? Of course, we can't do it at once. It might take some time. For instance, it might require a review of the curriculum on both sides for the lawyers and us in natural sciences to see how much aspects of law can be added into the courses, and then vice versa. But it can also mean more structured and issue-based engagement with the judiciary on these issues, which I think the journey has started, but maybe needs to be strengthened. And it could also mean influencing the research agenda for the researchers and scientists. Maybe to come up with the research topics that are also providing solutions or more evidence that can be used in in the court. And also working with both entities on real cases of of litigation, and then building that pool or that community of experts who are working together rather than working in silos. Yeah, I wanted to comment on that. And then the gap analysis is good. We've started on it. Maybe from this reflection, one clear gap is that the communication and the packaging of the evidence needs to be simplified without compromising what is in the science. And that can be another discussion for even a full day. But I could say that this is a starting point, maybe a more structured analysis of what are the gaps, and then having a responsive strategy to bridge the gaps would be something also to take away. Of course, James, your comment on how does Greenwatch work with others that are not fully pursuing litigation as an agenda, I think is also a good one, because you may want to use the previous case of Mabira, but it also depends on which issue are you litigating. But the challenge, the reality is that you may not have all the resources to influence a certain decision, even considering that there are also political interests around this case. Well, litigation could be one of the strategies, but alongside other strategies, and you can't work alone. Thank you.
All right, thank you very much, Zake. We're coming to the tail end of our session, and as a very good listener, I picked a few things that I wish the Secretary to quickly pick. We probably came here when we are very uncertain on whether we have scientists or experts that can support climate litigation, but I think from the conversation we are having, or we've had, we have them, and the willingness is there at different levels to participate in climate litigation. I've also observed that we need to be intentional in conducting a gap analysis when it comes to climate litigation. What is it that we need to address? And that will help us to prioritize our next set of course of action. It's also evident that if we are intentional in addressing harm, we may need to do studies that look at loss and damage assessment. And to me, that is something that the state will definitely have interest in. So it's a great opportunity for us to work with the state this time as partners, because they would use the same to argue in the different COPs that discuss loss and damage assessment. We need to acknowledge that we are addressing an issue that is global. So we need to pick lessons on litigation of global challenges in local courts. I know, for instance, terrorism is a global challenge, but countries have arrangements of litigating on it or addressing it at the local level. So what is it that we can pick from that? We can't run away from the fact that we need to appreciate the political economy of the issues we are dealing with. Because if you're going to make some gains, some quick wins, you need to understand the political economy of the issue you're dealing with. Less you'll be like that hero who never made it. Okay? Investing in evidence generation is something that we need to start thinking about. Who funds evidence generation? Is it a common good or common service? Who is responsible? Most likely it's just like building a bridge or building a road. So investing in evidence generation should be something that we could consider. I've also picked that we need to do strategic litigation that involves the public. At the end of the day, like we mentioned earlier on, the compelling narratives can only be generated if you have the public behind you. So when you're prioritizing issues that you want to litigate on, you need to be very strategic, and being strategic means that you're focusing on issues that directly affect the public. There it will be easy to convince court, but also to the state that most likely, or the individual organization or agency that is responsible will appreciate what you're trying to do. Advocacy among scientists, we need to enhance agency of advocacy among scientists. Many scientists, again, we use the word scientists here very cautiously to mean experts, don't have much agency when it comes to doing advocacy. Now, we need to interrogate, why don't they have this agency? Could it be the way advocacy is done here, going to radio, TV? We could do advocacy in many ways by providing evidence. So we need to explore ways through which we can enhance agency for advocacy on climate justice among scientists. Everybody has talked about stopping working in silos, which is really about partnerships. Partnerships in work, partnerships in training. And finally, dissemination of scientific output. Yeah, there's a lot out there, but again, we can't access it. So who should be responsible for making sure that this research that we have by our scientists, the rigor challenges notwithstanding, where is it? Who is curating it for our interest? I really sympathize with Greenwatch when they are fishing around for data. They have to drive to Makerere, they have to call people, they have to go to all these libraries. Is it possible to have a one-stop center where you can get some of this information? So this is something that all of us can consider to prioritize, making this data or evidence available. And one of the principles we have in environmental governance is transparency. When it comes to a state agency can have data, but they give it to you in a format that you cannot understand. So data should be available, but also easy to understand. So it means there has to be someone to process it. Okay? So with those many observations, I know the secretary has also picked a lot. I want to end this fireside session where I was a panelist and I didn't get any question. I think people feared to raise questions to the moderator. I want to thank my panelists, the members of the fireside session, Zake, Amos, and also I want to thank the Secretariat that took a gamble to ask me to be a moderator. With those many remarks, I invite Samantha and her team to give us our way forward and when we shall meet next. Thank you very much for your kind attention.
Yes, thank you, Waikitini, sir. Perhaps people didn't fear to ask the question, but because you are Ektinisa, a big person, you have to abide by that. So we are coming to the closure of our session. However, we have these cards, these small cards. Those small cards. Colleagues, did you see those small cards? You are saying welcome. So yes, so if in just 3 minutes we can just scan that code, below on that page there is a evaluation form, feedback form. We would want to get your candid feedback in just 3 minutes, really. Then after that, we will have Samantha come close. Then we have a photo moment, as we shall be guided by the photograph personnel for maybe 2 minutes, 1.5. Then we shall also be guided by admin on some admin communication. And then we organized an evening tea session for us. Please do not leave that session for the hosts of today. So if we can just scan it and just give the feedback, then we move forward. If you have any challenge with, these things, someone was asking that if I had a feature phone. Oh, perfectly. So, these Gen Zs, they're all over here. They can support in that. I've also been informed, because we are looking at a free and fair process, the feedback form is anonymous. So be as honest as you can be. We value feedback. Is that a little bit? Do you want support? You want a rose, and that you assess and see that it has an effect on the carbon footprint. Yeah. It was Dr. Isaiah who informed us of how far we've come in science and it being a tool to better communities. From phones on the walls, now we can scan QR codes. Perfect. I've also been informed in there is another form. For those who didn't fill it on the same page, consent photo form. It's a very short one, not as long as this one. For issues of publication, we also value privacy. Yes, so that one won't even take 30 seconds, a consent form. Yes, as we do that, I invite Samantha to give us the closing remarks for today.
I appreciate you for staying till the end of our training. Appreciate you for physically being present. It was really very intentional for us to have a physical meeting so that we can be able to. There's just something about meeting physically. I think we've been so accustomed to online meetings. It's convenient. You can do it while you're doing other things. You can multitask. But to have physical presence is something that we really appreciate. So thank you for staying that entire course. We would like to continue this engagement, and we are trying to figure out how best we can do this. I know that some of us are on over 500 WhatsApp groups. And sometimes the WhatsApp groups may not necessarily be effective. However, it is an avenue for us to keep in touch. So I would kindly ask if that's one of the ways that we can be able to keep in touch. But we'll also develop an email listserv where we will get all your email addresses and communicate that way, like we have for this particular training. The Secretariat is going to extract a report, and some of the follow-up proposals, suggestions will be shared with us all so that we can prioritize in terms of what should we do next, how should we go about this. I know David was talking about monthly webinars and meetings and things like that, but we can agree on what works best, because sometimes in the spaces that we all work and operate and do different and carry different responsibilities, I also know that there are several monthly meetings and the like that go on. So we also don't want to create something that will eventually lose momentum or something like that. So maybe monthly might not be the best. That's just my opinion, my experience as well. But maybe if we could structure something that we can do probably quarterly to keep us, in touch with each other and to keep this thing that we've started alive. Even us, we do not know where it will go. We have an idea, but it may turn into something bigger, may turn into something impactful, because it's something that we're just beginning. There are also many opportunities that have opened their doors to us in terms of science, in terms of cohorts, trainings, being part of litigations that are happening in different jurisdictions. So also how we can be able to support that. So I think what I'm saying is that kindly leave behind your contacts. If you're representing someone else, you can leave to both the person who you're representing's contact and yours as well, because you're the one who's been fed today. I'm speaking pastoral language, fed, but you understand. They're the one who has received the information, so please also put your contacts. I hope that the phone number that you left with us is a phone number that can receive mobile money. Because all transport refunds and the like are going to be made through mobile money. So if the number has any issues, please let us know so that we can be able to handle that. I would like to appreciate the team from Greenwatch, which I did not introduce, but I'll take this opportunity to introduce them. We have Miss Judith Nansubuga. Judith is our staff advocate. She's also a Betha Challenge Fellow for 2026. We have Mr. Mpeo Alan, who's our staff advocate as well and project manager. We have Mr. Thomas Kaisuka, IT and Communications Media, together with Miss Arimpa Benedette. She's also with our communications. We have Miss Unity Nwandinda. She is our research assistant at our clinic. Oh, by the way, let me just talk a bit about our environmental law clinic. So Greenwatch has an environmental law clinic, and that's an opportunity for us to take on more cases with support from our partners. Usually it's litigation, as you will know, is an expensive venture. And that's why our partnership with Kakran Company Advocates is very important. Most of the time they do our litigation pro bono. But with the clinic, we can be able to take on more cases, have more staff, and also train with universities with clinical education, and have some of the students support the clinic in terms of research, in terms of working on real life cases, and also giving them the opportunity to experience what litigating, public interest litigation is, and hopefully win them over so that they do not go to the likes of, you know, on the other side, but also realize they can build a career on this other side. I was looking at the bankers upstairs, just their demeanor, dress code, it looked a certain way. But that aside, most of the time, that's really what's attractive to young people, and they think that's where, you know, you can build your life. But there is also a career path on this side of public interest, of civil society organizations, of academia, so just to be able to provide that platform for students. And I also love working with students. I love working with young people. I didn't know all these things of QR code and all these things, but as you can see, it's not my doing. But there's a way in which the young people keep us on our toes. And also it's an opportunity to raise the next generation of public interest lawyers, of scientists and the like, so that at a time T, when we are not around, there will be others to do the work. All right, with those few remarks, I would like to close this training. I see Alan approaching me. Okay, photo. Yes, we didn't take a photo, so we'll just do it. We'll be guided by the photographers. And DM Events is the one that has supported us with the screens and the live streaming and the like. Very reliable. All right. Thank you.